Good morning. Welcome to the October Planning Board meeting. You could see from the podium we're a little bit short right now. We have 4 members, and our chair is not available today. So this is Mark Milland as vice chair, and I'll be running the meeting today. We're going to skip around a little bit because there are going to be some continuances granted here because of the shortness of our board. So I don't know if we want to go just approval of the minutes first. And so approval of the minutes first.
I read them. I move it.
Okay. Do I have a second?
I'll second.
Okay.
Okay. I'm going to do a roll call. Mr. Jelpy?
Yes.
Ms. DiPietro?
Yes.
Mr. Milan?
Yes.
Ms. Bott?
Yes.
Motion passes 4-0.
Okay. We're going to do the one discussion item first here, and that's number 2 on the agenda. And this is a discussion regarding the process and challenges of procuring off-duty police officers at entertainment establishments.
So I think we should have Chief Acosta on the...
I think they want to do this first, Mickey, because they have the chief of police right now available for this one. Sorry about that.
PJ, I don't know if Chief Acosta is on Zoom. Chief Acosta, are you available? I don't see his name, so maybe we can...
And Mr. Vice Chairman, if you'd like, I can, while we're waiting for the Assistant Chief, read our notice regarding lobbyist registration. Good morning, everyone. If you're appearing on behalf of a business, a corporation, or another person, you need to register as a lobbyist with the clerk's office. If you haven't registered yet, you should register before you speak to the board. You don't have to register as a lobbyist if you're speaking only on behalf of yourself and not any other party, or if you're testifying as an expert witness providing only scientific, technical, or other specialized information or testimony in this public meeting, or if you're appearing as a representative of a neighborhood association without any compensation or reimbursement for your appearance, to express support of or opposition to any item. Expert witnesses and representatives of neighborhood associations shall, prior to appearing, disclose in writing to the city clerk their name, address, and the principal on whose behalf they're communicating. If you're an architect, attorney, or employee representing an applicant or an objector, you must register as a lobbyist. These rules apply whether you're appearing in favor of or against an item, or encouraging or arguing against its passage, defeat, modification, or continuance.
Okay, so I guess we're going to, is the chief available, or should we move on and wait till he's available?
I guess we should go ahead and move on and wait till he's available. I don't see him on, so maybe something came up.
Okay. So I think we're going to go to item 6 right now because there's people here for the progress report on 1766 Bay Road. I don't think there's anything that we need to take any action on this, so it's a progress report.
Mm-hmm. So this progress report was for Dia Indian Kitchen, which is located at 1766 Bay Road. There was a... Oh, he's on? Chief Acosta's on? Chief Jones is on. Okay.
I apologize.
I'm sorry.
Sorry. It's just they asked for... He would make himself available, so...
Okay, so we have Chief Jones on. So this is a discussion item that the Planning Board requested regarding off-duty police officers and their availability at entertainment establishments in the entertainment district. There's really no, it's the board discussion, so if the board has any questions that they'd like to ask of the police department, this is your opportunity to do so.
If I remember, the issue was that people could put a request into the police department and then there could be no off-duty police available and they only had one point of contact. And I think we wanted to find out if there's always somebody available or what's the backup if there's not someone in Miami Beach who is available, and then whose responsibility is it to reach out to other police departments to find someone available.
I'm wondering
good
if
morning.
if there's anybody in the audience who falls into this category of needing these sorts of resources, who might be able to provide some of their experiences as we go through the discussion. It doesn't seem that that's the case, but maybe somebody who's watching and can speak up online to expand the discussion once we hear the presentation, that would be great.
Well, is there a presentation right now?
I think I heard Deputy Chief Jones. Are you? Yeah, he's on the line.
I am on. And good morning. I apologize if Chief Clemens cannot be here today. I'm the last one to fill in for both him and Chief Acosta. So, as I understand the question is, if someone requests, a business requests off-duty police officers, is there always an officer available to fill that request? So the short answer to that is no. It's not always a police officer available to fill a request. The way we assign off-duty jobs, it's all voluntary by the police officers. And it's typically done on the police officer's time off from work, days off from work. And if there's a job that comes out and that person's not available, if the officer's not available, then they won't fill it. We do have a process though where we reach out to other police agencies throughout the county that have what they call memorandums of understanding, or MOUs, with Miami Beach Police Department, and those police officers from other agencies typically fill those roles for us when we can't. I hope that answers your question.
And if someone in their CUP has this requirement, they're given one point of contact, or they're told to reach out to other police departments in the county, or you guys take that responsibility to do the reach out for them?
So we typically take that responsibility for them. And there are two types of jobs that go through the police department in off-duty capacity: full-time or long-term permanent off-duty jobs, and part-time or single off-duty jobs. When there's a permanent off-duty job, a police coordinator is assigned to that job, and so that police coordinator becomes a single point of contact between the person requesting off-duty police officers and the police department. If it's a one-time or temporary job, it goes to the off-duty office, and that off-duty officers, which is staffed by civilians in the police department, they're responsible for filling that job. If they can't fill that position with a Miami Beach police officer, then the off-duty office is responsible for reaching out to other agencies to fill that position. Likewise, in the case of permanent off-duty jobs, the job coordinator is responsible for filling those jobs with outside agency officers from other jurisdictions.
Thank you.
Is that coordinator also in the off-duty office, or is that a whole different department or section or whatever?
So we're talking two different things. I apologize if I confused you. So inside the off-duty office, we have civilian employees that are staffed permanently, full-time, and their whole sole job responsibility is to coordinate police jobs with folks requesting off-duty police officers. When there's a permanent or long-term job, or a large job per se, an off-duty coordinator, typically a police officer or sergeant or supervisor, is assigned to fill the requirements of that job. He or she, if they can't do it internally with Miami Beach police officers, he or she then have to reach out to other police officers from other jurisdictions in order to fill those positions.
So would an establishment that has as part of its CUP the requirement of having an off-duty police officer there for, let's say, whatever it is, Thursday, Friday, Saturday nights, would that be considered a long-term job because we know that it needs to be every Thursday, Friday, Saturday night?
Yes, so that would be considered a permanent job, and that would be assigned. That job would be assigned a Miami Beach police officer coordinator. He or she is then responsible for filling those positions at that location.
So then, when somebody says, "Oh, I've had trouble getting," an operator in the MXC says, "I've been having trouble fulfilling this obligation of the CUP because I can't get anyone to show up. They're busy, they're occupied, there's no other backup, so we haven't fulfilled that obligation." What is the appropriate response, and what is the appropriate resolution to that issue? Because that cannot be acceptable.
Yeah, so the onus of place on the coordinator to fill that position. There are some cases where officers, again, because it's a voluntary job, won't want to work a particular location, and it's difficult to fill it from outside agencies. Some outside agencies, although we have MOUs, a memorandum of understanding with a lot of agencies, they don't want their police officers working like gloves. In some cases, when staffing permits, and based on any of the issues that may be surrounding the location that wants an off-duty police officer, in some cases, we assign on-duty personnel to those locations.
I'm sorry, what kind of personnel?
On-duty police
On duty,
officers
okay, sorry.
to those locations. And there's a whole process in place for recouping the cost of having those officers there.
And are those costs recouped from the business in question or from somewhere else in the city budget?
Yes.
Okay.
For the business, for all intents and purposes, for the business who are requesting off-duty police officers, for all intents and purposes, they're getting police officers requested. Whether it's an on-duty person or the off-duty person they requested, they're getting a police officer requested. So there's a cost, obviously, associated with that.
So there should be no instance when a business operator is not able to satisfy the obligation, the requirement of the CUP with having an off-duty police officer. Because either you'll find it from within your crew who is somebody who's not working that night, or an agency with an MOU, or if worse comes to worse, you'll find a way to find an on-duty officer to fulfill that obligation. Is that a correct understanding?
Not in all cases, but ideally that would be true, but not in all cases. Again, signing those jobs and filling those jobs is voluntary. When staffing permits in the organization, when staffing permits, and that's not always, when staffing permits, there are occasions when the need, because there's a need to have an off-duty officer at a particular location, we will use on-duty resources to do that. But that's not in all cases.
So I guess what I'm trying to get to is when a business operator says, gee, I tried to get somebody, but I just can't.
That may be true in some cases.
But if that's a recurring situation or a recurring claim on the part of the business owner or operator, there's a problem there. So how do we close that gap? How do we fix that?
Well, I mean, from the police department perspective, I know the chief of police is doing some things to try and incentivize police officers to work, particularly nightclubs, more frequently. Because again, it's a voluntary position, right? People don't have to work it. They can be ordered to work it.
Is there a record of every request that's been made for off-duty police officers? So that if somebody says, I tried a couple of times and it just never worked out, we could cross-reference that and make sure that the effort was at least made on behalf of that the business operator did in fact make that effort?
There's a record of every permanent job through a coordinator of whether or not the position was filled at any given time.
But not necessarily of the non-permanent jobs.
Not necessarily, because that could amount to just a simple phone call to the off-duty office requesting a police officer for a particular day and time. The off-duty officer basically saying to the person making the request, "I'm sorry, we can't fill that request today."
Helio, can I ask something? When we put these requirements in, do we say a police officer, or do we say a City of Miami Beach police officer? Because I guess the question is do they have to be City of Miami Beach officers if there are potentially other officers from other municipalities or county that could be available?
I don't believe we have that requirement in any of our CUPs. We have requirements that they have security available, but we don't specify that it has to be a police officer. And I think that was something that the board was kind of wanting to know. Could it be a police officer? So we don't have that today.
And Mark, I think they do call out to other municipalities, the coordinator. But I think for this sake, we see that if businesses have this requirement, they can be doing their part of making the request to the coordinator, but it could still be falling short because it's a voluntary job and or the Miami Beach Police might not have the resources. Tanya, I don't know if we're going to solve that today.
No, I don't. Yeah. I wish things were easy enough to solve in one conversation. Rogelio, they can have an off-duty police officer, or they can have a security person, a licensed security person to fill the CUP obligation.
The way with the current language that's in our CUPs that we have along Ocean Drive, that would be the case.
So if the operator claims to have called the police department that handles this, and is told, sorry, we don't have any available, and none of our partner agencies outside within the county have anybody available to do it, it would then, it seems, be incumbent on the business operator to then hire somebody from an appropriate security agency. And so for a business operator to say, I called the police office in charge of handling this, and they said no one was available, and that's the end of it, is inadequate. Is that right?
I'm sorry, the last part, can you?
If a business operator who has this as a condition of their CUP calls the police department and speaks to the person in the office that handles this, and they're told, we don't have anybody for you, and the agencies with which we have MOUs don't have anybody for you, that's not the end of the conversation. What then has to happen is that the business operator needs to go hire somebody, a licensed security agent or whatever, and I don't know what the requirements for that would be, but somebody to fulfill that role to provide security at the venue. Is that correct?
So today, just the ones that I've seen, they have to have security staff. They don't have to have anybody hire a specific company or anything. They have to have security staff.
And we also don't put the level of security, because there's different levels that you could hire in the security company. There's
right.
Guys,
So
and there's guys who carry weapons.
Yeah, I guess that's the question that we're asking, to see if in the future we can modify our CUPs to incorporate these types of standards.
I kind of like where you're going with this, Tanya. I mean, I think that to a certain extent we say you make sort of a commercially reasonable effort to use a police officer either from Miami Beach or any related entities, and if you can't, then you have to get a security guard. But then do we want to at some point say, like, what level? I don't know enough about what the levels of security guards there are, but I'm pretty sure that there's like a standard for that.
Mm-hmm. Yeah, and I would think that while they might have security on staff, that to me would be probably a bouncer kind of a
Correct.
function.
Yeah, that with the way our language is worded today, a bouncer would.
Okay, but then if you're saying that somebody needs to have an off-duty police officer, and then they are saying, well, we have a bouncer that fulfills our obligation, that's not fulfilling. That might be technically fulfilling the obligation, but that is clearly not fulfilling the role as it's intended.
Well, we don't have any requirements today for them to have off-duty police officer. This is looking prospectively to incorporating that requirement into CUPs.
There was somebody who came before us a few months ago, I forget who it was, who triggered this whole discussion.
Mm-hmm.
I think it was Voodoo Lounge.
Yeah.
And I think they actually do have an off-duty police requirement, because they did say they have private security, but it kind of didn't seem to be enough to quell what was going on there.
Right, and that they had called and were told there was nobody available. So that's what I'm not saying that this has to be for everybody, but for those who have that requirement or who might in the future have that requirement conditional to their operating, I think we need to tighten this up a little bit and provide levels of, if A is not available, then go to B. If B is not available, then go to C. And C includes, from 1 to 5 on these points, it has to include all of this, whatever that would be. I don't know a thing about private security firms or what would be permissible and safe in the city of Miami. But if we're requesting them to have an off-duty police officer, presumably that person is armed, I'm guessing. I could be wrong, so please correct me if I am. But whatever is the expectation of the off-duty police officer to be providing in terms of security and equipment and sort of backup resources should be the same thing, I think, that we would require that business operator to find in the private sector, with a duly registered and background checked organization that the city, feels comfortable, so that we don't have wild mayhem caused by an unintended consequence.
Yeah.
That's my thought.
Yeah, I think we could certainly craft it that way, and I think if we're going to put a requirement that there's got to be off-duty police officers and they're not available, we have to provide an alternative so that someone's not breaching their CUP when we issue it.
Yeah.
So I'm
And
looking at.
and by the, I'm sorry, I mean, the reality is if the police aren't available, there's definitely going to be a security company that's going to be available to take the job. So there shouldn't be an excuse that they couldn't hire the police, and therefore there's nothing there, and so they just can't because we have to provide the alternative for them. And I think I'd like to ask staff to see if there is some sort of standard there for the level of security that you can hire, or is it a company by company thing what the level is, or is there sort of some sort of standard in the industry for that? Because if we're talking about an off-duty police officer, then the person at the security company's got to be sort of the ace, can't be the trainee.
Agreed. And I would suggest that it needs to be whatever we end up crafting to sort of fix this gap, this unintended gap, should be applied retroactively to anybody who is currently operating that has this requirement as their CUP, if that's something we are permitted to do.
That's challenging because the time for the board to impose conditions on conditional uses is when they come before you for a public hearing. So, staff may have some wiggle room based on the individual conditions and individual orders, but we can't impose new requirements.
Nick, has there been any instances where we had that requirement in the CUP, and there was a violation of the CUP based upon that specific requirement?
So right now, I just opened up, for example, the Voodoo CUP, and it just says security staff shall monitor circulation occupancy levels. Security staff shall take measures to strictly enforce patronage restrictions. So it just refers to security staff. It doesn't specify.
Right.
Is
So we're not.
Security guard?
So theoretically, going forward,
Yes.
we're going to have to be a little bit more specific on that. So I
Right.
think, but if we're going to be specific on it, we can't give suicide missions either. We have to provide alternatives so that they don't violate the CUPs. But I do think that security staff is pretty broad.
A bouncer is security staff.
That's
It
way
could be just
vague.
some guy, just
So if the Voodoo Lounge has as part of their CUP that they need security staff, they determine that to be an off-duty police officer, and when that officer was not available at that date, they figured they were fine. I mean, I'm trying to understand that because of the language in their CUP, and I don't mean to pick on the Voodoo Lounge in this instance, but it was the most recent that we can recall, so their so-called security staff, whatever that might be, the bouncer on duty that night, filled the role of an off-duty police officer.
So I think the issue with the off-duty police officer came about during the restrictions of the pandemic, the COVID restrictions, that in order to be allowed to continue to operate, they had to agree to certain conditions, and part of that process, part of that agreement included having an off-duty police officer, but that was not part of the CUP. That was a separate
It was
agreement.
a conditional use permit.
It was
That's a joke.
Sure. It's
Okay,
not
so-
technically not a conditional use permit. It was a part of the emergency measures that were adopted by the city. So that's when they had the issue with the off-duty police officer. As far as the conditional use permit that they have approved goes, it just calls for security staff.
Okay.
So the time to impose new measures would be as we get new applications for conditional use permits, or if they have violations and the board requests a revocation modification hearing. At that point, you can impose new conditions, and then perhaps that would be a good time to impose these new requirements.
So how do we then articulate or define and set forth what a for-profit security officer, what that would be? Are there a list of 10 companies that the city accepts or uses? Does that person have to have a certain amount of training, hours on the job? What kinds of equipment is that person responsible to have access to? What kind of background check? What kind of resources can be called upon if needed? That kind of stuff. I mean, that is way beyond anything I have any knowledge of.
Or myself. So what I would request is that you direct us to do this, to do some research, and we'll come back to you next month with some suggestions for
I think we should understand.
language.
We can't start putting these into CUPs. I like where we're going with it.
Yeah.
Yeah, I think we need more information. So perhaps you and your department, in conjunction with the police department, could put together, sort of an outline of what potential best practices would look like and guidelines and why. And, I can't imagine we're the only entertainment district in the entire country that has this issue. So if there are any sort of lessons to be learned from others that have similar issues, then that would be useful as well. Please and thank you.
Nick, do we have to open this up to the public, or is this?
We do not.
Okay. Does anyone else have anything further on this one, or? Nope. Okay. Then with that,
But do we want to open it to the public
sorry.
just in case there's
well,
somebody?
I guess is there anyone here from the public who wants to speak on this discussion item?
We do have one hand raised online. If you want, andresacion.miami.
Hi, guys. Somebody from the board, Andres Acion, 1000 South Point Drive. Somebody from the board mentioned if there is a way of checking people that have submitted requests and have not been filled. And I think that it would seem obvious that if somebody was going to have a private event at their house and needed an off-duty officer or a restaurant on Ocean Drive or anywhere else, that there should be an online place where somebody makes that formal request, and then they could be selected by one of the police departments to take the job or not take the job, and then you would see that the job was not taken in that event, but that it was open for Miami Beach. Obviously, you have first right of refusal, and then it would go to Metro, and then it would go to any other Doral, Miami, any of the other municipalities that would like to take the opportunities. But that we don't have something like that, it seems kind of silly. So I would suggest that the board should request that be done if it's not done already. And if it is done, then you would have the answer. If it's not done, then it should be done. Streamline the process. That's all.
That's actually an interesting idea, because that would then also provide a record of even the sort of casual phone call that Chief Jones mentioned, where somebody calls and is told, sorry, we don't have anybody available, and that's the end of that conversation. There's no tracking.
There's no record of that, right?
There's no record. So I think that's a great addition to see if we can make it work.
But is that possible? Is that giving, like, who's that, the administration that fall upon? Does it fall upon the police? I mean,
Maybe
they just may not want to do that. And
well, maybe it's just part of the overall conversation that part of the direction given is, in addition to, let's see if there's a way to do an online portal so that at the very least, to start off with, there's a record that can be viewed, and ideally it can be automatically disseminated to the other municipalities that participate. It might make life a lot easier. It might be much more efficient, and then that person who's managing that flow of requests could be freed up to do other things that arguably would be more fun and productive. So do we need to make a motion for that, or no? That's just directing you guys?
I mean, I have good direction on the type of research that we need to do.
Okay.
So I think we should put this on the agenda for the next meeting too, just to continue on to see what we've learned from that. And then,
Next month.
I'm sorry?
Next month, not next week.
Oh,
Right?
excuse me. Next month. Sorry.
Because a week is probably not realistic.
Yeah. For next month's, just to continue the discussion, just when we learn more information, because I'm certainly thinks it's a good idea to have a little bit more of a process here than just Wild West. Just a hope and a prayer, right?
Yes, I agree.
Okay. So I'll put continued to next month by acclamation.
Yeah, I got that. Yeah, okay. With that, there's one item that Commissioner Minor asked with a time certain. That is items 15 and 16 in the agenda. I'd like to go to those, and that's PB 21-0463 and PB 21-04. Oh, they're both 0463. It's the landscape neighborhood overlays.
Okay, so this file number PB21-0463. You have before you two ordinances. So there's actually two items listed on the agenda. They're companion items. They're very similar items. So they're going to be heard together. Same file number. The City Commission referred two versions of this ordinance to the Planning Board with a request that the Planning Board select their preferred alternative and transmit that to the City Commission. So by way of background, the city has a landscape ordinance which is in Chapter 126 of the City Code, which sets out requirements for street trees. Currently, street trees are required on all roadways with a spacing of 20 feet on center. There's a minimum tree height of 12 to 14 feet. And so the intent of this is to increase the canopy of the city, which is a goal of the city, providing shade, reducing urban heat island effect, reducing carbon dioxide emissions, absorbing carbon dioxide. So there's a multitude of benefits to this. However, there are certain neighborhoods where there is an existing characteristics that the neighborhoods may wish to keep. In this case, this came about as a result of the Lagorce neighborhood. There were some new homes being constructed. Those new homes would have to comply with the new landscape ordinance, which requires shade trees as street trees, as opposed to what their existing characteristics consist of, which are royal palms. So the proposed ordinance before you allows the city to create overlays which allow specific neighborhoods to maintain those specific characteristics that make them unique. So you have two options before you that allow this to happen. The first option is called the overlay version. And what this does is, if you're going to add new neighborhoods to create specific regulations for that neighborhood so they can have their own special landscape requirements, changes to that would take place through the process of an ordinance. An ordinance is required to come before the Planning Board for discussion and in public hearing, and then it's required to go to the City Commission for two readings, first and second reading. The second option that's before you is called the resolution version, and what that would do is it would allow for neighborhoods to be added or removed to the list with specific requirements by process of resolution of the City Commission. That only requires one hearing before the City Commission. So it's a much quicker process to add neighborhoods, but it's also a quicker process to remove neighborhoods. So those are the two differences between the two ordinances. Staff recommends the overlay version. We think that the process of going to the Planning Board is beneficial. It allows for any kinks to be worked out, making sure that what we're actually regulating is the correct thing, and provide some additional opportunities for public input. So with that, staff recommends that you discuss the two ordinances. And we recommend that you transmit the overlay version to the City Commission with a favorable recommendation.
Okay, I just want to ask something, Rogelio. So, just so I understand, the overlay version is a little more targeted right now. It's more targeted to the neighborhood, whereas the resolution one is more broad-based. And so, let's say I live on Allison Island. We wanted to deal with, some sort of changes to the landscape.
Mm-hmm.
We would be able to come under that one. We wouldn't be able to come under the overlay. We'd have to start the whole process again, correct? Versus the resolution version, because there's a lot of neighborhoods that may want to take advantage of this and say, if there's an expedited way to deal with this, perhaps we're better off with a resolution version versus an overlay, which is, really the overlay right now is only going to be for Lagorce right now, right?
So the way it's worded right now, it's only for Lagorce, but it creates a section of the code that would allow neighborhoods to be easily added to that. So it's not done in a way that
Okay, so how much easier is it, under that one than it is under the resolution version?
So under the ordinance version, it's the process of any other ordinance. We typically have 5 or 6 ordinances that come before this board every month. So it would be that same process that any other ordinance would have. The resolution version, what it does is it sets up the section of the code and the framework for future for these overlays to be added to the code. So actually, if you approve the resolution version, the City Commission would then actually have to approve the resolution implementing the LaGorce overlay.
Right, and I guess the next question is, and I'll let everyone go after me, is LaGorce is pretty organized, right? They have a homeowners association, and there's other, let's say where Asa lives, there's Normandy Island. There's probably not a real organized association.
We're organized.
I'm sorry?
We're organized.
Okay, well, so my island is not organized, okay? There's a homeowners, but it's really a loosey-goosey organization. So how would that happen for, because I understand with one organization, one voice, one association, one voice can do this. How would that happen for other ones? Would just a couple homeowners get together and say, we'd like to try to push this? And do they speak for everyone in the neighborhood?
So in both options, typically it would require a commission referring an item either to the planning board if it's the ordinance version, or putting a resolution on their commission agenda to adopt a new overlay.
So someone would have to get the commissioner's ear to do this, and then if the other neighbors don't like about it through this process, they may come and be against that.
So if it's the ordinance version, they would have 3 opportunities to be heard. If it's the resolution or option, it would just be that one hearing at the City Commission.
Right. Okay, I'll let other board members speak, and then we'll open up for the public. Recognize Alex?
Thank you, Mr. Chairman. Today I'm wearing
Vice Chair.
Well, you were sitting in the chairman's seat, but today I'm wearing two different cufflinks. I'm wearing our county cufflink because the seal of our county has a palm tree. I'm wearing our state cufflinks because the seal of our state has a palm tree. If I had a pin of the city, I'd be wearing that, which has the palm tree as well. So it's iconic to our city. We have streets named after palm trees and islands named after palm trees, and it's part of the identity of our city. So I want to thank Commissioner Minor for working to preserve the character of our landscape, which is part of the overall character of our city. Let me ask staff. With the ordinance version, there would be a public hearing. Is there a notice requirement to the community with this public hearing?
The public in this case, this type of an ordinance doesn't change the list of permitted, prohibited, or conditional uses. So it would be a herald advertisement, and then we do an email blast whenever there's ordinance amendments as well.
Okay, because I do appreciate the ability of there being a more streamlined process for something like this. I think it's always good when we streamline process in our community, especially for our residents. They want to preserve the character of their other neighborhoods, which is why I would be inclined to the resolution version of it. However, and perhaps this is more of a legal question, is there a way to incorporate with the resolution? For example, I've seen times that a resolution could have some sort of a public notice requirement when it's considered. Is there a way to incorporate that so that we still have a little bit of that, meats and potatoes from the ordinance style, but in a more efficient resolution version that doesn't require as many steps in the process?
I think so. I mean, the resolution version is still an ordinance, so you could recommend that version be amended to provide for specific notice in a public hearing.
Okay, got it. That's my question.
Thank you. Tanya?
I think I've got a couple of comments, but the very quick one is I think it falls under residents' right to know, right? So that people would have to be notified. And
not necessarily, no.
well, can we stipulate or can we amend it that it falls under residents' right to know? Because I can't think of anything more residents' right to know-ish than the fact that palm trees may be torn down on your street.
I would recommend more clearly, if the planning board wants to see a public hearing and notice requirement, that you include it.
So as part of residents' right to know or independent of?
No, I would just recommend that in this specific ordinance that there be a specific
Okay.
Yeah.
So I want to back up before we talk about the logistics of how to do this or not. I don't know if anybody from the department that's handling the urban forestry issues is available for this discussion, but I have the first glaring question to me is, as my colleague Alex alluded with his cufflinks and flag indicator, I understand that we want more canopy trees, shade trees, that it's good for resilience and it's good for the environment, and it's certainly more pleasant to walk through a neighborhood that has shade trees. However, I fail to see how removing palm trees, how accomplishing adding shade trees at the expense of existing palm trees is a good thing for our city. I mean, if you look at the GMCVB website, one of the first pictures you'll see when you look at Miami Beach is a beautiful shot of Art Deco buildings lit up at night or in their radiant, resplendent colors during the day. A clean beach, not cluttered with, rental chairs and kiosks for hire, and palm trees. I mean, how many productions have been shot here over the decades that show our palm trees as the setup, the immediate setup, so you know where you are. So yes, more shade trees by all means, definitely, please, absolutely, but not at the cost of tearing down palm trees. They're healthy, thriving trees. I can see if one or a stand of palm trees is failing or is diseased and they need to be eliminated to protect the others. That's just nature doing its thing. If you cut down a palm tree, you're actually releasing gases into the environment which are not good for us, and so you're actually setting us back further than if you just let them live their natural life. I just cannot fathom how this is a good idea. Again, more canopy, more shade trees, absolutely 100%, 150% yes, but not at the expense of taking down existing palm trees. So I would love to hear the relevant staff opinion on why it has to be an either or before we discuss how to make it happen.
Mark, if I could add something. I mean, is someone from Urban Forestry here to discuss?
I don't see anyone on. Let me see if I can get somebody.
Because Tanya, where are you? Let me just ask you, because I wasn't under the assumption that palm trees were going to be demolished as a result of this ordinance. It's the street tree requirement for new construction, meaning any existing palm tree is going to remain where it is. But to close out your permit, you're going to need to plant shade trees, canopy trees along the street. But that's not saying we need to demolish any palm trees that exist, correct?
The current plan, the current urban forestry plan is calling for the removal of palm trees throughout the city.
Right. But that isn't what this legislation isn't saying that. This is really so that the trees that are planted don't necessarily have to be shade trees, but rather can be palm trees.
Correct.
So it's sort of waiving whatever those kind of requirements are.
Okay, then is that an accurate?
Mm-hmm.
Okay,
yeah, this
then
relates to new
apologize.
construction. That's a separate issue altogether. This relates to what happens if you're building a new home. You have these minimum landscape requirements. In this specific area, instead of planting new shade trees, you are allowed to plant palm trees.
Okay, well, in that case, I apologize for my soapbox speech. My view on the matter remains the same, however, and I would like to, at some different point, have that conversation with urban forestry, because to me that seems, at cross purposes to what we're trying to accomplish. And then I will go to this matter at hand specifically, which is that while normally I think a visit to the planning board is better than not, so that more eyes can look at the issue and bring fresh perspective and sort of catch unintended consequences, I also think that it is complicated and expensive for people to make a visit to the planning board if the same goal can be accomplished with a thoughtful review and public comment and presentation to the commission.
I think what we're seeing here too is we don't want decisions made quickly, so I'm going to vote in favor of the ordinance version so that it goes through a little bit of a balance and a check.
Overlay.
And so the overlay being the ordinance, not the resolution. I think that most of our neighborhoods that have defining characteristics are quite organized and have homeowner associations. They're usually even special tax districts, so I don't think it's too difficult for them to organize. And then, unfortunately, those neighborhoods that aren't that organized would probably be left with the shade tree and canopies that the city is making a decision for. So I'm gonna vote that it goes through the planning board and the commissioners.
Or you have a motivated homeowner, right? That's
Or,
willing
yeah,
to
or they
talk
want to get
commissioners
organized.
to push an agenda for their neighborhood, and then it'll have public notice and.
Yeah, I'm going to
Just go ahead.
agree. I'm going to agree with Isa just to say that, there seems to be an aspect of fairness here, right? Like this is something that's being imposed citywide. And, I wouldn't want the appearance of unfairness to arise if there's a kind of quick review that doesn't go through the normal due process. I mean, we have a role here to advise, and I think we do a good job. And if something is going to be acceptable, we'll push it forward favorably. But I don't think we want to, take away maybe productive hurdles to get this done. I don't think we want anything done rashly. That seems to appear like it was done without fairness.
So you guys are for the resolution version?
No, we're
Overlay.
ordinance.
The
Well, they're
overlay.
both, correct me if I'm wrong, they're both ordinances, but one's
ordinances.
the resolution and one's,
The overlay.
Correct.
oh, okay, the overlay, yeah.
So
We do have a public hearing. We do have several people with their hand raised. I don't know
Yeah,
if you
well,
want to take that up before you continue the
let's-
discussion.
Let's take the public, and then we'll
Could I
bring it
just
back.
ask legal just one question?
Sure.
I just need some clarification on the language. Will the language, like for example, for Lagos, does it encourage the preservation and protection of any existing trees, royal palms or any other types of palms?
Which version?
Well, either version.
The only difference in the version is if it's just to the commissioners or to the planning board and the commissioners.
No, I
Right.
get that, but my question relates to the requirement for preservation. If there's any requirement to preserve any palm trees in either version of the two ordinances.
The city has a separate ordinance, Chapter 46, related to tree preservation. This deals purely with new construction and what happens with new construction.
Right.
So if there are palm trees on the site that exist, it'd be beneficial to the applicant to just leave those there instead of having to buy new palm trees, but it doesn't say that they couldn't replace existing royal palms with new royal palms.
And there is language, if you look at on page 216 of your agenda, which is page 2 of the overlay version, B, little Roman 2
Oh, yeah.
says, existing
Yeah.
royal palms and Canary Island day palms shall be preserved and protected during any proposed construction.
Yeah.
I believe there
Page
is similar
220.
language in the Reso version. If you turn to page 220, in the middle of the page, starting with the note, this is language that would not go into the code. This would go into the Reso, creating the Lagos exception. And if you look at 1B, you've got the same language there. Existing royal palms and Canary Island day palms shall be preserved and protected during
So
any
in both
proposed.
versions, whatever this board decides to adopt, we will be able to achieve the
That's right.
preservation.
Mhm.
Okay.
Yeah,
Again,
I
just
think
keep in mind
Lagos
the
gets what Lagos gets in either one. So the question is it an overlay, and is it easier for other neighborhoods to sort of replicate this?
Just keep in mind, in the resolution version, you are actually not approving the language specific to Lagos. You are just approving the framework that would allow the city commission to approve that language with Lagos, versus the ordinance version, you are approving the specifics of what would happen to Lagos.
I think it's also important to point out, you can still I have like 25 palm trees at my house, and then the tree on the side of the road is the shade tree they want me to have. So you can still have a whole palm tree shade canopy on your property if you so choose, and then we're really only talking about that shade tree or tree street lining component.
I just worry about the large areas of the city that are not incorporated, that's not what I mean to say, are not organized homeowner associations. You know, you have entire sections of blocks and blocks in North Beach that are low-density rental apartments. They're not condos, they're not high-rises, they're people who've lived here for decades, but they don't have the means to hire a lawyer and come before the planning board, and don't probably even know how well the process is designed to work and where to start. And so this, we're talking about fairness, and I totally understand, and I do agree with the point of more supervision on this sort of thing is better than less, generally speaking. But in this instance, it pretty much leaves all those people who don't know how the system works, may not have the means, may not be organized as a neighborhood, to deal with whatever is being foisted upon them. And I don't know how to work around that.
Well,
But they're just development regulations, Tanya. I mean, it's if somebody is building a new building in this neighborhood, and frankly, they should build shade trees. Palm trees, they're beautiful, but they contribute very little ecologically. And from a botanist perspective, they don't sequester carbon the way that other trees do. They don't provide shade. They don't retain the water that other trees do. So from an environmental perspective, they're basically valueless. From a tourist perspective, they have value, I understand, and they're beautiful. But there's no comparison between the two types of trees. So, I mean, I don't see it as something being thrust upon people unfairly. Again, unless I'm missing something, I don't think we're going to go demolish the trees in people's front yards. It's just that if they redevelop these properties, they're just going to have to plant native species of canopy trees, which would benefit the city.
palm trees are quite dangerous if you don't maintain them, and cutting coconuts out 3-4 times a year can get quite expensive. So, the shade trees are just better for people who live at these properties.
And again, I'm not anti-shade tree at all.
Should we open up the public hearing?
Yeah, let's open up to the public.
Okay, the first person with a hand raised is Neeson Kasdan.
Good morning,
Hi,
members
Neeson.
of the board. You able to hear me?
We hear you.
Neeson Kasdan, Ackerman LLP, representing Lagorce Island Homeowners Association. And pardon me if there's some noise in the background as I'm taking this from my house this morning, looking out actually at a small grove of palm trees in my yard. To give you a little bit of history on this, Lagorce Island has been characterized from the time that it was first created with majestic royal palms and medjool palms that line their streets with their large lawns. And this is the characteristic of the island. There are other neighborhoods as well in Miami Beach that are noted for this, for their groves of palm trees as well, such as Palm Island and Star Island, and there's the Palmview neighborhood as well. The city's urban forestry plan is a well-intentioned plan to provide more shade and canopy trees throughout the city. There are many neighborhoods in the city that lack trees on the public right-of-way in their entirety. But there are certain older neighborhoods in the city, like Lagorce Island, which are lush, which have large lawns and green areas, and are characterized by the palm trees that are on those islands. And so we went to Commissioner Minor. Commissioner Minor understood the importance of this and has put forth this legislation. I know there are other members of the Island Association who have worked closely as well with horticulturalists who will discuss some of the other aspects of this. So in sum, we are in favor of this moving forward. We are okay with either version, but as some board members have properly noted, it is a much easier process for the neighborhoods if it is done by resolution rather than the more lengthy process of ordinance where they might have to hire a lawyer like me to help guide them through the process. The one final note that I would make, and I think it's been amply noted by members of the board, the character of Miami Beach has been indelibly marked by palm trees from its inception. In fact, John Collins, the founder of the city, his first business here, and the Loomis brothers in Loomis Park was a coconut plantation. And many of those trees are still around today, almost 100 years later. And many of the trees on Lagos Island have been there for decades and decades. So they are sturdy. They've been able to withstand extreme environmental conditions and salt over many, many years. And they provide character and beauty to these locations. And that doesn't mean that on people's property or on other streets throughout the city that the guidance of the urban forestry plan will be followed. But this will allow neighborhoods that have a defining character to maintain that character, and therefore we ask for your support for this.
So, Neeson, this is Mark. You would be okay with the resolution version too? I mean, is that do you advocate for any specific one, or are you agnostic?
I think, candidly, we think the resolution version is better. It's simpler. The people who are affected are the people in that neighborhood. They would be the advocates for it to be adopted by resolution, and would only require one city commission vote. So I think on balance, the resolution mechanism is a more efficient, I would say, neighborhood-friendly version.
Thank you. Is there anyone else from the public?
Yes, we have Dennis Kanan.
Good morning. Can you hear me okay?
We do.
Oh, wonderful. Thank you. I am a board member of Lagos Island. I've lived on Lagos Island for 23 years, and I have lived in the city of Miami Beach since I was 3.5 years old, which is a long time ago, except for a period of exile in Coral Gables and when I was away at college. I appreciate that you're hearing us. I've worked closely with other members of the board, and we would suggest that the resolution manner is the more equitable manner, and I'd like to explain why. I realize that a lot of other neighborhoods are organized. I know Normandy-Isle is organized. Many neighborhoods are organized, but I want to explain that this process was not cheap. And by that I mean, we thought on the board we need to hire counsel, and we hired the best counsel that we believe is available in hiring Neeson Kazin, who is worth his weight in gold, but it wasn't cheap for the Homeowners Association. Additionally, we had a thought that he needed to show that Lagos Island is a historic place, and that the palm trees on Lagos Island are historic and part of the heritage of our community. We hired Dr. Paul George, a very well-known and respected historian, and he prepared a report on the history of Lagos Island. We also made public record requests to the city of Miami Beach that relate to such issues as what took place when the island was originally being planned by the fathers and not really mothers at that time, but the fathers, John Collins, Carl Fisher, and these folks at the time, when the city was being planned and Lagos Island was being planned. In other words, it is not easy to get this done. We've been fortunate that the facts and the law are in our favor. We've been fortunate that we have an excellent commission, and in particular Commissioner Minor, who heard our call. But my fear is that other neighborhoods, equally valuable in their history to the city, but with a less prosperous budget on their board or not having a board, will have to go through an extra gauntlet, which in a certain sense is not respectful of the democratic. Well, let me rephrase it. It's more difficult to get something that's good done. So we appreciate this, and we would suggest that the resolution process is a more equitable one that takes into consideration the human condition of different neighborhoods and their financial wherewithal. Thank you.
Thank you. Is there anyone else?
We have Joe Fleming.
Can you hear me?
We
Yes,
can
we can hear you. Thank you.
My name is Joe Fleming. I live at 6655 Sheffield Lane on Lagos Island. I've lived on Lagos Island for over 4 decades, and the royal palms that line our streetscapes have lived on Lagos Island since the 1940s. With rare exception, we have the royal palms, hundreds of them, that are still standing. And when this was originally proposed, we read about it because in the master plan, Forestry, which along with sustainability, who have changed their minds, were saying that the royal palms only lived 8 years. They wouldn't survive the storms, and they should be replaced as new homes came online. Lagos Island, like the city of Miami Beach, is sort of an empire in which the cement never sets. So we have houses being built all the time, and that would mean that the royal palms would be decimated. And in fact, the master plan stated that it showed royal palms being replaced by canopy trees. So I, along with others, were upset because it's not only iconic, historic, and beautiful, and a park for all residents of Miami Beach who come there by bikes, by cars, to walking, and enjoy it. But also, it's a wonderful area that is beautiful, and that raises the property values because by virtue of looking like you're in a park, you have added values for the homes there, and that's why many people come there to see it. I communicated with Charles Lee of Florida Audubon Society, who I knew about this, and he communicated with Forestry and the city and noted that royal palms were indigenous. They, as I also have observed, they not only live on the east side of the Everglades in the freshwater wetlands in the royal palm hammock. There's a royal palm hammock on the west coast of Florida in the saltwater area where they live. And they have lived on Lagos Island when there have been hurricanes, so that you have fresh water inundating the island and then salt water overlapping the island. We also spoke with Charles Birnbaum. I found him through an architectural landscape representative here in Miami, and he runs the Cultural Landscape Foundation. He worked for the Department of Interior and the National Park Service and designed the historic landscape regulations. He also runs a cultural landscape foundation and teaches at Harvard in the graduate school and is known for his expertise. And he said and communicated that the value of the royal palms was that they were not only iconic and beautiful, but they contributed to the landscape. And the appreciation of nature is part of protecting nature. The concept of the city originally was you need shade trees, canopy. So we got too many royal palms and palms. We're going to change the ratio. And as someone earlier said, we're not against the canopy, but the way to increase the canopy is to increase the canopy where it's appropriate and not take down the palms so that the percentage changes, because that's like a shell game. The way to increase shade trees is to grow more shade trees. And we're not against shade trees on our property, but in this iconic viewscape, we wanted to protect and prevent the problem. And the reality is the city originally was, through its staff, saying that a palm tree is like a blade of grass. It descends from the grass family. Now, when I checked with the people at Fairchild, they said that's true, but you know, you can't go out and pick a royal palm like you can pick up a piece of grass on your lawn. These things are iconic and they've evolved, just like humans have evolved. You don't want to say that originally we were fish and then we were monkeys and say, therefore, we we should be treated as fish and monkeys. We've evolved, and these things have evolved over long periods of time. So we're in favor, as our attorney Neeson Caston adequately noted, in terms of taking either. But as he brilliantly noted, we're in favor of a process that doesn't require people like Neeson, who's an attorney, people like myself. I'm also an attorney. We shouldn't have to be involved. So we favor the resolution because we're not an island. We have people coming to us, and we don't want to pretend that we're an island off the city of Miami Beach. We want to protect the whole city, and that's the way to do it. We don't have any concern about the planning board, except that it becomes a matter of having to go through legal representation that might be eliminated. And that's why we felt that Commissioner Minor was at first the only person in the city who would receive the information and reached out to talk to scientists. And he heard our voice, and we felt that that analysis that he made should be available for others. And relying on associations and saying that they should hire attorneys makes it a little bit too expensive. And in those areas, like you mentioned, where there may not be an association, there's still residents who appreciate the beauty. And if they come to a commissioner, the reality is this offers them an alternative. It's not an attempt to eliminate sustainability or any type of a canopy. So we hope you would consider that and our requests. And as Dennis Kainan said, this is very historical. These trees were planted around the 40s. They were part of development that was proposed by Carl Fisher, and his genius is imprinted on the landscapes. And we'd like to see that type of protection extended throughout the city.
Mr.
Thanks
Fleming,
for being
your time is up.
Okay, we have Wayne Roberts.
Yes, good morning. My concern with the whole process with these trees has been the information that is coming from the administration. Several months ago, the position of the administration was that there would be no loss of palm trees. In fact, there'd be an increase. And now, I don't know if it's the result of Mr. Minor's work or the attorney, but now, I think as of last week, I think it was somewhere where it was a third less number of trees, palm trees. So my biggest concern is when the administration speaks, that it's honest, that it's thoughtful, and that it's accurate. And, I don't know if there's a mission that they want to accomplish, and but we have to deal with truth and honesty and integrity, first and foremost, when we make statements out of government. So that is my big issue. I love palm trees, and it's not just for tourists, it's for residents as well, because we could live in Georgia with shade trees. But we live in South Florida, and palm trees are a part of the attraction for not only tourists, but residents. And I don't want to see, shade trees are important, and it's certainly important for walkways that are associated with, blaring sun, or maybe homes that are affected by blaring sun. But I don't think at the detriment of the palm trees. Thank you.
Thank you, Mr. Roberts.
We have nobody else with their hand raised online. I don't know if there's anybody in the audience that would like to speak.
Is there anyone here to speak on the subject? Okay, with that, I'm going to close the public and bring it to the board now.
Just a question on the procedure to the city attorney. Under the ordinance version, so if the ordinance is created, let's say at some point the neighborhood no longer wants this, would there then have to be a new process, a new ordinance to amend the LDRs and have a public hearing, go through planning board again and all that?
That's right. So for any amendment to the ordinance would have to come back before the planning board and would require 2 readings before the city commission.
And if then the residents and the neighborhoods no longer want this. Under the ordinance version, would that require 5 votes of the city commission?
Yes.
And under the resolution version, it would require 4 votes?
If under the Reso version,
Yeah.
it would require 4 votes.
Okay. And you mentioned earlier that there would be perhaps a way to incorporate perhaps a public notice requirement as part of the resolution one, which, because from my perspective, it is more efficient, but you also give the public more of a role, because the threshold of the city commission is lower. With the resolution version, you only need 4 votes of the city commission versus 5 votes of the city commission.
That's right. The resolution, they actually both provide for a public hearing. I think Ms. Bott's question earlier was, would we require additional notice? But they do both require
additional
public
notice
hearing.
is what I'm asking about. We could include that into
Yes.
the language. Okay. All right. Thank you.
Anyone have?
I have a
Nick?
few questions about the ordinance itself. So we are actually approving the ordinance amendment for Lagos Island today, right? And then we're approving how it is transmitted. Is that correct?
There are 2 options on the table. So
I understand that. It's 2
right.
options for moving it forward and how it's
Right.
reviewed. That sets a precedent for the future, how other neighborhoods are going to approach
That's
this, as Alex was saying. But we are also approving the language of this overlay, correct?
Yes.
Okay. So I have a few questions. So is this amendment now saying that, because I'm reading here that it says the palm trees will be considered to contribute toward the required street trees. So could you satisfy the requirements of the street tree requirement with only palm trees in this overlay?
That's
Zero
how I
canopy
understand it.
trees at all?
That's how I understand it. Rogelio, is that correct?
The street tree requirement, yes, with only palm trees. However, the landscape code does have other requirements for trees on your site. Those
so this is
would
just
still
within
need to
the-
be shade trees.
So this is just within the swale?
Correct.
Okay. But the tree requirements within your property would remain the same?
Correct.
Okay. Okay.
Yeah, so you still do need to plant shade trees if you're building a new home, just not on the swale.
Okay. And about the original urban forestry master plan, is it true? So were they really going to go demolish the existing palm trees and replace them with canopy trees, or they were just going to add canopy trees to the street trees?
The urban forestry master plan, you're talking about just city projects?
We heard a number of speakers say urban forestry is going to go around chopping down palm trees. Is that true in the master plan?
I don't believe that's true.
That wasn't my understanding of it either.
I can request somebody from them to jump on the call, but I don't believe that's the case.
Okay, I just wanted to be sure about that. I mean, and you know, just to respond to a number of the speakers, I think somebody said, going with the overlay version of this makes it more difficult to get something good done. I think we could debate whether it's good or not. I mean, this is a debatable issue. It's certainly good not to plant more palm trees in terms of sustainability. It may be good for aesthetics to plant palm trees, but that's not really what this is intended to do. Another speaker said, Lagos Island is special because buildings are constantly being torn down and rebuilt, which states that the kind of character of the island is constantly changing. It seems strange to only preserve trees and not the architecture itself. I mean, guys, as we redevelop the city, we need to consider new standards, make it smarter, and the city is going to evolve. And I just worry that we're relying on kind of nostalgia to consider this issue and not really thinking about the whole merits of the initial overlay itself, of the initial master plan.
Although I don't think it's ever really a layup here. I think we're talking a little bit more about process, right? So is it a easier process versus a more difficult process? But either way, there's still going to be a process with public notice and hearings, and I'm all for efficiency. And so, to the certain extent, if it's more efficient to go with the resolution, the second version, it's still going to be vetted. It's still going to be discussed. It's it's still going to be well thought out and discussed. It's a bit easier to go through and less expensive to go through the process.
Let me ask you a question, Mark, because my concern is that as we develop, increase our standards, raise roads, raise finished floor, elevations, some of those things to modernize the city, which, originally was a coconut plantation, are difficult pills to swallow. And I worry that something like this overlay has good intentions, even if it is difficult to swallow in some cases. I'm concerned then that we make it easier for, let's face it, LaGorce Island is a very expensive neighborhood. My concern is that the expensive neighborhoods are more easily able to just have the commission exempt them from some of these difficult standard upgrades. That's a concern that I have.
But, I don't think it's really we're stuck between the choice of palm trees or no palm trees, because I think that if people want, if a neighborhood wants other types of trees, I think they can get that too, because I don't think there's anything in here that says, that it has to be palm trees. I think, specific to LaGorce Island is palm trees, and I think it's a little bit of a red herring that we're only talking about palm trees, because I think if there's another neighborhood that has, oaks, or whatever they have there.
Well, that's what they want, yeah.
That's what they want. They can sort of create consistency in their neighborhood that way. And to be frank with you, I'm not sure if a lot of neighborhoods are going to be coming back to us because,
but Miami Beach,
of course, is very unique here.
Yeah, and if I'm not mistaken about this, Miami Beach ranks way, way, way at the bottom in terms of canopy street trees. There isn't shade in the right of way. You walk around, it's hard to get shade. We're way, way worse than the city of Miami that has more extensive canopies. And so, listen, is it going to affect me one way or another if LaGorce Island has more palm trees? I ride my bike there all the time. I think it's a beautiful place, and it is. I just worry that there's this new master plan, and then we're just going to start exempting it. To me, it seems like it has no teeth. And then I worry about what was the point of it to begin with.
If you have any questions about the urban forestry master plan, we have Elizabeth Wheaton in the audience.
Elizabeth.
Yeah, we do have a few questions. Thank you for coming. The 2020 Urban Forestry Master Plan, can you comment, what is the extent of it? Is the goal to replace existing trees with new canopy trees? Would we start demolishing the existing palm trees in the swales around the city and replacing them, or are we adding to them?
Sure. So the Urban Forestry Master Plan, the purpose of the Urban Forestry Master Plan is to provide a roadmap for sustainable urban forest. And why this is important is as we think of the future of climate change, increased heat, as well as walkability of our cities, tree canopy plays an important role. Also for the uptake of stormwater, providing habitat, so many benefits that trees provide. And so the Urban Forestry Master Plan sets the goal to increase our tree canopy. We also have our city code through Chapter 46, which requires mitigation when trees are removed. The city in 2015 took over this program from Miami-Dade County because we wanted to have more control over the trees and making sure that any mitigation that was completed went back into our city. So when private development removes trees and palms, they're required to plant back canopy trees based on the amount of trees or palms which were removed. The property, a single family home or condo, they can also plant palm trees, but that does not count as mitigation. And so as we go forward for public projects and as we're thinking about reforestation, we are looking to increase our canopy trees, but also provide palm trees as accents. But they're not the focal point and main species that we're wanting to plant because of the greater environmental benefits that canopy trees provide. We're not removing palm trees as part of any project unless it is required per the design. And that's something that we evaluate through the tree permitting process. So of course, during construction, you're going to have impacts, and that includes to both palms and trees. But through our tree preservation code, those impacts will be mitigated.
Great. And maybe could you say a little more, about the benefits of the canopy trees and where do we rank? I was just commenting. I don't remember where, but I believe we read that we rank very, very low in Miami Beach in terms of shade, canopy cover, in right of ways, things like that. Isn't that the intention of the master plan?
Yeah, so currently we have 22% canopy coverage citywide, and we're looking to increase that to 25%. And in order to do that, a big piece of it is increasing canopy on private property because there's only so much public land that we have. But through our general obligation bond, we did receive $5 million for over the next 5 years to continue to plant canopy trees and add canopy trees to the right-of-way and to our park spaces. Trees are so important because you can't have a large, healthy tree with the greatest environmental benefits overnight. It takes time. So we're planting trees today that are going to be here for 20, 30, 40, 50 plus years. So the Urban Forestry Master Plan also provides specifications on how these trees should be planted. For example, the use of silvacells where we have sidewalks, which allows for the root system to grow underneath of the sidewalk, so we have larger canopy trees in our commercial areas, is so important. As we're thinking about species, looking at salt-tolerant species, which will survive as we have a rising groundwater table, which we know is brackish. So those are the types of recommendations that are put forth by the Urban Forestry Master Plan. And as we're thinking today for the future, tree canopy is so important because what we put in today is really what trees that we're planning for 10, 20 plus years.
Did you all consider in the master plan the potential that the whole landscape of the city is going to transform as a result of this, and that the city is going to look quite different maybe 75 years in the future? Do you still expect palm trees to be here?
Absolutely. And, a great example is we looked at projects over the last 3 years to understand what impacts have been to palms. So of projects which have received a tree permit, we've actually increased the number of palm trees as a result of those projects, but we've also increased the number of canopy trees because what often happens is when we have a new project, either a city project or a private project, they're required to bring in canopy trees, but then they also want to bring in palms to have that lush look. However, it's not a code requirement, rather it's something that the designers decide to build in. And, you look around the city and there's palms everywhere, which, we all love palms. They have that tropical vibe. And so we're not looking to replace them. Rather, we want to use palms in the appropriate locations where they become that focal point or where we don't have enough space, and then utilizing the larger areas for canopy trees where we can. So it's creating that balance. And yes, I do hope in the future we have a different landscape, one that, still in 20, 30 years, we want to walk around Lincoln Road. We want to walk, to dinner and, not be under the scorching heat. And, as a resident myself, I plan my walking based on where there's shade canopy because, you want to be in that shade. And I know I'm not the only one who finds respite under a tree in the summer heat.
Or there's buildings.
What?
There's buildings.
There's buildings too, yes.
Yeah, I think Normandy Shores neighborhood, we do a good job about having a canopy. They even planted like hundreds of more trees, but you'll see everyone from the surrounding areas flocks to the neighborhood because we have a tree canopy and everyone's biking and walking and riding. And I would say 4 out of 5 of the people in the neighborhood don't even live there. They're just there for our shade.
Mr. Chairman? So just a question, because when I'm reading the language of the 2 pieces of legislation before us, I'm seeing that it's the creation of a landscape neighborhood overlay, but as part of that overlay, it will identify species of particular plant material, trees, palms, and or significant landscape features. And my question is this, is it just limited to identify what's currently there, or could it also be a vision of what the neighborhood may want to kind of like address what Board Member Gelpi was saying? And I don't know if that's a procedural question for the attorneys or for staff, but if I could get some guidance on that.
So you're asking about the criteria for the minimum standards?
Right. So when we're saying under minimum standards, we're creating a neighborhood overlay. We're saying that the species of the particular plant material, trees, palms, and/or significant landscape features shall be identified within the overlay. Are we identifying only what is existing there at the time that the overlay is created, or is it also the opportunity for the neighborhood to come together and say, this is the vision that we want to have for our neighborhood?
I think they can decide, Alex.
Yeah.
Yeah.
It seems to me that,
I think
if a certain neighborhood wants certain types of trees, like what we're talking about with ASO
Want a
saying.
whole neighborhood of mango trees.
Yeah.
Yes, that'd be wonderful. I love that neighborhood. And Mr. Chairman, and to your point about efficiency, that's where I really see the benefit of the resolution version. Because with the resolution version, as we adapt over time, and especially as we learn more with sea level rise and climate change, we want to be able to be adaptable and quickly change to the type of foliage and trees that not only help reduce heat in our city, but absorb more water, etc. Which is why I also feel that the resolution version creates more of a streamlined, efficient process to make those amendments as may be necessary over time.
But I think the city has identified the best tree to use that maybe is affordable and can take brackish water and provide shade and habitat for us. So I think maybe having this dual layer of eyes on it and discussions through the planning board is best, because maybe a neighborhood could raise enough money to say we're going to do a whole mango tree neighborhood, but maybe by having more of a process behind it, we could figure out why this tree that we've already chosen may be best to achieve long-term goals.
Urban forestry has a tree tabulation table. So if you remove like a significant tree, you have to replace it with a certain number of gumbo limbos versus a certain number of I don't know, buttonwood, whatever it is. So yeah, the species exist. I think either of these options should be sufficient. The only thing is, I know the commission meetings are packed, and this gives us an opportunity to sort of, lay down a record for them to refer to as they consider it. Again, I think either option would be fine, but I think this, just allows more public input. One question about the Lagos Island overlay: are we, because the landscape requirements are street plantings with an average spacing of 20 feet on center, are we doing like a one-to-one replacement of, a canopy tree with a single palm tree, or are we increasing the density of palm trees if we're allowing those?
My understanding is that it's keeping the existing conditions the same, and the reason that this has come to be is that what has happened on Lagos Island is that you have private properties have redeveloped and have been required to plant street trees, which they don't want to see street trees in between the palm trees. So they're looking for a solution, and then this overlay would allow for only palm trees to be planted in the right-of-way, which is contrary to what the rest of the code says. So it would provide this exemption.
But the spacing would remain the same?
Yes.
The current code is for 20-foot spacing of canopy trees. That seems quite close, actually, isn't it?
I'm sorry, I don't have the code right in front of me.
I know tree canopies can be, 75 feet in some cases.
That is the case for street trees throughout the city. But this overlay allows the existing conditions. So if the palm trees in a specific area are spaced at 20 feet, that's what remains. If it's more, if it's less, that's what remains. It calls for keeping the existing character of what's there.
Which is 20 feet, or sorry, what? Yeah, 20 feet.
It depends on the specific site. So we would get a survey as part of the site.
Okay.
And so what's there, that's how it would remain. So if it is 20, that's what it would be. If it's larger, that's what it would be.
Okay.
Mr. Chair.
Go ahead, Tanya.
I have a couple of questions. Elizabeth, it's nice to see you. It's been quite a few years, although emails have gone back and forth. Nice to see you, and thank you for coming down at such short notice. I do have a question. The statistic of removing 1,500 healthy palm trees from the city of Miami Beach has been quoted by Commissioner Minor and others who have reviewed the urban forestry plan. I don't disagree with a single word you have said about the need for resilience, for the need for increased canopy trees, et cetera, et cetera. And I know it's slightly out of the purview of the item being discussed right now, but can you address where that number is coming from and why, if healthy trees are being removed, they're not being relocated to someplace else?
Sure. So through the tree permitting process, our urban forestry team evaluates whether a tree or a palm, number one, can be remaining in place and protected during construction. Oftentimes, that's not possible for various reasons. Either that's where the building is going to be sited, or construction means a methodology. So the palm or tree needs to be removed. So if that is the case, then the next option is to relocate that tree or palm to another location on site or to potentially a public site. So we often work with private development to potentially relocate trees from a private site to a public site. However, and also within public projects, we'll move, like right now we're talking about removing a tree in one park and placing it in another park in order to keep that large canopy. But it's not always possible. So for example, when we have trees and palms that are located closer to the beach, that sandy soil doesn't allow for a root ball to be created. And because there's no root ball, we're not going to have success in doing that relocation. Oftentimes, it's going to cost more money to even attempt a relocation, and chances are that tree is not going to survive. So in those cases, our urban forestry team, and there's various reasons. They're looking at the tree health. There has to be an arborist report. The urban forestry team will recommend that tree needs to be mitigated for. That tree or palm. So when we came up with that 1,500 palms to be removed, we worked with our public works and our CIP and our GeoBond team to identify projects which currently have a design. We know there's going to be impacts, and this is the count that we have. So it's not that we're looking to remove those palms for any reason other than the project. In order to accommodate the project, you need to. And relocation is not financially viable or viable from a health perspective. But we're always looking, and for example, actually, it's the hotel project. I was trying to remember. The hotel project over here, the parking lot behind us, has gorgeous large trees. So we're beginning that process now to do the root pruning so that we can move those very large mature trees to a park space so that we can continue to get those benefits. But again, it really is, you have to look at each project, the health of the tree, you review the arborist report. There's always changes that are made out in the field. But the great thing about Miami Beach is that we do have an urban forestry team who's dedicated in, first, the protection of trees, and then two, how do we continue to grow and expand our urban forest and do that through these projects. Does that answer your question?
It does, thank you. So just one specific that pops to mind, though. When that hill just north of 79th Street was leveled on the beach to make way for the beach walk that is starting its final phase of completion, yay, there were a number of palm trees and other trees that were taken down. So, and that is sandy soil, but it is on the edge of a huge multi-block park. So there was no opportunity to relocate those trees to 100 feet down the way to more sandy soil in the park?
The challenge is that the sandy soil doesn't allow for the relocation. So in this case, and some of the palms and some of the trees had structural deficiencies that would not make them a candidate for relocation, but from the ability for those trees to survive once they've been relocated, it's not possible. And so, yes, we had palm trees and trees that were removed at the beginning of construction. When that project is complete, it's going to be bringing back a considerable amount of both palms and canopy trees. So, I think it's one where at the beginning of a project, it's, trees are going to be removed, but you look at the end product. But also, while unfortunately with the sandy soil, it makes it hard, there are other areas of the city where we are able to do those relocations successfully. And we're always looking at the parks as receiving areas. So like I said, when private development comes in and they have a tree that's perfect for relocation, but they don't have room, we'll look at places like North Shore Open Space Park to do that relocation.
Okay, thank you for illuminating a lot of things, so thank you. I have a question for staff. So I'm a little bit torn, well, I'm very torn on this issue because I like the idea of making it a more equitable, simpler process, more efficient process, and one where you don't need to have a significant outlay for experts and lawyers to try to manage what your neighborhood and what your development and what your home is going to look like. I think that is really important because, as some of the callers pointed out, the very well-to-do and organized associations have resources of time and money and expertise available to them to do that. But a lot of people, as I said earlier, don't. And that is a concern. I am also concerned the last full commission meeting had, I believe, 142 items on the commission if there weren't some added at the last minute. And I am quite certain that even though as well-intended as this is, I fear that these applications won't be given the full due consideration that they need by people who are trying to get through an impossible amount of heavy-duty, heavy-lifting kinds of items. And so my question is there a way to sort of simplify the process going to the planning board? So you don't need to hire a lawyer. It's not a two-part review at the commission, but maybe it comes to the planning board in an expedited manner where the fees are waived if it's appropriate. I'm not sure what the details of that would be. And then pending our review and recommendation, it then goes to the commission for one review and vote instead of two. So it shortens the process and it simplifies the cost. And
unfortunately, we can't. Any amendment to the land development regulations requires an ordinance, a public hearing before this body, and 2 readings, and at least 1 public hearing before the city commission. But to address, I think I can address some of your points. The first is that there's no need to hire an attorney. I think that what we've seen with this city commission is that we see a commission that is responsive to the concerns of its residents. So there's really no need to hire an attorney to sponsor, for a commissioner to sponsor a referral on a city commission agenda to the planning board. The second is that I think that the either version that's before you provides a framework for neighborhoods to be vetted and added. So even if the planning board moves forward with the ordinance version, that sort of like the framework for your consideration, the criteria of how staff would analyze and how the board would consider new neighborhoods is drafted. So I think that it's sort of the way that these items have been prepared. I think they address what you're saying, which is to provide a framework, a streamlined framework for the consideration of additional neighborhoods.
I think it's nice to also remember we have city staff who's trying to put the best foot forward to make Miami Beach more resilient. And if a neighborhood decides, to Nick's point, that the architecture or what was there before is not defining their neighborhood but their foliage, and that they want to opt out of being and making the most sustainable move to protect a certain tree species, so be it if it's a little bit longer of a process. I think that it needs due diligence. It needs a check and balance. It needs eyes on it. I think it was great that Elizabeth could come down here today. And if this bypassed us, there was a lot of misinformation floating around about what this was about and over, and she was able to clear it up. So I think we see the importance that if we're going to be bypassing sustainability in our community, maybe it is a longer process. And I think it's great LaGorce can keep their trees. I'm a proponent of it. But I don't think we all of a sudden want every special interest in neighborhood in Miami Beach saying, I want to opt out of doing what's the most sustainable because, hey, I like this tree. But I didn't like my house. I knocked that down and built the Apple store. So, I think this should go planning board and then to the commissioners.
Does anyone want to make a motion?
Let me just ask a question. Procedurally, it would have to go to the city commission, then it comes to us, and then it goes back to the city commission between the two hearings, right?
Typically when we have an ordinance, it's referred to the planning board, and then and it would come to the planning board, then 2 readings at city commission.
And let me ask you this: if the resolution version is adopted, because we do like resident input, does it have the ability for the city commission to be able to still refer to the planning board? Is that
It would not be required.
it would not be required, but the commission would have under their,
I think they always have the prerogative. I think
they
they
have
do
this
that.
in their prerogative.
That's right.
It's their prerogative to do that. So if it does require that further vetting and input, they could, in their prerogative, refer it to the.
They certainly could.
I believe in streamlined processes when we're dealing with, especially with residents. If this includes a public notice requirement, maybe the residents' right to know that we have in our charter, we could include it in this language. I would be comfortable moving the resolution version to include that rights to know requirement in it.
We have a motion. Do we have a second?
I'll second it.
Okay, so the motion is the resolution version incorporating a public notice provision consistent with the resident's right to know?
Yes, that's correct.
Give me 1 second to write that down.
And that public noticing provision, is that a mailer or is that just an email blast? What is that?
That would be an email blast. Okay, so we have a motion by Mr. Fernandez. We have a second by Ms. Bott. So I'll do a roll call. Ms. Bott?
Yes.
Ms. DiPietro?
No.
Mr. Fernandez?
Yes.
Mr. Gelpi?
No.
Mr. Milan?
Yes.
The motion fails 3-2. We need 4 affirmative votes to pass a motion.
Well, the effect of that is that the ordinance would be transmitted without a favorable recommendation.
Right. It's just an interesting concept here, Nick, because right now we're sending this up with a favorable or unfavorable recommendation.
Right.
So the board is theoretically not in agreement as to. I think the board is in agreement to send something to the commission, right?
No, I think we're voting.
The question is it's.
Mr. Chair, aren't we voting on? I think we would vote favorably on the ordinance, but it's the manner of how it gets reviewed.
Right, but there's two alternatives. So, so again, conceptually, we all are in agreement on this. It's now we're talking about the process for this. So I guess if we say it's unfavorable, it's. Do you want to try to do a vote on the other one and see if that passes? That
you can. We can take another motion if there's another motion.
I'll move it under the overlay ordinance version. That has to go to planning board and then the commission.
I would second.
Okay, so we have a motion by Ms. DiPietro. We have a second by Mr. Gelpi. And I'll do a roll call. Ms. Bott?
No.
Ms. DiPietro?
Yes.
Mr. Fernandez?
Yes.
Mr. Gelpi?
Yes.
Mr. Milan?
Yes.
Motion passes 4-1.
I'll put it on the record, though I like the other one better.
So did I.
But it has to pass, and I would also, I guess, I don't know if we could talk to the commission to say, you're free agents here, you can decide on either one still. Okay. We're gonna just do it. I'm sorry. Do you need something or?
No.
We're going to go to item 6 right now. I'm sorry, they almost were up, but yeah, the commission, the police commissioner stepped in. This is number 6 on the agenda, PB 18-0238. It's just a progress report.
Okay, so this is a progress report. It was continued from the July 27th meeting. At the time, we recommended that the planning board continue the application just to keep monitoring the situation. I believe they had a band playing at their establishment, and they were holding a special event without a special event permit. Since that time, they haven't had any other issues. So staff is recommending that the planning board discuss and conclude this progress report. And I think the applicant's here if we want to.
I don't know if you need me to say anything about it. We're playing by the rules.
So, I don't know if we want to open a public hearing. I don't see any hands raised for this item.
Just a question, have there been any more violations?
There have not been any more violations.
Okay.
So there was one violation that happened. There was a band that they didn't realize they weren't or live music.
Mm-hmm. Yeah, they had a band, and then they had their crowds exceeded what they were allowed, so they should have required a special event permit, which are also prohibited per their CUP. So they had 2 CUP violations.
Okay, is there any action that we need to take, other than just that they don't need to come back in front of us? Is that
if you're okay with that, a vote to conclude the progress report.
Yeah, I'll move to close it.
I'll second that.
Okay, motion by Ms. DiPietro, second by Mr. Fernandez. Roll call, Ms. Bott?
Yes.
Ms. DiPietro?
Yes.
Mr. Fernandez?
Yes.
Mr. Gelpi?
Yes.
Mr. Milan?
Yes.
Item passes 5-0.
Thank you. Sorry for having
time.
to wait so long here today.
Can't they all be easy like this?
Mr. Vice Chairman, I think we may have skipped over the request for continuances.
Yeah, not yet, but I think that's what I wanted to get to next.
Okay.
Because I think there's an issue here, and there's some confusion, because I think some folks didn't think that Mr. Fernandez is going to be here, and I think they sent a lot of people away who were perhaps going to be here. So let's hear who potential continuances or requests for continuances right now. Who's first up here? I think you got to arm wrestle to get. Okay, you're first to the stand. You're quicker than Mickey.
I'll take it.
And this is which matter right now?
Good morning, Mr. Chair, board members. This would be the matter Mila, 800 Lincoln Road, which on your agenda is
item 7.
Yes.
So this is a previously continued.
Yes, sir. This was an application that was improved in part, but a portion of it was continued. And noting you have a short board today, we're just asking that it be continued to your October meeting.
Does anyone want to have any discussion about it? Is there anyone from the public for this?
We have no hands raised, and staff has no objection to the continuance.
Okay. Does anyone want to have a discussion about this? Or okay, is there a motion or a second?
I'll move to continue it.
Okay, we have a motion from Ms. DiPietro,
I'll second it.
second by Ms. Bott. I'll do a roll call. Ms. Bott?
Yes.
Ms. DiPietro?
Yes.
Mr. Fernandez?
Yes.
Mr. Gelpi?
Yes.
Mr. Milan?
Yes.
Motion passes 5-0.
Thank you very much.
Thanks. Take care. Mick, you're too slow to the podium here.
It's all right. Very patient. Okay. Good morning, Mr. Chair, members of the board. Mickey Marrero, law firm Burke, Howard, Fernandez, and Larkin, 200 South Biscayne Boulevard. Item is 1415 Marseille Drive. Unfortunately, we got noticed when the chairperson was unable to attend that there would be four members and we couldn't hear the lot split. I advised my whole team I know things have been evolving, but it was a little bit too late to get everybody remobilized, so we just need to ask for a continuance to October.
Is there anyone from the public on this one?
We have no hands raised.
Anyone on the board care to discuss this? If not, we'll take a motion for this.
I'll move it to be continued to October.
Second.
Okay. We have a motion by Ms. DiPietro, second by Ms. Bott. Ms. Bott?
Yes.
Ms. DiPietro?
Yes.
Mr. Fernandez?
Yes.
Mr. Jalpi?
Yes.
Mr. Milan?
Yes.
Motion passes 5-0.
Thank you.
Okay. I think should we go to item 8 here? I think we're going to put the discussion items later on right now. And just so everyone know, I have a hard stop at 4 because I have a flight to catch. So I'd like to get through applications and legislation. And if we get to discussion, great. But if not, I'm going to have to take off at some point. So I think the next one would be number 8, which would be PB 16-0075, 601-685 Washington Avenue.
Okay, so this is a revocation and modification hearing for 601-685 Washington Avenue, which is the Good Time Hotel. So this item has been before the board for a few hearings now. Since the last hearing, which was on July 27th, there have not been any new violations. However, we have gotten some emails with complaints, but there haven't been any violations issued. Because this is a revocation modification hearing, staff is recommending some modifications to their conditional use permit to clarify some conditions of operations. And so I'm just going to briefly go through what our recommendations are for the changes. The first is that the conditional use permit currently allows them to have entertainment 7 days a week from entertainment levels of music. So they are allowed to have DJs for longer hours, but they can only exceed ambient levels between 11 a.m. and 8 p.m. 7 days a week. Staff is recommending that be modified to only Friday and Saturday, and that's between 1 p.m. and 8 p.m. So their starting time would be moved back 2 hours. The next change that we're requesting is that they be required to maintain a manager on duty and to oversee the operations, and that the passwords for the sound system only be provided to the manager, and the manager is the only person with access to changing volume control levels. Second is that require that the outdoor speaker system require the deployment of multiple small, closely spaced speakers driven at low individual volumes. That's a distributed sound system in order to keep the sound from spreading far distances. The second is that all outdoor speakers be oriented in a way to minimize sound propagation towards nearby residential buildings. The third is that only the applicant's outdoor approved speaker system be used. So DJs can't bring speakers to supplement their house sound system. Next is that the applicant's sound system not be audible from any area west of Washington Avenue at any time. This is one of the big changes. Currently, we treat it as the eastern face of the Arcadia House, which is the apartment across the street. This changes that threshold of which we consider it audible to the west side of Washington Avenue. So it moves the line a little bit further east because we're finding that if you can hear it at the western face of the Arcadia House, but by that point it's too late and it's probably being heard further up. The next is that within 30 days of the revocation and modification hearing, the outdoor sound system shall be tested by a qualified acoustical professional, and that they shall provide a report to the planning department, which will be peer reviewed. Next, we require that the applicant train all staff that services outdoor areas on sound-related conditions of the CUP in order to assist with enforcing these limits. We have a condition that the applicant shall incorporate additional sound attenuation measures for the outdoor areas where possible. And then the last modification that we're requesting is incorporating a condition which we typically include in most applications which require outdoor entertainment, which is that a violation of Chapter 46, which is the noise ordinance of the City Code, also be considered a violation of the CUP. So those are the major changes that we're requesting, and then we have the applicant here before us. And we do have some people with their hands raised if we want to have a public hearing.
We'll let him, Mr. Larkin do his presentation.
Yes, sir. So, good
Mr.
morning.
Larkin, would you like me to swear in any members of your team who'll be testifying so I don't interrupt your presentation?
Yes, they'll all raise their hand.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
So, good morning, Mr. Chairman, or good afternoon, Mr. Chairman, Board Member Staff, Michael Larkin, 200 South Biscayne Boulevard, here within the Good Time Hotel. With me today are the day-to-day people behind the Good Time Hotel. Avi Yeslowich is our general manager. Nick Fieldings, Group Hospitality, operates Strawberry Moon. Also, Dave Koch. He is new to our team. He is our sound expert, and they hired him from Criterion Acoustics. And my partners, Mickey Marrero and Matthew Amster. Could I ask that our presentation be pulled up, please, that we submitted a few days ago? Thank you. And I'll ask to advance the pages in just a little bit. And also, Mr. Chairman, or whoever is in charge of the digital divide, we have Dave Koch. He is our sound expert. Could he be promoted to participate via Zoom? I don't know if Rogelio, you're in charge of that.
I do not have that power.
Is that communication?
I believe you said David Koch. I believe his hand is raised.
Right.
If we want to add him as a panelist.
Are you promoting him now?
I can't promote.
Oh, who can?
I'm requesting that it be done.
Okay.
Good to go.
Okay.
All right. Got it. Thanks. Gotta love the era of Zoom. So as a reminder, the Good Time Hotel opened a few months ago in April this year, which is the culmination of 7 years of hard work by the owner, from teaming up with the city to get the Washington Avenue incentives adopted way back in 2014, to the Planning Board and Historic Preservation Board approvals in 2016 and 2017, to building permit and construction of this full block development. The owner remains steadfast in the commitment to revitalize Washington Avenue. The Good Time Hotel concept from day one has always been providing a daytime, rooftop, outdoor venue, not a ground floor venue that's allowing the ground floor to have flourishing, more interesting commercial uses, retail and restaurant uses, rather than dead during the day with nightclub uses. This is a marked transition from the numerous nighttime super late hour nightclubs that had numerous additional issues and had barren storefronts, as I just said, during the daylight hours. This is a key component to the Good Time Hotel, as well as to the successful rejuvenation and realignment of Washington Avenue. Even before the July progress report, we lowered the music and have been keeping the music at ambient levels. We have completely stopped headlining DJ events. Notably, there has not been any noise violations since July. As a reminder, we have appealed all the violations issued regardless, and those appeals have yet to be heard by the city's special master. We have hired Dave of Criterion Acoustics, an expert sound consultant with great experience in entertainment venues, including the outdoors in places such as Las Vegas and the Poconos and Asbury Park on the Jersey Shore, to perform a full analysis and modeling of the sound system for a complete overhaul. Dave has produced a sound study that shows that this outdoor venue can coexist without detriment to the neighborhood. We have recently submitted Dave's sound study to the city to begin the peer review process, which takes some time to complete. It's not complete now, but the city's peer is in the process of doing that. A major component of this revised system is an acoustic wall along the perimeter, east and north of the pool deck. This will greatly assist in keeping the sound contained at the venue. Notably, it will be an extension of the existing green wall and will further beautify this project. This element alters the exterior of the building. As a result, we have filed the required Historic Preservation Board application and will appear before that board on November 9th for our hopeful quick approval. Important conclusion of the sound study that Dave has produced is that the noise barrier, the new distributed sound system, and other attenuation provide a 25 decibel level reduction for the residential neighborhood. And Dave's going to get into that and explain how significant that is during his portion of this presentation. This means that any music offsite will be at or below ambient noise levels in the area. We're also going to have Dave speak about the sound system modeling and improvements, and he's going to go through, and I'll skip to the part of the PowerPoint presentation that correlates to his testimony in a little bit. We've also continued and expanded our neighbor outreach. We reached out to many surrounding residential owners, including the Arcadia House and the apartments at 650 Euclid Avenue, and other concerned individuals to let them know of our progress and address their concerns. We've also met with the Flamingo Park Neighborhood Association on September 13th to provide our status update and answer questions. They've anointed Jeff Donnelly to be their point person, so we met with Jeff separately, explained what we were doing to Jeff, so Jeff is fully up to speed with our progress here. We are committed to making this work and have taken all appropriate steps to be a good neighbor while working carefully to revise the sound system. This effort takes time. With music already turned down and major events not happening, there is no urgent need to take any type of action now. It would be premature without the guidance of the experts. We need to let the city's peer review vet Dave's study, and we need to let the Historic Preservation Board hear and approve of our application for acoustic wall on November 9th. As a result, we respectfully request that you all continue us to November 30th for another progress report. By that time, several benchmarks will have been met. We believe today it's premature to do anything that staff is suggesting. As a result, we would respectfully request that you all continue us until November 30th to have a full progress report where we can tell you what the Historic Preservation Board did and what the peer review has thought of with regard to our study. We hope that we'll also be able to have our appeals heard by then. In short, let's do this right. Let's not piecemeal it. By November, we'll have a comprehensive game plan for improvements. Revocation or the adoption of any measures suggested by staff today would be harsh actions that would have a chilling effect on an owner and operator working very hard to resolve past issues and to make Washington Avenue a really vibrant corridor. The owner has been and will continue to act responsibly for the benefit of the neighborhood. This project is needed to turn Washington Avenue into a vibrant daytime commercial corridor as it was always meant to be. And our outdoor entertainment on the pool deck can coexist with appropriate sound attenuation, measures that take time to work through and implement. But we are taking step by step in order to address concerns raised by neighbors and you all at prior hearings. Please give us the time to properly address the situation and return with a more comprehensive package for a progress report in November. I'd like to turn it over now to Avi. He is going to discuss in more detail the neighbor outreach that he is responsible for in the last couple of months.
Good afternoon, distinguished members of the board. It's a pleasure to be here. I'm Avi Yesowich. I'm the general manager of the Good Time. Thank you for your time and consideration. So, in one of the previous hearings, I was observing and listening to all the feedback from the residents in the community, and I was really taking a lot of notes. And I was with my colleague Nick Fielding, and we had made the determination that the best thing that we could do to explain the Good Time story and what we're trying to bring to the community while also respecting their concerns comes from direct outreach. So I personally wrote down the names of every single person that spoke and all the communities that spoke in coordination with our legal team, and I reached out personally to anybody who would be willing to listen. And I'm very, very pleased to report that I think the response and the connection that we built with the surrounding communities, specifically 650 Euclid and the leadership of Andrew Wharton and Gene Carpenter there, and also with Lorna Salas, who's the president of the Arcadia House, and also with Jeff Donnelly and Scott Needleman, who I reached out to make the connection so we can explain not only the mitigation measures that we're taking in order to make this system work for the community, but to be an active and great steward and revitalizing the neighborhood and also giving back to them. So the dialogue really started with Lorna Salas, who's at the Arcadia House across the street. She's a wonderful woman, very receptive. Nick and I went and visited her back in early June after this was really starting to bubble up. And we had a very open discussion about the mitigation measures that we were taking and also how seriously we took the complaints. We went through operationally all the different measures that we were taking in order to reduce the sound, and also invited her and the community to come over, tour the hotel, understand what we're trying to do there, and see all the improvements, both on the operational side and the investment side, that we are taking to eradicate this problem. So that was an ongoing dialogue with Lorna, and then I actively reached out to, again, Andrew Wharton, the treasurer at 650 Euclid, and Gene Carpenter, again, wonderful people. Andrew's actually in the business, so it was a great having a connection with him, and he understands kind of the trials and tribulations of building a new hotel project and doing it successfully. So I engaged in dialogue with them, and again, very open, very honest. We were fortunate to have Gene come over in mid-September, and again, toured the property, let her experience the restaurant, and just see actively. We're not sitting around doing nothing. We're responding genuinely and sincerely and actively to each of these concerns that were raised by the community members that surround the Good Time Hotel. I believe, and I don't want to be subjective here, but I do believe that we did establish a great relationship, and this is not going to be a short-term relationship. We actively and openly invited them to come back to the hotel for future events, and we'd love to host community events in order to bring them into the fantastic and beautiful property that we built so they can experience it for the long term. I certainly don't want to speak on any of their behalves, but I do feel confident that we established a very strong beginning portion of the relationship, and that will continue to endure. I truly believe that, and on top of everything else, it's very, very important for us that everybody here knows that beyond the investment that's going into resolving this issue, we as people in the hospitality business truly care about the people inside our four walls and outside of the hotel. And I truly hope that we made that impression. If you have any questions, I'm certainly available to answer them at the time. But thank you very much for your time and your consideration.
Thanks.
Thank you very much, Avi. Now, Mr. Chairman and board members, I'd like for you all to turn your attention to Dave Koch. He has now been promoted as a panelist. And with regard to the communications department, could you please advance the slides, and I'll tell you when to stop. So next slide, next slide, next slide. Stop. Oh, go back one. Please go back one. Thank you very much. So this is where, Dave, you're going to start your testimony here, and this is Dave Koch. He's from Criterion Acoustics. Go ahead, Dave, and begin your testimony. When you want to advance the slides, just say next slide, please. So go ahead.
In 2011, we projects that are very tied to the hospitality markets. We've done extensive
Sir,
noise
can you,
modeling.
sir, you have to speak up a little bit. It's very difficult to hear you.
And Mr. Larkin, how much additional time, just because we've got 20 seconds on the clock, do you think you're going to need?
Just 5 minutes.
Okay. Mr. Chairman, is that okay?
Mark. Is that better now?
I'm sorry. Yeah, that's fine.
Yeah, just speak closer to the mic, Dave, but it is it is marginally better. Go ahead.
A Zoom error. Okay, sorry about that. So I founded Criterion Acoustics in 2011, and we work extensively in the hospitality industry with issues such as this. Some of the major outdoor projects we've worked on, since in 2008 in Las Vegas, we've worked on every major tower, from Cosmopolitan of Las Vegas to Circa to Resorts World to various special wind projects. Most recently, in Asbury Park, New Jersey, we worked with very similar modeling techniques as that city has grown with similar issues such as this one to help control the outdoor noise from impacting various residential units. We also, a couple of years ago, completed a project in the Poconos for Live Nation at Mount Airy Casino and Resort, which had similar issues with an outdoor concert series. And needless to say, it's very quiet there because it's a rural country environment, and we use similar modeling techniques for success. We've helped the Good Time Hotel folks develop a plan here to mitigate the noise. The first step is constructing a 12-foot high barrier wall, which is shown in green. This barrier wall is a special noise barrier system manufactured by IAC Acoustics. It's not site-built. And in total, it's about 9 inches thick. The barrier wall is very good at mitigating low-frequency noise and is absorptive on the pool deck side. So it will absorb as much sound as is on the pool deck side. Should we advance to the next slide so we can look at what it will look like? So from the exterior, we plan to plant foliage all the way around the noise barrier to conceal it, and the barrier system can be painted whichever color we choose to be behind the foliage. Next slide. There's a second rendering with additional foliage growing over time. And next slide. So we combined the barrier wall approach with a highly directional loudspeaker system. In the past, I would say about 7 to 10 years, subwoofers have become much more directional, and this utilizes rear firing drivers and digital signal processing to help control the sound on the pool deck. Combined with the barrier wall system, we begin to get very effective results from leaving the pool deck and impacting the adjacent residences and neighbors. So on the left chart is the model utilizing DBA. DBA is what most folks are familiar with when people use the term decibels. DBA really is how we perceive hearing. It many years ago was very tied to OSHA for hearing loss, etc. The chart on the right is DBC, and DBC is much more focused on the low frequencies or the bass. As you're aware from hospitality environments, both considerations are quite important. So if you zoom in to the left sound plan model, I'm not sure if that's possible.
I don't think so.
Okay, but in the center of the pool deck, we put receivers, and we modeled the pool deck operating at 86 to 88 dB, depending on exactly where you were. We achieved a 20 to 25 dBA reduction with the barrier wall and the directional speakers. To put this into perspective, every 10 dB is either a halving or a doubling of sound. So this is 4 times as quiet at some of the first receiving locations. DBC was also modeled, and we are getting around approximately 20 to 25 DBC reduction as well. So similar results. The pool deck system can be tailored. It's highly zoned with very good control in the system's design to be able to lower or control different speakers in different frequency range, as well as limiting certain portions of the sound system on the pool deck. To put it into perspective, when you begin to see 60 to 65 dBA at many of the facades of the residence, 60 to 65 dBA at the facade of many of the residents, I believe a chart was circulated to the board members.
It has been. Go ahead, Dave.
And, some reference points are basically, this is, if you were standing on a sidewalk, passing a typical automobile or a very busy office. So 60 to 65 dBA is very similar to general urban noise. It's a very reasonable approach. Michael, is there anything else I need to address? But I think in summary that the approach we're coming up with, the combined noise barrier approach and directional sound system, will make immeasurable improvements, and we can really achieve a system that works for the residents surrounding the Good Time Hotel.
I think that's it, Dave. Thank you very much for your testimony, and just be available for questions, okay?
Sure, I'm here.
And thank you, Mr. Chairman. Again, we expect a request a continuance until November 30th.
Okay. I think there's probably people from the public here, so I think we should probably, since they're putting on testimony, we might as well listen to the public.
Okay. And I just wanted to let you know, we do have our sound consultant who has begun the process of reviewing this on the line if questions come up later.
Okay.
So for the public hearing, David Koch just spoke. So the first person we have is Jeff Donnelly.
Mr. Donnelly, do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Can you hear me?
Yes.
Can you hear me?
I think you just cut out. I don't know if you can hear us.
No, let's move on and bring him back.
No, can you hear me?
Okay, we hear you now.
Can you hear me now?
Yes.
Yes, okay. Thank you, Mr. Chairman. My name is Jeff Donnelly. Speaking for myself right now, the key issue is not how many decibels there are on the pool deck. The key issue is whether or not the sound, audio sound from the pool deck interferes with the peaceful enjoyment of the property, of the residential properties to the west of that. We really are very grateful to the planning staff because of their effort to bring a conditional use permit that really improves the situation for the residents, and we're supportive of that. I also really would like to correct something that came up.
I think we lost him. Okay, let's move on to the next person, and hopefully he gets a better connection.
Okay, the next person is Marty Labert.
Hi, do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do. Can you hear me?
Thank you. Yes, we can.
Great. I appreciate the work that the staff did a lot, and I think it's valuable to the city, certainly to the adjacent residents, and even blocks beyond where we have heard the music earlier, to go ahead and implement that. If Good Time is observing it, then great. If it's not, then the residents have the protection of what the staff has researched and recommended, which is valuable. I appreciate that Good Time has put a lot of money and effort into this. I don't want to forget how much people have put into their homes and their peaceful enjoyment of them, and some of us work in our spaces. The 60 to 65 decibels urban standard, is that
Maybe we have the back.
We lost you. Hello?
I have just unmuted myself. It said that the host muted me. I thought maybe my time was up.
No, 40 more seconds, I think.
Yep.
Okay. 60, 65 decibels, urban standard. Is that passing noise or constant noise? Because we're not in the entertainment district, and I don't think we want that standard as constant noise. Again, appreciate what the staff did, would like to see it implemented. If they're interested in being good neighbors, they'd have no problem observing it. Thank you.
Thank you.
Okay, next is Patricia Pinto.
Hi, Patricia, do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Hi there. Yes.
Thank you.
Can you guys hear me?
Yes, you have 2 minutes.
Great. Again, I want to echo what everybody's been saying. I really appreciate all the work that you guys have put forth, the good times, and you guys as supporting us residents. I live a block and a half away, and I think that 4 times less than what it used to be, right, these parties, I personally don't think that it's enough. So I'm not sure how you guys are going to test this out in the future. Just know that from living, I live between 7th and 8th in Pennsylvania, my entire home would shake. I could audibly tell the words of songs. I mean, the whole party was in my house. So if that's going to be 4 times less, then it's going to be the party outside my house. And I don't want to sound like a bummer to everybody that's been working so hard on this, but that's the level of noise that was happening. So just wanted to say that to you guys, just to understand how loud it was.
Thank you.
Next, we have Niels Bax.
Hi, do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
He seems to be unmuted. Niels, can you hear us? No. Okay.
take the next one and come back?
I guess
Yeah.
the next hand raises are sound consultant Jesse Einert. So I think that's it. Sorry? I don't see Jeff on anymore. Jeff? If you want to speak again, raise your hand, please. Jeff, can you unmute yourself?
Hear me now.
We can hear you now.
Good. I'm not doing anything, so I don't know why I'm being cut off. But in any event, to pick up the Flamingo Park Neighborhood Association and, the Flamingo Park neighborhood is really notorious for being a place where somebody is awake and somebody's asleep 24/7. And so, the idea that you can, playfully play during the day and, avoid a neighborhood conflict is not valid. The real issue is how does it sound in the neighbor's apartment, not, what the decibel level is at the source. And so again, the Flamingo Park, Neighborhood Association passed a resolution. That resolution is still in effect, and it's been part of your material from the beginning. Thank you.
Thank you. Is there anyone else from the public?
I don't know if we want to try Niels again, because his hand is still raised.
Let's give him a
Yes,
shot.
can you hear me now?
We can hear you now.
Hi, do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You have 2 minutes.
Okay, I just wanted to add that I think, and I was invited to visit the property and appreciate that, and I spoke to Jeannie, I'm part of the same building, and she and I had a conversation about this, and we truly appreciate the efforts that the hotel is making. One thing that I have concerns about is that we're talking about measures the way they're doing it now. There's no excessive parties, there's no extra loud music, and when I was reading back into the paperwork that was all submitted, it's always been vague about the intent of the rooftop, and only after opening, the intent of the rooftop was, in my words, an outdoor club where loud music, big parties with big DJs were. And such a facility at that location, I think, especially with the garage in the background and the echoing of the sounds, and we have rooftop outdoor spaces as well, that was, to the earlier speaker, very loud, very noisy, etc. If the intent is to have an outdoor pool with entertainment, and that described as we have some music, an occasional louder party, great. But if the intent is to have every, Thursday or maybe Friday and Saturday, true outdoor discotheque club-like music, I think it's going to be very challenging to, put that in that residential area where they are. So that was really my concern, is the past 2-3 months since, the complaints have arrived and the music has been lowered, we're talking about an outdoor pool with the occasional sounds. But if it's going to go back to full-time club, I'm not sure if all the measures that are being discussed even fit. And to the earlier speaker's point as well, currently we vaguely hear some music, but, if it goes, I don't want continuous, whether it's bass or non-bass, but continuous music ongoing that we can hear as soon as we open any door or window of our property. Thank you.
Thank you. Anyone else in the public?
That's it for the public.
Okay, so we're going to
I don't know if there's anybody in the audience.
So, Mr. Chairman, can I have a quick rebuttal just of a couple of points that I think were made unclear? So, when Mr. Donnelly was talking about the measurement of the sound, our sound expert has done modeling based upon the speakers that have been selected. In the modeling, yes, you have to have one reference point being what is the decibel level of the music on the pool deck. But if you remember back on the slides, there were multiple measurements that were made off the property. Every little rectangular bubble were a series of 4 or 5 measurements that were made off the property, whether it was dBA, which is the lighter sound, or dBc, which is the bass sound. And just to give you a frame of reference, for the Arcadia House, the range for dBA, which is the lighter sound, is 59 to 63. And that's a conversation that could be 3 feet away. That's a common frame of reference. When you measure the bass sound, it was 68 to 71 dBc, which is classroom chatter. And even on this OSHA chart, which is something the venerable Don Washburn from the Audio Bug used to give for all his sound studies, you can see the frame of reference. 50 is a typical suburban area background, 60 is a busy office, and 70 is if you're on the sidewalk listening to a passing automobile. So again, we think any action today would be premature. We've just submitted our sound study. Jesse's already working on it. Jesse is your peer reviewer, but he's not done with his efforts. And the Historic Preservation Board has yet to weigh in. We'll do so November 9th. So by November 30th, we will have be fully equipped to come back and have a good, honest debate with you all about these conditions. So thank you.
Thank you. With that,
Mr. Chair, can I ask a quick question?
Go ahead.
The reason you're going to Historic Preservation Board is because of this new wall that you're adding
Correct.
to the building?
Correct.
And the height of the wall is 9 feet? 7 feet?
9? 12. It's 12 feet.
12
it's,
feet.
I think, 9 inches thick.
Okay.
Yeah, 9 inches thick.
Okay.
Okay, with that, we'll close the public hearing and open up discussion amongst our members.
I just want to clarify one thing. I just got a message from Jesse. He did send us he has completed his peer review. So we did get the results of that. We haven't really gone over them as staff yet because we just got them. So it's available. But staff has no objections if the board does want to continue it to next month.
Has no objections if we decide to continue.
Correct.
Okay.
Can we get a synopsis from him on what he found?
Sure.
I mean, it won't be a final anything, but just a quick snapshot of what he thinks is going on.
Is he available?
Yeah, Jesse, can you give us a quick update or summary of your findings from your peer review?
And Jesse,
Yes, can you hear me?
Sorry, do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Bless you.
I do.
Thank you. Yes, we can hear you.
So great. Okay, I see. Excuse my dog. So, the report was well done. I agree with the need for the 12-foot, 9-inch thick wall. The proposed wall is a good product. The model was also well done. An issue that I had with it, though, is that the product of the report indicated that with 86 to 88 dBA on the pool deck, that you're reaching a maximum of about 65 dBA on the nearby facades, presumably on the other side of Washington Avenue, and 70 to 75 dBc on the facades across Washington Avenue, which is likely to be audible. I mean, it may not be continuous, but I don't want to give the impression that it's not going to be audible. And the sound plan, or what I assume is the sound plan model, modeling results bear that out. Those are my big takeaways, and I also recommended that a sound level monitoring system be installed there to kind of hold them to the limits that will presumably be set by a calibration exercise.
So just so you all know, we weren't aware of anything that Jesse just testified to. We weren't given that in advance because it wasn't ready. I'm not casting blame here or there. Just so Dave might be able to respond, he might not. I would prefer that he take more time and he and Jesse actually talk before the next hearing on November 30th.
Yeah, I don't feel comfortable if staff hasn't seen this, they haven't seen this. It's hard to really do this on the spot, and I would prefer to continue it till everyone can kind of look at this new information that has just become available.
Yeah, I just wanted to get a little snapshot of what the findings were. No, it was nothing binding, no pop quizzes, nothing like that. Just wanted to get a headline.
Thank you, Tanya.
Is there a reason? I know continuing to November allows you to come back with everything ready to discuss, including the permission to go ahead with the wall. But is there a reason why we can't sort out kind of the rest of the issues in advance of that in the October meeting? Is there a reason why it has to be pushed back 2 months?
I wouldn't want to do it on a piecemeal basis because the HPV meets on November 9th. And if the HPV tells us, oh, we don't like a 12-foot wall, but 10 feet we're fine, then our whole sound study has to be redone to account for a 2-foot reduction in the height of the wall. So, and we'll do that quickly, and we'll get to Jesse quickly, but it won't, by October, that event will not have happened.
So what plans do you all have between now and then to mitigate the sound issue? Because you don't have a wall built, you don't have the new speaker system in place. Like, there's a lot in process, and I understand how much effort by everybody involved and how much money is being put into this. So it's not for lack of good intentions. But at the end of the day, I got 2 phone calls yesterday, or 2 text messages yesterday from 2 different people saying that in the early evening they were hearing noise and they were calling code and whatever. So I don't know what the outcome of that is, but the de facto issue is that there are neighbors who are still hearing music when, in theory, they shouldn't be hearing very much at all. And so, I am not a sound engineer. I know it may shock you, but I'm not a sound engineer. But it seems to me the simplest thing to do is to, put the metaphorical piece of tape on the control volume knob and say it just doesn't go past here, period. Like, ever, for any reason.
So, Tanya, I don't disagree. And just, the objective evidence here is that there have been no noise violations issued since July. There may have been complaints. And it's so hard because there are subjective standards here, but as you all know, code compliance has been out en masse since June, stationing themselves at corners, not walking, stationing themselves in front of the Arcadia House. So if code compliance has not issued a notice violation, I think the absence sometimes proves a positive here, and the absence of the violation proves that we are really behaving ourselves. We're not having loud events. I can't account for the people that texted you, but I can say that we haven't had any loud DJ headlining events, since July. We won't going forward until we resolve these issues.
This is a question, I think, for you guys. In the language here, it talks about only the manager having access to control noise. So we have the GM of the entire facility, the entire hotel property. I'm sure there are probably other managers who have, a more specific area of control. So when we say manager, who are we specifying? Because I would imagine to have you running up to the pool deck every 20 minutes because somebody thinks it might be too loud is not really the ideal way to proceed. So can we be more specific about that? And the corollary to that is that in the interest of protecting access to the volume controls, we specify, or it's specified in here, that only one person will have access to it, presumably per shift. But I would suggest that having a backup person so that you don't have to wait 45 minutes to find where the first person is, or if the first person is engaged with a VIP, you're not going to say, excuse me, I have to go turn down the music. Like, that's just not a good look for you guys.
I think that's a smart idea. And what we usually do is we proffer what I call counter conditions, or a red line version of staffs. So before we come back to the hearing, we'll distribute those to you all and to staff. And like what you said, it could be a deputized manager that's just responsible for the sound box, and then have an alternative deputized manager. So the chain of command is never broken, but it never proliferates.
So, but maybe between now and November, you put those practices into action so that there are no hiccups. And then you'll also be able to say, hey, listen, we've been doing this for 2 months. It works great. Or, it doesn't work, and here's why, and here's what we suggest.
Right. We've had situations here where there's been different people responsible and no one responsible, so you get a lot of that.
Yeah.
Right. And so we don't, I think we're going to be specific on this in whatever modification we end up doing.
And Avi just nodded his head, so that's on the record.
I'm sorry?
Avi just nodded his head. He's nodding his head strongly.
For the sake of time, I think they don't have violations. They seem to be putting their best foot forward while they're constructing this wall and doing their best to mitigate this for the neighbors. But I'm happy to move the continuance because I don't think we're going to make any decisions today.
Is there a second?
I'll second it.
Is that continued to October?
November 30th.
November. I think to be most efficient, November.
Okay, so we have a motion and a second. The only thing I'm going to say is that, you have an opportunity to do good and you have an opportunity to do bad here.
Yes, sir.
Right? Because if you do bad here, it's going to be very impactful on how I look at this, and I'm sure a lot of my other colleagues here feel the same way. So if we start getting a lot of complaints, and we understand the complaints, sometimes maybe just some are more real than others, perhaps, but we want to make sure that you understand here that you got to be on your best behavior now, starting now, and obviously after the CUP is issued. But then the CUP is going to be modified a little bit to deal with some of the issues we're going to talk about in November.
Right. May I add to that? Just very briefly. I mean, if you go back to the conversations we've had in prior months, nobody is discounting the amount of effort that has gone into this project, the amount of money that's gone into this project, and the possible good that could come out of this project as it improves and sort of figures out how to proceed. And we want you all to succeed. The issue is that you built a hotel with a roof deck party space effectively adjacent to neighborhoods, and that is a reality of the fact. So as my colleague Mark said, the vice chair said, prove to us that you get it, you're internalizing it, and you got the memo, and that's just how it's going to be, so that nobody's even texting any of us saying, oh, they were so loud again, I can't believe it, I had to call code. Whether or not it's subjective, let's just make all those things go away, because you guys are doing everything within your power with the facilities you have at your disposal now to make it work.
Right. I think, Al, before we take the vote, I think Alex just wanted to say.
Yeah, and just a question for the city attorney. Let's say if we were to consider the staff recommendation, we would need 5 favorable votes for that. Is that correct?
That's right.
Okay, just for the public to understand that, there's a feeling on the board that there's a need for an analysis of the peer review that was submitted, so it seems like there wouldn't be those 5 votes. But I just want to make sure that I get for the record.
We have a motion now, Alex. Now I understand you. We have a motion right now. That's pending.
I just want to make sure that Mr. Larkin is saying that they're working and that there's not going to be any events going on there.
But there will be no major noisy events for sure.
Okay.
Just minor noisy events.
Okay, so
Thank you, Mr. Chair.
we have a motion by Mr. Pietro. I'm sorry, I missed who seconded the motion.
I did.
Okay, Ms. Bott seconded the motion. Okay, roll call, Ms. Bott.
Yep.
Ms. Pietro.
Yes.
Mr. Fernandez.
Yes.
Mr. Jalpi.
Yes.
Mr. Milan.
Yes.
Motion passes.
Great. Thank you very much.
Thank you. Good luck. Be good.
Behave.
We do have food for the board members back here if you guys want to get take a quick break.
If you guys wouldn't mind working, we could be slobs and eat while we're going forward, because I'd like, I do have the hard stops. I'd like to try to push as opposed to take a 20-minute that turns into 45 minutes.
Yeah,
if you guys don't mind.
I have my bar.
Well, you have the salad there, don't you, too? So I'd like to just continue moving forward, and everyone could go get their salads and eat, and excuse the public, excuse us if we're getting food on ourselves while we're hearing this, but it's a much more efficient way to get things done. I think that the next one is an application is a mechanical parking. Is that the next one, which would be number 9 on our package, PB 21-0455.
Neeson, are you going to be prepared to move forward on this item? Yes. Okay.
We're going to eat sitting and hearing. Yeah, we'll get through this.
An efficient meeting. Efficient meeting. I like it.
Mr. Kasdan, if you'd like, I can swear in your team now.
Yes.
So if you intend to testify today, please raise your right hand. Do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Yes. Okay, so I'll give the staff introduction real quick. So this is file number PB21-0455. The address is 5333 Collins Avenue. So this proposal consists of a new 17-story residential tower that will replace an existing 14-story residential building. The applicant is requesting a conditional use permit for a parking garage which contains mechanical lifts, which will be used to park 68 cars, and 115 traditional spaces for a total of 183 spaces. The mechanical lifts consist of single stackers and double tandem stackers. They're pretty standard in terms of mechanical lifts. The ground floor of the tower will contain the lobby and the driveways to access the parking garage, and the parking garage will be in the basement level. The proposal contains 100 units, and actually that's a reduction from the existing building, which I believe has 120 units. And then the only other use on the site, in addition to the residential amenities, is a small 200 square foot retail space located at the ground floor. The parking garage is complying with the requirements of Chapter 130-60 regarding the ability to adapt should roads be modified or roads be raised and for resiliency. And so with that, staff recommends that the planning board approve the conditional use permit subject to the conditions in the draft order.
So, before you speak, we're really only discussing right now, looking at whether or not they should be able to get mechanical lifts for this property.
Correct. This is just the mechanical parking. The design review board will be considering the rest of the design and the building and all the other issues. Thank you.
Mr. Chair, members of the board, good afternoon. Neeson Kasdan and Chris Pinellas of Ackerman representing the applicant 5333 Collins. And I'm very proud to present this project to you. I understand that the slice that you're looking at is a relatively minor component in the overall scheme, but I would also, by the way, like to thank you for constituting a quorum for this conditional use, because team members came from out of town and were about to scatter literally minutes from getting on an airplane.
Yeah, and thank you for staying. We apologize for that.
We appreciate this.
We also thank you, Alex, for showing up today early. Thank you.
This project, I would just want to say two things about it. This is another great project which will move the city of Miami Beach in terms of its character and its quality in the direction that we want it to go into. And secondarily, this is also a great step forward in terms of resiliency and sustainability, as you will see in the presentation. I'm going to introduce the project team. With me today is Michael Patricio of Mass Capital. This is a venture of Mass Capital and Starwood Capital. And for the presentation, we have the architects Jason Long and Yusuf Dennis from the Office of Metropolitan Architecture, Rem Koolhaus's firm. Landscape architect is Neil Porter with Gustafson Porter in the United Kingdom, who is available online if we need to talk to him. Same with Adrian Dubkowski from Kimley. Before I turn it over, Rogelio has given you the very straightforward application that we have. The project is approximately 100 residential units in a 19-story tower with 183 parking spaces. The mechanical parking systems are the only reason that we are coming before this board. Of the 183 spaces, 68 will be mechanical lift parking spaces and 115 traditional parking spaces. We meet all the criteria under Section 118-192 regarding conditional use applications and for mechanical parking. And so I'd just like to turn it over to Jason Long from OMA. I happen to have worked with Jason on he was the lead architect for the Faena buildings on the west side of Collins Avenue, including the car park and most significantly the Faena Forum. So Jason and Yusuf are working again in this city, and I'm pleased to introduce them.
Thanks so much, Neeson, and thank you all. It's great to be back here again. I think we have a presentation that might need to get brought up.
Here it is.
Oh, okay, great. So as Neeson already covered, we've been developing this residential building at 533 Collins. Next. Maybe you can go through the... Neeson covered this, but the building is, there's a 200-foot height limit, and which we're, of course, complying to, as you'll see. Next. So where our office was founded in Rotterdam. We're doing this project out of New York, where we've been doing a number of projects, including, of course, the Faena Forum. Next. Our work does not really have a specific style, but tries to always respond to the specific conditions and even the history of the site that it's coming into, which I hope you can see here in Miami Beach at the Faena Forum, which is on the lower right here. Next. We've also been developing a number of residential towers, not unlike this, throughout the world. Most close to here is the 3 towers at Park Grove and Coconut Grove in Miami. Next. And we're working on this project with landscape architect Gustafson Porter out of the UK. They're known throughout the world, and most specifically here for their work that they're doing right now on the reconfiguration of the Eiffel Tower grounds for the 2024 Olympics. Next. And also the Princess Diana Memorial in Hyde Park. Next. Next. So the project is located in a really special part of the beach between 44th Street and just north of this site where Collins runs along Indian Creek. Next. You can see here the existing La Costa condominium building that's on the site today, which fills the site kind of from north to south. In this area of the beach, you really have views both to the ocean, of course, but also back across the creek into downtown Miami. Next. Here, a number of views around the site where you can see the existing building in place from both sides of the site. Next. Next. So as I mentioned, when we started to approach this building, we wanted to take advantage of this special location and the potential to have views really in both directions, and also to try to occupy the site in a way that was more porous than the existing building. Next. And so we began thinking about it. What if we were doing a smaller building, a kind of a home even? How would we orient it? And we saw that if we rotated it at 45 degrees, we could actually capture views in all directions and looking past our neighbors and also not getting in the way of our neighbors. Next. And we thought if we almost multiply that module, we would also echo in some ways the scale of the homes even across the creek, and a smaller scale than maybe a kind of straight slab would imply. Next. And so if we extrude those modules, next, and then fuse them together, we come up with a form that's both articulated and really designed to take advantage of the peculiar conditions of this site. Next. And here you see that the result on the site itself. Again, we're biasing the building toward the middle of the site to maximize visibility and kind of a sense of porosity through the site. Next. And also the way we meet the ground and meet the sky, we wanted to treat in a way that would create kind of beneficial conditions all around. So next. We actually sculpt the top, stepping down from the 200-foot height limit at the top to create a series of terraces, and also below to create entries and amenities. Next. And then here you can see the end product on the site from the beach. Next. And then here again. Next. And we're also adjusting the kind of form of the building to emphasize the scale. Next. And then here, looking from the creek side. Next. And then here you can see a view of the entry from Collins. Next. And I'll turn it over to Yusuf to talk more about the mechanical parking.
Hi, good afternoon. So as you enter the site from Collins Avenue via curb cut on the south, you enter past an entry pavilion which takes you from the street level up to the main level of the building, which is at plus 13, so plus 5 feet above freeboard. And from there you have access to the lobby and then can proceed down into the single level of underground parking. Next. You can see here our mechanical parking strategy, where we have 183 spaces, 68 of which are stackers. So this is at plus 0, so 4.5 feet below the street level. Next.
Are you planning on doing valet?
We are planning on doing some valet, yes.
With the stackers, or is it valet?
Yeah, not exclusively valet, but for the stackers. And here you can see the sectional relationship of the main deck at plus 13, and then the single level that includes mechanical parking at plus 0. Next. And we've also illustrated a kind of traditional non-mechanical parking scenario that happens over 2 levels. So here, only building landward of the coastal construction line and adding a second cellar level at minus 10'8" NGVD. Next. So here you see, again, similar plan on the first cellar level, B1, using no mechanical parking at all. Next. And then the sub-cellar level, which contains 105 spaces. So reaching the same number of parking spaces, but here within 2 floors and without using any mechanical stackers. Next. So I'd like to also introduce you to the kind of concept behind the landscape design that we've been working together with Justice and Porter to develop. Next. Using a mixture of resilient and native species that can really connect inland plantings to coastal plantings and further connect the site into its context. Next. So here you see an arrangement plan across the site where along Collins Avenue we're introducing significant shade trees for pedestrians, and then as you move across the site, creating moments of intimacy and discovery that lead you and tenants towards the ocean. Next. And here you see a rendering from the beach side with the pool for the residents. Next. So what we're really doing is taking a site that is really kind of concrete jungle with only 1,500 square feet of landscape, next, and transforming it into a kind of lush, open green space that contains over 15,000 square feet of green space, which we see as a huge improvement. Next. Next. So in conclusion, I think we've really created, or hope we've created a building that is both subtle but also very memorable. Next. A building that opens up towards the ocean, next, and breaks down the kind of wall of buildings that you typically see along Collins Avenue, next. And a building that uses shape and material and color in a subtle way to further break down the scale and create a sense of rhythm as you move around the building, next. And I think it's something that, again, we feel is quite unique, next, but also feels at home within the context of Miami Beach. So with that, I'd like to thank you all for your time and for the opportunity to present to you today.
Thank you. And that concludes our presentation. Our team is here for any questions that you might have.
Thank you. Yeah, let's open for the public hearing right now.
And while we wait for the public, do any board members have any ex parte communications to disclose on this application? No? Okay.
Okay, the first person, well, there's only one person with their hand raised, that's DL.
Okay, please state your name for the record, and also, do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do. My name is Dario Farello. I object to this application. I'm the owner, one of the owners of this property. Still, we have an ownership interest in my unit and in the common elements of the entire condominium, as are 15 other unit owners. The board of the association never discussed or voted on this application. The applicant still doesn't have full ownership of the property. We still own our units, and we did not consent to any sale. So if Mass Capital is representing to you that they have full ownership of this property at this time, it is false, because it is very much in dispute and we're in active litigation with them. They've claimed to have terminated the condominium. Our position is that the termination is invalid, and in fact the division is currently investigating that. But even if it were valid by the applicant's own admission, they don't own the entire property yet at this time, because they're trying to partition the property, and that has not happened yet. So either way, they do not fully own this property. So how can you approve or even consider an application like this when there are a significant number of owners who object and their application appears to be on false pretenses, namely that they fully own the property when they do not? So for these reasons, I strongly oppose this application and any other application that this applicant brings to you with respect to this property, which is still my home. This is premature at best and improper at worst, as it tramples on our rights as unit owners, including our constitutional rights to due process and protection against forced sale of our homestead. So thank you for your time.
Thank you, sir.
We
so
do
I think
have another person
these are legal issues, right, that we're really not really within the purview of our board here, right? I mean, this is a dispute amongst this developer and the existing condominium owners, which seems to me it's kind of irrelevant to us at this point because we're just here to decide on mechanical parking for a potential project. Is that accurate, Nick? Or?
That's right, Mr. Chairman. It sounds like the comments during the public hearing may relate to a private dispute.
Right. So whatever happens in that litigation, if there is any, happens, and if this group here wins, they can move forward on a project based upon decisions that we make here.
That sounds right to me. If you have any questions about the litigation, though, I would defer to the applicant.
I frankly don't see how that's really relevant to decide whether mechanical, parking spots are here. That's an esoteric condominium law issue. So, is there anyone else from the public right now?
Yes, we have Maria Alvarez.
Hi, Maria. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Maria, can you unmute yourself if you'd like to speak?
Is there anyone else?
That's the only person with the hand raised right now.
Okay.
Is that it? Public?
Maria's the only person. Maria, going once, going twice.
Okay. If I'm going to close it to the public right now. If she joins, I'm going to let her in. Okay.
Okay.
So at least we can move it forward.
She removed her hand.
Okay. I don't know if anyone wants to talk about this right now or.
I'm in support of it. I think when we see buildings being designed like this, it's exactly what we're looking to transform Miami Beach into. And if approving mechanical parking allows us to have more permeable landscape, natural landscape, then there's really no reason to object here.
I would just chime in. I think the design is great. A disclosure, I have several OMA books, including OMA's research on the metabolism.
So he's going to be conflicted out that he's going to have to not vote on it.
I like the elevation. It reminds me of Isozaki's clusters in the sky. I think it's a very cool proposal. I guess the auto car park comes to us because of the noise impacts with the neighbors. So, I mean, is there typically any type of like sound study or anything that we would consider?
No. Not really. We had, not with this type of a system. We've had a robotic system in another situation where there were some conditions on noise, but in a system like this one, it's just a typical lift. There aren't too many issues.
It's just a two-space lift, as Rogelio was saying, where you had the full mechanical garage. That's where there were issues with neighbors.
I'm a big believer in more automated parking generally, even the ones where you get out and just kind of send your car along. So I think the less we can excavate and do significant earthworks on the shoreline, the better. So anyway, I think we're not the design review board, but I think it's a great design and a nice proposal. Your next step is
we're going before the design review board in this month, actually.
Okay. Great. Yeah, I think it looks great, guys.
Well, actually, I guess November now.
November, yeah.
It was because it was continued.
Okay. Alex?
Yes.
I'm sorry to interrupt. Maria did raise her hand again.
Okay. If it's
yeah,
okay.
of course, for the public always.
Hi, Maria. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Can't hear Maria.
Maria, can you hear us?
While we're waiting, we're going in
Okay, I
October,
apologize.
actually. October to DRB, not November.
Can you hear me?
Now we can hear you.
Yes.
Okay. I'm an owner of a unit on the Amethyst, and I object to Mass getting an approval on something they don't have the permit to even build. How can they get an approval on a parking when they don't even have the permit to build and construct? Also, there are owners that still have, their property is there. They're the owner. Mass is not the owner of the 100% of the building. How could that be?
What's up?
And the noise is unnecessary at this time. There's nothing approved yet. There's no construction approved yet. I think it's a waste of your time on taking your time right now on approving something that hasn't even been approved. That is it.
Thank you.
You're welcome.
So, ma'am, I just want to say that, we're not here to deal with a dispute that may exist between a neighbor, between an existing condominium unit owner. This applicant here is willing to take the risk here, spend the time, money, effort to move the project along. If there is litigation, which we have no knowledge of, then whoever, the result of that everyone lives with, and if they can't build a building, then they've wasted time and effort, but they're allowed to go forward with this process, and so we're going to go forward with this.
Mr. Chair, there is another hand raised in case you want to take that person. I know you closed the public hearing.
Sure.
Okay, Manny, your hand is raised. You can speak?
Hi, Manny. Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do. Good afternoon, everyone. Can anyone hear me?
Yes.
Yes? Okay. My family also owns a unit in La Cosa, 5333 Collins. And I just want to have on the record that everything that was said here is in regards to the parking lot. However, a lot of the comments that were made were not in regards to the parking lot, more in regards to the landscaping and the architecture of the building. Just for the record. And also, these people basically are kicking us out of our homes, using their legal terms and their attorneys, whatever it is. We have our attorneys now trying to defend our home. And just wanted that on the record, that you're not voting based on the aesthetics of Miami Beach. It's also our family that lives there. People live there. Just take that into your consideration, because although it is just for a parking lot, there's still people. Thank you.
Thank you, sir. Again, I'm repeating myself a bit, but we're here to decide whether or not, if this building goes forward, if after the result of litigations are decided, whether or not mechanical lifts can be installed in the parking lot. So it's a very narrow issue here. The issues you're talking about and your other fellow owners will be decided in a different forum, but not this forum. Alex?
Yes, and just to echo a little bit of what you said, Mr. Chairman, this is if this project does go forward, then this would be the mechanical parking for that, and the review of our scope is just strictly the conditional use approval for the mechanical parking. Is that right?
That's correct.
Okay, and this mechanical parking being underground, if I could get confirmation, it results in a reduction in scale and depth of the parking, and it relieves the necessity for there to be a pedestal parking structure.
Either a pedestal, or alternatively, they could have gone 2 levels below ground. So either way, it would reduce the excavation.
Okay. All right. Perfect. Thank you.
You're welcome.
So let me say something first in a second. So I always think it's a little bit, not silly is a bad word, but the whether or not mechanical operated garage lifts, to me, seems to be a staff issue. It doesn't have a lot to do with planning, with what we do. And it just seems it's a little bit quirky always. They come before us, yet it's a good idea. It creates less ugly parking garage space and pedestals and stuff. And so it makes a lot of sense to me. The technology exists. It's just a comment. It's not really specifically commenting on this one. It's just I always thought that it's such a no-brainer to allow these mechanical lifts that it's almost not worthy of coming before us at planning. Go ahead.
As always, I have a few questions, so just if you don't mind.
Sure.
So by doing a mechanical parking situation like this, is there a great difference in weight and stress put on the ground underneath it between parking, a mechanical parking version versus 2 stories of parking?
Well, the architects could answer that, but of course, anything that is going to be put there is going to be engineered to have the support that it needs, whether it's mechanical parking or separate levels of parking. So that has to meet all the engineering requirements and pass the engineering requirements of the city.
And have those requirements changed either by the city or by your team based on the unfortunate circumstances in Surfside? Is there, I'm not, this isn't a gotcha question, I'm just curious. We all saw what happened, it was terrible. So is there now an additional type of study that gets done, or?
No, I don't know if there have been other changes in the engineering rules with regard to that specific thing. What I will tell you, though, is that the means and methods, engineering, technology of the buildings that are being built today are significantly stronger than the building that collapsed, the Champlain Towers. So all these new buildings, the way they do the concrete mix, everything, the engineering is advanced over what it was 40 years ago. So that's one of the positives, candidly, of these new buildings being built.
In terms of the noise and vibration, if you're on the lowest possible residential floor, what is going to mitigate that from the parking structure to the first residential unit?
Well, the architects could answer that. I think a couple of things. First of all, these are only, number one, these are only lifts, so where there's only one car put on top of another. It's not a large mechanical piece of equipment moving many cars through different levels. Number two, of course, it will be the residential levels are not just above, but I think at least 3 levels above where this will be. So I'm sure that it will be done in a way where they're going to be selling very expensive units, where the mechanical parking will be done such that it has no impact on the residential.
And if you're standing outside of the parking structure, can you hear the lifts when they're operational?
You should not be able to, because this is going to be partially subterranean and also screened, and so you shouldn't be able to hear anything.
So if you're standing on the sidewalk at the entrance of the driveway going down to the garage,
you won't see anything.
You won't see anything.
I'm sure you won't hear anything.
It'll be like it's invisible, like it's not even there.
Right. As opposed to today, the current parking deck there covers almost the entire site. You can see all the cars, and the cars coming and going, and the headlights and the horns and the doors slamming. This will be completely secreted from public view.
Thank you for answering the questions.
Welcome.
Do I have a motion here?
I'll move it. I'll be happy to move it, or I'll be happy to second.
I'll move it.
She's on a roll here. She's the
I'll just move them all.
Hoover today.
And I'll second her motion.
Okay. Motion to approve. We have a motion from Ms. DiPietro, second by Mr. Fernandez, and I'll do a roll call. Ms. Bott?
Yes.
Ms. DiPietro?
Yes.
Mr. Fernandez?
Yes.
Mr. Gelpi?
Yes.
Mr. Milan?
Yes.
Motion passes.
Thank you very much. Enjoy
Thank
your
you, Mr.
lunch.
Kazin. Sorry if I was drooling on myself or got like a little salad on my...
We prefer you having
Did I have any of my teeth?
eaten while we were working. That's
Yeah.
respectful of the people out here. Thank you.
Thank you. Beautiful project, by the way. Okay, we're going to take the next, which is, I think this is legislation, right? This one. So this is Planning Board 21-0456, 7575 Collins Avenue, Bandshell Historic Designation.
Okay, so this file number, PB21-0456, 7275 Collins Avenue. We have Debbie Tackett, who's the Historic Preservation Officer, who will be presenting this item.
Good afternoon, members of the Planning Board. It's great to see you in person. It's been a while. Yes, as Rogelio mentioned, this is a request for a proposed historic designation of the North Beach Bandshell as an individually designated historic site. This request was initiated by the Historic Preservation Board in December of 2020. Excuse me. On September 13th of this year, the Historic Preservation Board did review the designation report, which I believe is in your package. After that discussion, the board issued a favorable recommendation to the Planning Board and to the City Commission regarding the historic site designation for the Bandshell. The Bandshell is an excellent example of post-war modern style of architecture. It was constructed in 1961 and designed by prominent local architect Norman Geller. For the reasons I'm not going to go into every little detail because that is in the designation report, but we did find as staff that the proposed designation does satisfy the historic preservation criteria. We believe it satisfies the Planning Board review criteria as well as the sea level rise review criteria, and we are recommending that you transmit a favorable recommendation to the City Commission. If you do so, we would appreciate it, and the first reading is scheduled for October 13th.
Can I ask a question?
Absolutely.
So is this just for the Bandshell or the whole area? Because the question is, let's say, I think the Rhythm Foundation works out of there, right? And let's say they wanted to do an auxiliary structure or something because they just needed it for demand for music
so
and
if
the
you
arts.
look at, I think we provided the legal description in a map or property survey in your report. We had a separate property survey done for just the immediate area around the Bandshell. So, for example, it is in Bandshell Park, which is the entire parcel.
Right.
This designation would not include the Unidad facility or any significant land area outside of the footprint.
So there's that newer building there, right? So that theoretically
Correct.
could be expanded, modified, or something.
Yes, and we've been working very closely with the Rhythm Foundation, who has come out in support of this designation as well. I believe they are going to be considering going to the Historic Preservation Board for some modifications, and they're very comfortable with this process. So,
Mr. Chair, if I could just go
Sure, go ahead.
Just a question, Debbie. The impact of this designation. Well, what is it, the effect? It makes it more difficult to demo? Or?
The effect is that it will transfer jurisdiction from the Design Review Board to the Historic Preservation Board.
Right.
Typically, the Historic Preservation Board, the major difference between the Historic Preservation Board and the Design Review Board is the authority over demolition. However, in this particular instance, because it is a city-owned facility, as long as it stays city-owned, the City Commission would have the ultimate authority regarding any request for demolition of the structure.
And I think for residential structures, if please confirm that this is the case, are you allowed maybe more flexibility in terms of zoning setbacks and any type of development in relation?
There are incentives. Not necessarily with zoning incentives. It's dependent upon the underlying zoning and if there are any overlays or special considerations for contributing structures or historic structures. But there are also some building code incentives in terms of upgrading facilities, floodplain waiver, and that type of thing. I don't really think that this particular property would really avail themselves of some of those incentives. However, there are also enhanced grant opportunities. This is a non-for-profit tenant that we have. Also, the city is eligible as a government to apply for grants, and the historic designation would avail ourselves of more opportunities to apply for grants.
If I could just ask one more question. What are the reasons not to grant historic designation to a structure seeking it?
We review everything in accordance with their criteria. There are more considerations that we look at now, namely the sea level rise and resiliency criteria. So there could be instances where we would be cautious. In this case, there's no habitable area below base flood. The adjacent grade is very high to begin with. So we see no downside in this particular case, but we would evaluate any request on a case-by-case basis.
But so I guess to echo or to expand on that, is the benefit, is there some potential opportunities for funding or,
There's enhanced opportunities to apply for funding and for ranking in funding, right? If you're a historically designated site, usually, even if it's not required as part of a grant application, usually that is given weight to your application during the review process.
Does anyone have any? Is there anyone from the public waiting to speak?
We have one hand raised, Donald Worth.
Mr. Worth, do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do. My name's Donald Worth. I'm a resident at 1390 Ocean Drive in Miami Beach, and I'm also a board member of the Rhythm Foundation, and we enthusiastically support this historic designation. We think it'll do several things for us. For one, it does provide an extra layer of protection, I think, designating it, and not that the building is in any imminent danger right now. It also provides us with some cachet. We like to think we do terrific world music in a very, very special venue. We have been very aware of the historic importance of this building, and when we collaborated with the city of Miami Beach a couple of years ago to make some improvements to the band shell, we made sure that they were sympathetic and compatible with the building. The canopy is round, and as you know, the new canopy, which is wonderful, by the way, was designed with the assistance of Ira Giller, the son of the original architect, Norman Giller. We have a second set of very modest changes to the band shell. We've already previewed those to the Historic Preservation Board, and we're comfortable that we can make those changes within the historic designation envelope, and that's what we want to do. I should say that there's been a lot of discussion about culture in North Beach and the Byron Carlisle. As a board member, you should know we got something very terrific here in the band shell. Next time you can, just Google North Beach band shell, and you'll see we've got 11 events scheduled for October. Terrific events. The Arts Center has moved their Gospel Sundays to the band shell. The great Blue Note Jazz Club has done concerts at the band shell, and they can continue doing that. And most recently, AEG, the second largest concert promoter in the world, and they are, by the way, not able to promote events at the Fillmore because that's a Live Nation venue. They did an event at the band shell. They will be back. So we're already bringing culture to North Beach, and in fact, on November 11th, we're having a fundraiser for the Rhythm Foundation at the band shell, and we're celebrating the 60th anniversary of the band shell. So we're hoping to get this designation in place. I'd like to thank Debbie Tackett so much and the Historic Preservation Board, and please approve this designation. And by the way, if you check, you'll see that Miami New Times has just awarded the Rhythm the band shell as the best music video, the best music venue in Miami. So this just proves that feasibility and historic designation can work hand in hand. Thank you.
Thank you, Mr. Worth. Is there anyone else in the public?
Yes, we have James Quinlan.
Mr. Quinlan, do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do. Thank you.
Thank you.
Yes, just to, again, echo what Don has said, and thank Don. I don't need to repeat it. Don is one of our great champions, and one of the great champions of North Beach as a MIMO district, really, going back to the original recognition there. And thanks to the staff, great staff at HP for this designation report. Brought a number of things to light, and I think it's really worth reading. We're going to be celebrating this, as I said as he said for the 60th anniversary on November 11th. And I urge you all to support this. We are absolutely in favor of designation. We are very proud of our iconic location in the center of the MIMO district. Thank you for your support.
Thank you, Mr. Quinlan. Anyone else in the public?
We have no other hands raised.
Okay, with that, I'm going to close the public hearing, and I'm going to recognize Alex.
Yes, and thank you, Mr. Chairman, and I want to start off by thanking the Historic Preservation Board and to the planning staff for working on this, but the Historic Preservation Board that initiated this designation process. I think when we have structures like this that possess integrity of design and architecture, even after 60 years of existence, is worthy of this designation. It not only contributes to our architecture and style, but it also contributes to our city's history. And so I just want to thank the HPB for having initiated this, and it was good to hear Mr. Quinlan on the phone on Zoom. Keep up the good work over at the Rhythm Foundation, and thank you. At the right time, I'd be happy to move this item after we hear our colleagues.
I was going to do the same thing. And thank you, Debbie, for you and your team's work on this. I mean, it's there's this push and pull in the city of it's old, get rid of it, it's out of date, it doesn't work anymore, and everything new and shiny is better. And this is just an example of why that is not the case. It is a fantastic venue. It would serve as a fantastic endpoint for a cultural corridor going from Normandy Fountain to the Byron Carlisle to the Rhythm Foundation and the bandshell. Ira Giller, Norman's son, just did the edition, the Martini Glass edition, and it is absolutely a fantastic structure that I have enjoyed for many years and look forward to it enjoying for many more years. And if Alex is making the motion,
Before I want to say something, I'm going to let you guys do the motion in the second, but I do want to say something too here. So I moved here in 1971 to Miami Beach, and I was a North Beach kid, and I used to roller skate at North Shore Park on the corner where the building is now. But they used to have basketball courts there, and we'd go over to the bandshell and hang out, and then Carvel right down the street. It's an amazing place. The only I do want to say is that the stage there is currently named the Doug Burris Stage, and who's a very important person to me and to many people in Miami Beach. And I just want to put it on the record that, whatever happens there, that name can never come off that stage because he was such an important person. People will forget about it perhaps 50 years from now or so. But for the people who went to Beach High, who experienced this man, he founded Rock Ensemble Beach High. And I just want to put on the record that name never comes off that stage.
Mr.
I don't know if we could. I'm sure we don't have the power to do that. I'm just putting it on the record.
I apologize to interrupt, but I didn't have any information when we prepared the designation report. So feel free to send me some supplementary information about the namesake, and we would.
It's just for people who grew up Miami Beach. That name is an incredibly important name to people, and he deserves to have his name there in perpetuity.
I'm more than happy to supplement the designation report with some of that information. That would be great.
Okay. With that.
Yeah.
No, I'm going to let you. I'm going to let you move it. So.
Yep. As amended by the chair, I think what he's saying. I think when we talk about historic preservation, it's not just architecture, but the people who have contributed to it. And as you well stated, I support what you mentioned. So move as amended.
Second.
Okay, so that's a motion to approve. And you said as modified, so that would be to add.
I don't know if you have the power to do that, but if we do, whether it's a power to do it or a suggestion, a strong suggestion that it's there, I just want it to be there because, we won't be here 50 years from now and maybe they decide to name the stage something else, but it should be there forever as long as that bandshell's standing.
You can include the board can include that as a recommendation that the city commission retain the name.
I'd be very much in favor of that if you want to.
May I ask a question in addition to what we're doing here with this motion? That name on the stage was that done through commission action or is that the individual organization that did it?
I don't know.
Because perhaps, Mr. Chairman, you may want to make, in addition to what we're doing here, make a separate motion asking the city commission to consider, adopting the name by legislation.
Do you know, Debbie?
In addition to this.
I don't know.
I don't know how that happened. I mean, why, how that came about to name the stage, but it is named that, and it was a big deal. There's a big concert there and celebration, which I participated in.
Okay.
Well, if you want to include in your recommendation that the city commission, retain the name and or formally name the stage. It's going to take follow-up.
I think we can keep it within this within
Okay.
this legislation, but that's
All right.
an add-on.
Okay, cool. Yeah. So that's amended.
Suggest to CC to retain the name.
To retain and then stamp it permanently.
Etch it.
Etch it in stone.
Okay, got it. So I have the motion by Mr. Fernandez. I have it second by Ms. Bott. I'll do a roll call. Ms. Bott?
Yes.
Ms. DiPietro?
Yes.
Mr. Fernandez?
Yes.
Mr. Jelpy?
Yes.
Mr. Milan?
Hell yes.
Motion passes unanimously 5-0.
Thank you very much.
Thank you. Okay. Brought me back to high school there.
You got to bring your guitar.
Next time. Okay, next is PB 21-0461, medical cannabis and pharmacy overlay.
Okay. One second to get to that page. Okay, file number PB21-0461, medical cannabis overlay. Just by way of background, state law requires, as part of the recently adopted constitutional amendment that authorized the sale of medical cannabis in the state of Florida, the implementing legislation requires that local governments, if they want to regulate the locations of medical cannabis dispensaries, have to regulate them in the same manner that they would regulate a pharmacy. So if we want to allow a medical cannabis dispensary in a pharmacy in an area, we also have to allow a medical cannabis dispensary in an area. We have to, and then any conditions that we apply to the medical cannabis dispensary also have to apply to the pharmacy. So, by way of background, and I'm sure Mr. Larkin will explain it further, Care Resources would like to incorporate a pharmacy into their facilities as a result of federal regulations. So in order to accommodate that, what this legislation proposes is creating a new sub-area where both pharmacy stores and medical cannabis dispensaries would be allowed. In this case, it's a one-block area located between Michigan Avenue, Lenox Avenue, 17th Street, and Lincoln Lane North. Actually, the parking lot just north of Lincoln Lane North. And it has several protections to minimize any potential impacts from any potential medical cannabis dispensary and pharmacy store. I'm going to briefly just go through them. It requires that the treatment center, the medical cannabis treatment center or pharmacy store be accessory to a medical office, clinic, or health center. It limits the hours from 6 p.m. except one night where they're allowed till 7 p.m. It requires that the medical office have at least 2 full-time physicians or physicians extenders and a minimum of 5 patient examination rooms. Requires that it be located in an office building with a minimum area of 25,000 square feet as of the effective date of the ordinance. So it can't be in a building built after that date. Requires that the medical cannabis treatment center or pharmacy store not be on the ground floor. Requires that the area used for the pharmacy or for the medical cannabis treatment center not exceed 1,000 square feet. It requires that the treatment center only service patients from private waiting rooms or pharmacy stores from private waiting rooms. Prohibits queuing of patients in hallways. Prohibits exterior signage and has a distance separation of 600 feet. So a pharmacy has to be 600 feet from another pharmacy, and a medical cannabis dispensary has to be located 600 feet from another dispensary. So in this area, because of the size of it, it would really pretty much only be limited to one establishment within this area. And it requires that there be no variances from this section of the code. So with that, staff recommends that the Planning Board transmit the proposed ordinance to the City Commission with a favorable recommendation.
Good afternoon, Mr. Chairman, board member, staff. Michael Larkin, 200 South Biscayne Boulevard, here representing Care Resource. Could we please pull up the presentation? And then Rick Saklari is, would we please promote him to a panelist? He's now out there trying. And just, I don't know if there's a way, Rogelio, to let me know whether he's been promoted yet, but.
PJ, can you add? I'm sorry, could you repeat that?
Rick Saklari.
Rick Saklari as a panelist? I don't see his name on the list.
Okay, well.
Okay, oh no. No, I don't see the name on the list.
You guys text him and just tell him to raise his hand. He's not there? Okay, thank you. Okay, hopefully he'll join toward the end of the presentation.
Okay.
So, good afternoon, Mr. Chairman, Board Member, Staff. Michael Larkin, 200 South Biscayne Boulevard. Here representing Care Resource. With me today is Stuart Stein, Jonathan Welsh, and Rick Saklari. Rick Saklari is the Chief Executive Officer of Care Resource, and I'm sure he'll be with us shortly. And from my law firm, my colleague, Nicholas Rodriguez. As many of you know, Care Resource is an important South Florida nonprofit institution that provides care to thousands of underserved and vulnerable individuals. Care Resource was founded in the 1980s in response to the AIDS crisis, and over time has grown to a multifaceted healthcare organization offering treatment for almost any ailment to those who need it the most. Today, we are here before you with proposed legislation to allow Care Resource to operate an accessory pharmacy in conjunction with the existing medical clinic at 1680 Michigan Avenue, which it badly needs in order to continue providing high-quality charitable care to the community. Care Resource funds many of its programs through what is called the Federal 340B Drug Discount Program, which allows Care Resource to obtain deeply discounted medications. 80% of their revenue is generated by the 340B program. And could you please turn to next slide, please, to reinforce these points?
Mr. Saklari is on if you need him to speak.
Thank you, Rogelio. I appreciate the notice. So 80% of their revenue, as you can see in this slide, is generated by the 340B program. Without it, many of the services that Care Resource offers could no longer be offered. The issue is that Big Pharma, which I collectively refer to as the largest pharmaceutical manufacturers, has threatened to stop providing discounted medications to Care Resource because they utilize retail pharmacies like Walgreens and CVS to dispense their medication to their patients. The message from Big Pharma to these federally qualified healthcare centers is create your own pharmacy network, don't depend upon Walgreens and CVS. Care Resource purchased an additional unit in its building at 1680 Michigan for the purpose of opening a pharmacy. Care Resource did not realize that under state law, local governments that regulate location dispensaries must also apply those regulations equally to pharmacies. In Miami Beach, we have adopted subzones where pharmacies and dispensaries may be located. 1680 Michigan Avenue is not within a subzone. Care Resource has obtained a variance to operate a small pharmacy with a subzone at 1427 Alton Road. However, the temporary pharmacy at 1427 Alton is inconvenient and an administrative burden for Care Resource. It also does not provide the same clinical benefits and is less private than the pharmacy that Care Resource proposes to operate at 1680 Michigan Avenue. Next slide, please. So the goal is to allow Care Resource to open an accessory pharmacy to its existing medical clinic at 1680 Michigan Avenue. From the beginning, we knew we needed support of the surrounding residential and business communities for the legislation to get off the ground. We presented to Palmview, which is to our north, the Lincoln Road BID, and the Flamingo Park Neighborhood Association to our south. Each of those entities has asked for certain suggestions, language in the legislation, and we have included that language and earned their support. Next slide, please. This is, since I'm blind, hold on. This is a letter from Palmview indicating their support for the legislation. Next slide. This is the resolution from the Lincoln Road BID indicating its support. Next slide. And finally, we have a letter from the Flamingo Park Neighborhood Association, which was a letter of support for the Board of Adjustment variance application for the pharmacy at 1427 Alton, but the last sentence references the pending legislation and says they'd be in support of it as well. Next slide, please. So the existing healthcare center at 1680 Michigan is located between Palmview to the north, Lincoln Road BID to the immediate south, and Flamingo Park Neighborhood Association just south of Lincoln Road. The boundaries of our subzone would be 17th Street on the north, Michigan Avenue on the east, the northern lot line of the city parking lot on the south, and then Lenox Avenue on the west. But in truth, the green boundaries within the blue dotted line are really where a pharmacy or dispensary could locate. Next slide, please. Rogelio described to you all a number of different restrictions that we put in there, making this the most heavily restricted subzone within the city. If you look at the second bullet with regard to dispensaries, the law, the litmus test that the city attorney's office uses is it possible that a dispensary could locate within the zone? That's the state test. Is it possible? Not probable. And with all these restrictions, I will tell you that it's not probable that a dispensary would be here. And particularly the second bullet on the left-hand side is that medical cannabis treatment centers are prohibited within 500 feet of schools. So the Lincoln Martí School is on the north side of 17th Street within 500 feet. They would have to get a variance from the Board of Adjustment in order to have a dispensary at this location. Staff granting in favor of that, staff recommending approval, and the Board of Adjustment granting a variance is really far-fetched, I think. The next bullet is the pharmacy must be located above the ground floor. We got that suggested language from the Lincoln Road bid. We accepted it. The building which the use must be located must be an existing office building, 25,000 square feet in size. That is our office building. It can't spread to others. The Lincoln Road bid also asked us to expand the definition of medical office, so we did so in more precise definition with at least 2 full-time physician extenders and 5 exam rooms. The maximum size of the accessory pharmacy is 1,000 square feet, very small. The Lincoln Road bid also asked us to include no exterior signage or advertising. We agreed to do so. No retail sale, alcohol sale. The condo association, because 1680 Michigan Avenue is a condominium office building, they've asked us to limit our hours of operation, no later than 6 p.m., except 7 p.m. once per week. We agreed to do that. Of course, we also proffer that we cannot sell or distribute cannabis to cannabis or cannabis products. Within the legislation, there is language that says we have to use our best efforts to serve patients only and avoid impacts on neighbors. That was also from the condo association. And finally, they said no queuing in the hallways. We agreed to accept that condition as well and make it a part of the legislation. So we are doing everything we can to balance between Care Resources' need of having an accessory pharmacy use and in no way being a nuisance to anyone outside of our building or within our building. So with that, I'd like to turn over to Jonathan Welch. He's going to explain to you a little bit more about Care Resources' role in our community, and our testimony will end with Rick Siclari. But now, please turn your attention to Jonathan.
Good afternoon. I've been working at Care Resource for 8 years. It's a great place where people provide compassionate, competent, and committed care every day. I'm also a resident here of Miami Beach and a patient of Care Resource. Care Resource, we are a nonprofit. We are a multicultural, community-based organization since 1983, and we are a federally qualified health center. In fact, we are one of the largest federal qualified health centers in South Florida. What makes us unique is that we serve people who are vulnerable and places, people who may be underserved. We are a safety net. We are our safety net for people that are low income, uninsured, and underinsured. Last year, our health center served 25,000 patients with 125,000 visits. What's unique about those patients is that over half of them, in fact 53% of them, are uninsured. We have a whole scope of services. I'm going to read out just a bunch of them to kind of give you an idea of the kind of services that we provide. We do primary medical care. We do diagnostic labs. We do immunizations. We do behavioral health, substance use disorders services. We do women's care, pediatric care, pharmaceutical care, case management, HIV primary care and support, nutrition services, outreach services, and even specialty services like gynecology, podiatry, and neurology. But regarding our office in Miami Beach, which is right next door, we've been serving the residents of Miami Beach for almost 35 years. Almost 2,000 residents of Miami Beach come to our health center for their care, and our office has served over 3,000 patients with 12,000 visits last year. Our impact in the community is huge, and this pharmacy would be of great benefit to the patients that we serve. Thank you.
Thank you very much, Jonathan, for your remarks. And our last speaker, Mr. Chairman and board members, is Rick Siclari. He's the Chief Executive Officer of Care Resource. He has been the CEO for a long time, and it's been a great time for Care Resource under his stewardship. So, Rick, are you available to speak?
Yeah, I am certainly. Can you all hear me? This is the first time I've ever been on Zoom where I can't figure out anybody's faces, how to get them on the screen. So I'm hoping you can see me, because I can't. But at any rate, I don't want to take too much time here. Let me get to the point. So you've heard a lot, I guess, about the technical aspects of this program and a bit on the agency services. And I don't want to be redundant, but they did a great job of describing who we are. We've been around a very long time, since the onset of the HIV/AIDS epidemic, and we've certainly morphed over the years. I certainly have morphed with the agency over the years to the point where we're now, this year, I think, $100 million budget and an operation that happens in 5 locations across 2 counties. And we've served an awful lot of people and saved an awful lot of lives over that time. So becoming a federally qualified health center was a goal of ours, and that was finally realized about 12 years ago. And we were up since then and added additional new access points, they call them. And we've been a part of the Miami Beach community, part of its fabric, for a very long time and taken care of a lot of patients. It is true when I say that we've saved lives, especially in the early days of HIV, but it continues now that we've expanded to all folks, anyone in need. And it's very important that you hear that part of it, because this program, more than anything else we've ever been eligible to have or do, or any grant we have received, helps us, enables us to serve more patients and keep people really well and live longer. It's just true. And the reason it does that is because of the reasons you heard. We are able to purchase our medications at a government rate, basically, and sell them at retail rates. And that margin was designed by the federal government to give us the latitude to take those funds and reinvest them in our patients. And that's the most serious part of this. We're not allowed to just take that money and run with it or do anything we want with it. We have to be accountable for every dollar of those savings, that money that we make, and it must serve the purpose of furthering our mission to help more people who are sick. So that's key in this equation. The Miami Beach site is unique. There are a lot of patients who have been going to the site for a long time. We merged with Dr. Canis several years back now, and it's been a wonderful thing. We've grown the office, and we are not able to fully capitalize on patients who would use our pharmacy if it was right there in front of them and it was easy for them to do. So what this proposal will do for us, by allowing us to have a small satellite there, is to essentially have more patients take the opportunity to be a part of it. When they do that, they're helping their neighbor, because then their neighbor who doesn't have access to health insurance and doesn't have access to care can be helped by us. There's basically 2 things we can do with this money. We can use it to actually take care of the patient, and I can think of a time where a female of ours had developed cancer, and we got her a full treatment of chemotherapy over many, many months with the funds received from this program. She would not have otherwise had access to that. She would not have lived. And so it's that kind of thing that this money does. It also allows us to invest in facilities like the one we have on the beach. So I can't drive the point home enough to tell you what the specific goal of these funds are and how we very much use them wisely over time. This last year, and I'll finish with this statement, I was really proud to learn that we're one of the newbie federally qualified health centers. The program's been around for over 50 years. This year, we achieved a ranking of being within the top 10% of community health centers in this country as far as quality of care. And that's measured by a lot of clinical outcomes. That's because of things like this program and the, of course, incredible staff I have. Thanks for your time.
Great. Thank you very much, Rick. Appreciate your comments. Mr. Chairman, board members, that's all we have available for your questions.
Go ahead, Tanya.
Just a quick question for your CEO. Do you have statistics on what medical outcomes are if people are able to get their medication on site directly rather than having a lag time of going to a pharmacy or some external pharmacy or supermarket to fill their prescriptions? Does it make a difference for outcomes?
It's a really good question. We know that it facilitates compliance. Whether or not the rapidity of getting them sooner versus, say even an overnight delivery is helpful, I don't know that. I actually would defer to one of my staff who's on there. Nicole, do you know anything about that being in quality management? Are we looking at that data? It's not one of our, we call them performance indicators. So it's not one of the ones that the feds track, but it may well be data we have or can use, but I'm not aware of it. But it really is a good question. We know that patients will avail. We do know that there are more percentage of patients at our other sites accessing the program because there is a pharmacy on site. That much we know. The outcome piece is I'm less certain about. It's a pretty sophisticated question you're asking as far as data requirement, but we might be able to do it, if not now in the future. Nicole?
Mike, can I ask something? So they bought this, right? They own a condo unit in this place. It's a commercial condo. So I mean, when they bought it, there was no pharmacy there, right? So I mean, just saying, what was the thinking there? Because there was no expectation at that point that they were going to have a pharmacy. They were just opened as a clinic, not as a pharmacy.
Well, I think when they purchased the unit, they purchased it for use as a pharmacy.
But we didn't realize this restriction was in place.
How long did you buy this?
I don't know, what has it been, like a couple?
2 years?
2 years, maybe 2+ years. And we honestly didn't, when we did the transaction, we just didn't know that it was prohibited in this particular area of town. I think I'm accurate in saying
Okay,
that.
so the plan at that point was to open a clinic with a pharmacy, but then what happened?
Well, I think the clinic's been there for a while, but what has happened is that Big Pharma has this erroneous interpretation of these federal regulations, and Big Pharma is telling all these healthcare centers you can no longer enter into a partnership with Walgreens and CVS to distribute these discounted medications through these partners. We believe under our interpretation you can't do it. So we're going to cut you off unless you establish your own network of pharmacies. So that's what they're doing.
And when did that happen around? I'm just trying to get a timeline, just to understand sort of what,
Yeah.
This has been recent, the last few years, what was just described to you so accurately. We are under a lot of, it's all a matter of degree, and it really is kind of a complicated program. We do have many, many contracts with CVS's and Walgreens who actually kind of keep our little pharmacies separate and distinct, if you will, from their bigger pharmacy because of the data requirements and the reporting. So it's complicated. But it's fair to say that in an effort for Big Pharma to limit the availability of these drugs to us at discounted rates, because that's not in their best profit goals, then they've made it harder. And they're saying unless you become a direct pharmacy yourself and don't contract the pharmacy out, you cannot avail yourself of this discount. So that's happening as we speak. It's evolving. There are a couple different companies that are challenging us now, won't deliver certain drugs to us. And we expect it's going to get tough. And as we shared with you, it's worth a lot of money. So the storm can happen anyway, but the better we position ourselves to have an in-house pharmacy, the better off we are. But we did intend all along to have a small satellite pharmacy in there, recognizing the benefit to patients and the maximum convenience. And we did think we could do it at the time. Patients will go to contract pharmacies to get their meds and still see us, yes, but the point is you want to maximize the volume of patients who can do this and want to do it, because there's where you make the best opportunity to help more people.
Okay, and just one other, do you have any issues with your fellow owners at the condo? Are they fighting you? Are they for this? What's going on with that?
Yes, they have threatened litigation. They believe that this pharmacy use is not permitted above the ground floor. We disagree with that, but as you all previously adopted a position with regard to the condominium building about what is a private dispute, I'd rather not go into the details of that litigation because I don't think it's fair.
I agree. Whatever that happens there is independent of what we decide here. I get that.
But what I just told you is true.
Just seeing if there's, because I'm sure, I think we should open up to the public now, and I imagine we're going to hear from some condo owners.
That could be.
Okay, we have a few hands raised. The first one is Stuart Stein.
Yes, can you hear me?
Yes.
So I have 3 different roles. I am a part-time employee of Care Resource, but uniquely, my husband and I were the former owners of the medical practice in 912 and operators of the pharmacy for over 20 years. But even more pertinent, I think, is the fact we are also owners of a suite number 901 on the 9th floor. So we have a unique interest and perspective in this. I understand my neighbors' concerns about foot traffic. I have zero concern that this will impact my investment in my business. My husband's been performing cosmetic dermatology for 20 years, and as much as I am also loyal to Care Resource, I would never be asked, nor would we ever agree to sacrifice our own financial investment and our 20 years of building a cosmetic dermatology business in the process. As someone who's operated a pharmacy for 20 years in that space, I understand that this type of pharmacy, maybe through a technicality, may be open to the public, but since I ran the previous pharmacy in 912, I can tell you that the model, and I will be overseeing for Care Resource the rollout and operation of the pharmacy. I can tell you that I have zero concern that it will generate the foot traffic because of the nature of the way we will operate it, and I will be operating it exactly in the same way that we operated it for 20 years in complete harmony with our neighbors. It's very unlikely that a person from outside our clinic would somehow find us on the 9th floor, come up to the pharmacy, come into the medical office, be screened for COVID, come to the waiting room, find out that we don't stock very many medications because we only target what our providers are prescribing and chronic care medications that we would deliver to our patients. When we operated the pharmacy previously, we delivered virtually 95% of medications via FedEx same-day courier or during a patient's visit to the office. So I just would like to say that, in summary, I really have to believe what I'm telling you because I have skin in the game. When we ran that practice, we cared for over 2,000 active patients over 23 years. And as a 25-year Miami Beach resident, caring for people of all races, ethnicities, incomes, I can personally tell you that this pharmacy matters greatly to these patients, many of whom are our former patients that value this on-site pharmacy tremendously. And I am absolutely certain that it will not be a nuisance to our neighbors. Thank you.
Can I just add one other point to this that I think is very important and needs to be said? If you also think about it, Care Resource as a business entity, and let's put our business caps on just for a minute, Care Resource as a business entity, frankly, has no interest in marketing this pharmacy to anyone outside of its own patients. Why? Because if we do not gain the 340B advantage. That only happens if they are a registered primary care patient of ours and is seen for regular care. So if you think about it, there is no interest in having people, the larger community, come to this pharmacy because it really doesn't serve the purpose we need it to be able to provide the funding to be able to see more patients. They're not eligible.
Thank you. Sir, this is open for the public right now. It's not sort of point counterpoint. You'll have an opportunity for rebuttal after. So right now this is open for the public, and we appreciate if you don't comment after each person who speaks. Thank you.
Okay, the next person is Ronald Thomas.
Hello, can I be heard?
Yes, we can hear you.
Yes.
Okay, thank you. Yeah, my name is Ronald Thomas, and I'm the managing member for Aspen Partners, which is Unit 914, immediately across from Care Resource. And we're together with Stuart, whom I've known for many years, we're a long-term owner. We bought into the condo building back in 2006 under the premise that it was professional offices. Now, for all the years that Stuart ran the operation, frankly, we had no issues no issues whatsoever. Since Care Resource has been there, our concern is that there's been several instances that we've struggled with, obviously worst off even during COVID, where people were just lining up, queuing in the hallways. It seemed a little bit, disregard for other people's health. There's been instances where obviously they don't have sufficient bathroom, and the medical crew in there would have everybody walk to the public restrooms on the 9th floor. And we've had instances where they're walking down the corridors with their urine cup samples. They go into the bathroom, they leave their urine samples on the countertop. There's been 2 instances in which, because they were defecating outside the toilets, the bathrooms had to be shut down and totally sanitized. So what I struggle with is that under Stewart, they operated and they continue to have the ability to be a doctor's dispensary, which allows them to provide medication to their clients. So it begs the question, if the goal is to increase volume, and we're already having these issues now, what can I, as the offices across the hallway, expect when I already have, because we sublet our offices to tenants, and I have my tenants already complaining, if this is going to go on, I'm going to look elsewhere. So it begs the question, who's going to take care of Aspen when we have problems maintaining our tenants because of what's going on across the hallway? And I would just like for them to be able to address that in terms of property value.
Thank you, Mr. Thomas.
Thank you.
Paul Thomas? Alex Wendell? Alex Wendell?
Yes, can you hear me?
We can hear you.
Perfect. I have a different concern, and I know that Andy's got some concerns upstairs, which I can't share with him because they're not my neighbors, so I can't really speak to that. My concern with the ordinance is that I know that you want to be restricted with the ordinance to decrease the possibility of cannabis distribution in the building, which I think is great. But I think that also, because you're not allowing any other pharmacy stores to be located within 600 feet, you're really giving a monopoly to this company for no reason. It's not fair to the rest of us who have real estate rights as well to have our units purchased or rented by companies who also may have opened a pharmacy. And so I'd like to just have you guys know there's a couple of facts, because this is not an insignificant matter. If you look at the 990s filed by this organization from 2019, they had $75 million of sales, pharmacy sales, on their tax returns. And of that, about $50 million in pharmacy costs. And that was divided over about, I believe, 5 pharmacies. I could be wrong about the exact number. But they're making like $5 million per pharmacy per year. So I appreciate the concerns that other people have about the use and the neighborhood part of it. But I think for the city to give a monopoly to one company through a foot distance restriction from one pharmacy to another restricts the rest of us from also being able to benefit from having pharmacies in our locations.
Thank you, Mr. Wendell.
Okay, and then we have Paul Thomas.
Hello, can everyone hear me?
Yes, we can. Thank you.
Hi, good afternoon, everyone. I just wanted to weigh in as a South Beach resident in favor of the pharmacy, and also as someone who has worked in healthcare for a very long time and with these pharmacies at different locations. And just to allow the board to try to understand how important it is for a patient to be able to leave their doctor's office and walk into the pharmacy right next door, and what a difference that makes in care. what a difference that makes in the understanding of what's going on. To this very day, I get calls every day from patients who say, I took my prescription and I walked into the CVS store, I walked into them, they gave me medications that I left, and I don't understand even what I'm taking. The idea that Care Resource, having all these patients, would also be able to allow their patients to get the best outcomes in their care by walking next door, talking to a pharmacist who understands, especially HIV, which is very different than the average pharmacist. Most pharmacists don't know about the HIV programs. They don't understand the 340B program. They don't understand all the different ways that patients are able to obtain very expensive medication for little or zero cost. So they call me and they say, I'm not taking my medication because they wanted $800 a month. And it's only because they weren't going to a 340B pharmacy associated with their provider that they were just not going to take their HIV medication and get very sick, right? And then I have to redirect them to a pharmacy like Care Resource would have so that they could get the proper care and the proper instruction. I think that for a provider to be in this location for this long and be such a benefit to the community and to be stopped from giving the patients the best care that they could ever get is just really not fair to the community. I send lots of my elderly neighbors to Care Resource for care. They need to be able to walk next door and talk to somebody who's connected to their doctor. They cannot wander around South Beach with their canes and their walkers and not understand what they're taking and why. For me, that impact on the community and that benefit alone outweighs any other discussion because we're talking about people's lives at that level. And so I just wanted to weigh in and speak on behalf of Care Resource being able to have this pharmacy, which is so important for all the patients at that location. Thank you very much.
Thank you, Mr. Thomas.
We have no other hands raised.
You want to?
Sure, just 2 minutes, Mr. Chairman, between me and Rick Siclari. I'll, of course, keep his comments very brief as well. But with regard to Mr. Thomas's concern about spacing the hallway, again, that's addressed by the legislation. But more importantly, the origin of that was during the height of COVID, when the number of patients had to observe the social distancing requirements. It did, at times, have people out into the hallway, but that time has passed. The vaccination rates have risen dramatically, and that no longer occurs. The bathroom issue, I don't want to really get into. Collectively, the comments by them are really going to be a private dispute, and that will be resolved either by litigation or through arbitration as provided for in the Declaration Condominium. Other than that, I don't want to say anything about that. Alex Wendell's concern is unique. There's always a spacing requirement between pharmacies. Usually it's 1,200 feet. We reduced it to 600 feet because we didn't want to go through this whole process and then have to seek a variance from the Board of Adjustment because there is another pharmacy at the Walgreens just on Alton Road north of Dade Boulevard. So we thought that would be really a bit too much, so we did reduce it from 1,200 to 600. But other than that, there's always going to be a spacing requirement between pharmacies, and there's nothing we can do about that. And that's all, Mr. Chairman. I don't know if, Rick, you have any brief comments you'd like to make to the board? Okay. I think that's
Okay, with that, we'll close it to the public and we'll bring it to the board. So, Nick, just as disclosure, I represented the original developer of that building. I converted that building. So I did those documents 20-something years ago. I don't know if that impacts.
Is the developer the association? Well, not the developer anymore, but is the association?
I don't even recall who the developer is anymore.
Okay, if you don't represent the association, which is the successor to the developer, then I don't see a conflict.
Okay, thank you.
I'm sorry, this is Rick Siclari. I was muted before. I just wanted to respond to the gentleman who was concerned about the increasing volume and remind him that the principal focus of this pharmacy is going to be our current existing patients. It's not about increasing the volume of the pharmacy for the community overall, just for the reasons we described.
Great. Thank you.
Thank you. Okay, we're closed and So the board want to start it off here?
Yeah, I just have a few questions.
Sure.
So I noticed that the distance requirement is 600 feet from another, I guess, similar use. But the district that it's in is a very small district. Where does the 600 feet number come from?
600 feet was just something we proffered. It basically is the boundaries of our district. Like, it's usually 1,200 feet between pharmacies. If we kept it at 1,200 feet, then that would probably encompass the Walgreens on Alton, just north of Dade Boulevard, and we'd have to seek a variance. And we'd prefer not to go down that road.
Okay, so by keeping it at 600 feet, in essence, is keeping it within that box of that specific sub-district?
Correct.
Okay. Is this location providing services for homeless individuals? Is that something that you could address?
I don't know the answer to that, but is Rick still on the phone?
Yes. To the extent that, am I unmuted? I think, can you hear me? Yes. To the extent that we have a number of patients, many who are homeless, it certainly does help them and serve them. As long as they're part of our Medicare program, they're eligible for this program.
And whether we approve this ordinance or not, you still would be, I would assume, treating these individuals.
Yes. Of course. No, that will have nothing to do with it. And they'll still be able to get medications. I want to be clear. It just will not have that convenience and ease that we described to you here.
Is Care Resources part of the Ryan White program?
Yes, we receive significant funding across 2 counties.
Okay, and I don't think there's many organizations here in Miami Beach that are part of the Ryan White program. Maybe there's just one other. And I underscore that just because it's so important to, when the AIDS epidemic started 40 years ago, the work that Care Resources has been doing ever since. And, yesterday happened to be National Gay Men's HIV/AIDS Awareness Day in our country, and it's important to recognize the challenges that people who live with HIV and AIDS go through, and the importance of providing them with medications for their debilitating conditions when they get at that point. I'm usually, I have concerns with ordinances like this, but I think Care Resources has a very well-established record of service in our community with a very clearly defined mission of providing very important support to a very, very vulnerable segment of our population that's underprivileged. And, I would be going against some very deep core values if I would oppose this legislation, because I do believe that we have to be compassionate and do whatever we can to provide this medication. And again, the change here is the change in the federal requirement. That the federal requirement now, in order for them to continue doing this, is that they have this pharmacy established. And I just want to get confirmation that is what is bringing us here today, is that change in the federal requirement. Is that correct?
That's what we understand, yes, from the applicant, yes.
Okay. With that clarification, I will be supporting this ordinance.
Go ahead, Don, yes, sorry.
I have just a couple of questions for clarification. Michael, I'm not sure if you're the right person or if Mrs. Ciclari is, but my understanding from one of the people who called in is that there had been a pharmacy operating in that space prior?
Correct. Yes.
And for how long and until how recently?
I think for a number of years. It operated in conjunction with the cosmetic dermatology practice between Stuart Stein and his husband, Albert Canis. That's how the pharmacy operated. I'm not sure how many years, but it ceased operation, and so couldn't really be considered a legal nonconforming use because it stopped operation, for over 6 months, and then your vested status expires at that point in time. I don't know if that's what you were leading to that question.
No, not to the continuation, but to understand that there has already been this use in this space.
Correct.
Maybe not literally in that particular unit, but in that building.
Yes.
That was
Yes.
not a problem. So it seems like
Yes.
the concerns are that the ways in which the spaces have been used in the last couple of years under wildly unexpected conditions has been suboptimal. And I can understand and empathize with the unit owners that nobody wants to deal with that. And I understand that there were extenuating circumstances, but maybe protocols could be put into place by the operators to mitigate this type of situation, because who knows if we're going to find ourselves in yet another pandemic in a couple of years. I hope not, for myriad reasons, but maybe that's something that can be articulated ahead of time.
Yes.
And is there a prohibition of adding additional bathrooms to what they're trying to do? I mean, I know, I'm sure it adds expense, but if this is one of the sticking points, then maybe this is something that should be.
I don't want to speak for Rick. I hear him. Is it okay if Rick
May I
responds to that
speak?
question? Go ahead, Rick.
We've actually been in communication with the board of the building about many possibilities that we could pursue in order to facilitate making some solutions happen, such as a part-time housekeeping person that we would fund for the building in our area, not just in our office, but out in the area that's been of some concern. The truth of the matter is we have a patient mix of folks that have mental health illnesses and other things. We are a complicated agency, and it is a little different than the practice that was in there prior. So I understand these needs, and I really do understand the concern. And we have also considered facilities enhancement. It's a great idea you suggest specifically about the bathrooms. That one hadn't come to mind, but I know we put offers on the table, and we remain committed to continuing that conversation.
Okay, so that's already a dialogue that exists.
Yes.
It is technically feasible for somebody who is not a patient at the clinic to find him or herself, prescription in hand, wandering upstairs to an unmarked location to get the prescription filled. I mean, technically that could happen.
Yes.
Yes.
But that's not going to drive traffic. I mean, that's
We won't advertise if it appears on a Yelp map. There's nothing we can do. But again, there's no guarantee we would have those medications there to fill.
And then I guess this is for the staff. My understanding, my reading of this is that this is specific to any already existing building. But if Baptist wanted to come in to a new space and build this kind of pharmacy, it would be a different set of considerations. So this is really for this particular space, this organization, and this location.
Correct.
Not really. It's really for an area, because this is legislation for an area, not a specific building.
Right, but it's the small envelope.
Yeah,
right?
I mean, I don't know what else could be.
Yes.
What else could be?
But if somebody were building something new, it would be a whole different conversation.
The ordinance says that it has to be in an existing building
Within
as of
that
the
envelope.
date of the adoption of the ordinance. So if the building was not built prior to the adoption of this ordinance, they could not go in that building.
Correct.
And given the shape and the size, I guess, not so much the shape, but the size of the envelope in which this finds itself, is there a possibility for another such pharmacy to exist, given the 600-foot? Okay, so it's effectively addressing this one particular opportunity in this one particular building in this one particular zone.
Correct.
So from a staff perspective, how does this translate? I'm always very cautious about the tip of the spear kind of issues. So how would this then potentially be used in a different situation in a different part of the city?
Well, if we were going to add this to another part of the city, we'd have to have another ordinance, and we'd have specific regulations for that part of the city.
So nobody could come in and say, you did this here, let's extrapolate it to some other place automatically. You would have to go through the same
It would have to come back to the city referral to the city commission for an ordinance, and it'd come back here and then back to the city commission.
They'll hire Michael to do that again. That's a lot.
Michael's like, yes, let's get it going.
But if our colleague yields, if you don't mind, I want to ask, just for clarity, my peace of mind. Right abutting it, I'm noticing there's geo-zoned property.
Mm-hmm.
And when GU zoned property, if there's ever any change of ownership or anything like that, doesn't that GU zoned property then adopt the designation of the abutting property?
It would adopt the CD3 designation if it were to not be part of the GU, if it were to be sold. However, this district boundary would not extend to that.
It would not extend to.
That only applies to the underlying zoning.
Okay, so even if that area stops being GU, these regulations for the pharmacy would only stay within this small envelope.
Correct.
And if then it'll only still be one.
Correct.
Okay.
Right, that's what we're always worried about, is that the unintended consequences
Right.
of what we do. All of a sudden, there's 7 pharmacies here that, we really were trying to target it, really, for this specific business, but all of a sudden, there's quite a few others.
No, and it's a very valid concern. I mean, we see it happen all the time where people
It has
say,
happened, absolutely.
yeah, well, you did it here, so we can buy a right, go do it someplace else. So we definitely want to avoid that. But you promise that's not going to happen.
So if you look at the ordinance, there's areas where they're allowed, and those are the only places where they can go.
A quick question, Riley. Did we have these? We didn't have these pharmacy zones previous to the medical marijuana issue, right?
Correct. They were just treated as a commercial use, and any commercial district, they could go into those commercial districts.
So there's no distance requirement or anything like that?
Nope.
Almost any pharmacy you go to now is a legal non-conforming use.
Right.
You sound like a big zoning nerd, but yes, it's true.
Yeah.
To Nick's point, if a medical marijuana dispensary said, oh, that's a really good idea, I want to do that in that same zone as well, and have all the same, stipulations applied to me, they couldn't, though, because they would be considered effectively another pharmacy in that 600.
No, that's one of the issues here, that a medical cannabis dispensary could also locate in this area. So the distance separation only applies pharmacies to pharmacies, dispensary to dispensary.
But there's also a distance separation between dispensaries and schools. And as I was remarking in my presentation, Lincoln Marti is just the northeast of here within 500 feet.
So it's precluded from...
Right, you have to get a variance.
You have another you have another piece of regulation that impacts that.
That's the only difference between pharmacies and dispensaries, is because state law also has that 500-foot separation from schools for for dispensaries. That state law does not apply to the pharmacies. All the laws that we adopt have to be consistent for both. However, the state has an extra regulation that only applies to the dispensaries.
One last question, if you don't mind.
Go ahead.
What happens if a dispensary comes and wants to buy out their lease? They see a market opportunity.
Buy out their lease, they could.
But they still would have to
But
come
they're
to us.
still
They're still within 500
Well, the
feet
500
of the
feet
school.
would apply.
It's a fundamentally different use.
The only issue I see there, that just for transfer, I think that's a daycare center. I don't think it's a full school, the Lincoln Marti, if I'm not mistaken.
But I think the way that the Florida legislature defines school is inclusive of daycare centers.
Daycares? Okay. Okay. So we'd have to confirm that, but I think that's the case.
Okay. So in which case the dispensary wouldn't be able to.
But it's also I mean, it's right accessory to a medical office, right? So.
Right.
I mean,
Okay,
I don't
you're
think
right.
that. Yeah, I mean, so if it's just a weed store, unless they have doctors next door that are, that they're somehow connected, it doesn't comply with this.
Yeah.
Right. Okay.
Yeah, it has a lot in there to make it where it's really got to be an accessory to a health care.
Very
facility.
tailored to the specific need.
But not spot zoning.
No.
Nope.
Not a rezoning. I'm a purist when it comes to that.
Anything else?
I
I think we're closed right
Rick, it's
now for the
okay.
public, sir. So,
Okay.
I would move it forward with a favorable recommendation, if it's time to do that.
Okay, we have a.
I'll second it.
Okay, we have a second.
Motion by Mr. Jelpy, second by Ms. Bott. Roll call, Ms. Bott.
Yep.
Ms. DiPietro.
Yes.
Mr. Fernandez.
Yes.
Mr. Jelpy.
Yes.
Mr. Milan.
Yes.
Motion passes.
Great. Thank you all
Good
very
luck.
much for your time.
Good luck.
Thank you all. Appreciate it very much.
Thank you.
Thank you, guys.
Okay, we got one more piece of legislation here. It's, I'm sorry, two more pieces of legislation here, yeah. So we have item 13 on our agenda, PB 210458, solar panel encroachment.
Okay. So this is a fairly simple ordinance, PB 21-0458. What this ordinance does is it takes existing allowable encroachments that exist in the land development regulations. So today we have our side yard setbacks for single-family districts. Certain things are allowed to encroach into that, and those include air conditioners are the main thing, but it also includes emergency generators, swimming pool equipment, things like that, which go on the side of the house and are allowed to encroach into that setback. What this ordinance does is it simply allows for solar panels and home battery systems as to that list of things that are allowed to encroach into the setback. They are not allowed to be closer than 5 feet to the lot line or 10 feet in a lot facing a street. They are not allowed to exceed 5 feet above the current flood elevation or the maximum height of 10 feet above grade. They cannot be visible from the right-of-way, and landscaping or physical screening is required. And it's required to comply with any other sound buffering requirements. So it's a simple ordinance. It simply just allows for solar panels and backup batteries to be as part of the allowable encroachments. It's consistent with the existing regulations that are allowed for existing mechanical equipment. So with that, staff recommends that the planning board transmit the amendment to the City Commission with a favorable recommendation.
Okay, is there anyone from the public on this one?
We have no hands raised.
Okay, with that, we'll close the public hearing. Does anyone want to? I think
Yeah,
you're a resident architect, so
I just have a
go
few
at
questions.
it.
I have a few questions. My home, for instance, was built in 1960, so currently it has non-conforming side setbacks. I only have 5 feet on my side.
Mm-hmm.
Is there any exception allowed if you have like a legally non-conforming home with only a 5-foot side yard? Would you still be allowed to place it there?
I believe you would need a variance the way this is worded.
I'm sorry?
You would need a variance the way this is worded.
That's interesting, because I kind of would be in favor of, if his electrical, I mean, if his equipment is there.
My air conditioning is there.
Right, but and it's there because it was good as a grandfathered in situation. Why shouldn't he be able to put these other items there too?
I think, I mean, I understand if you're extending the non-conforming addition, adding on to the building envelope, I think the variance is merited. But if it's if this is intended to sort of ease and expedite the introduction and adaptation of solar, can we carve out a provision? Can it be like a staff level thing? Something that doesn't require just a simple variance, just for that equipment itself.
Are you saying for homes with a, let's say, non-conforming
side
encroachment,
a legal non-conforming,
legally
situation,
non-conforming configuration,
that this equipment could follow that same non-conforming? Could we frame it that way?
I think so.
Okay.
We should add that.
I guess the only issue
We
there
have,
is, the only issue there is, does it have to be within the same footprint there? Because, you could also take advantage of that too.
We could say it has to follow the same line. So if your air conditioner encroaches 2 feet, the solar panel can also encroach 2 feet. Something to that effect. We have similar language for homes that have non-conforming setbacks. If you're doing an addition, that it can follow the existing non-conforming line. So that's something.
The spirit of this, right, is to allow solar panels and battery systems in these areas, right? And so I think, consistent with that philosophy would be to allow that to work in legal non-conforming areas.
Yeah, and the battery systems, those need to be am I mistaken? Don't they need to be on the interior of a garage or something? They're not outside the envelope, are they?
I've seen some images of Tesla's battery backup systems that go on the side of the house. They're not on the inside. So I've seen some images of some. I've never personally worked with one, but.
Okay, and the only other building component here is a solar carport. So that is only a carport with solar panels on it. Is that correct?
Yes, I don't believe we touched that section of the code in this amendment. We authorized those. I want to say it's been about 2 years since we authorized
Oh, yeah,
those.
that was in background in 2019. Okay. And do we anticipate anything in terms of a height exception? We're only anticipating height exceptions above grade. Is there any provision if you want to put this? Is it an allowable height exception if your home is maxed out? You can still add.
Yes, it's an allowable height exception for the roof. So this was in the case we had somebody that wanted to have some movable solar panels that they wanted to be able to put in the side of the house, and so this basically is. We didn't see anything wrong with it. It wasn't going to impact the neighbors. The neighbors wouldn't even see it, so we didn't see any issues with it. And it doesn't make noise. It's a solar panel, so we didn't have any concerns.
I honestly can't. I mean, I'm fine with that. I can't imagine anyone's going to do that, though. I would hope they would at least make a carport or something, so it's not a big rack of things sitting on the side of that. But no matter. Yeah, I think that makes sense.
I mean, what's the difference though between that and like AC equipment? None of it's really beautiful, right? I mean,
In Boulder, for instance, I'm doing a project where they require solar to offset all of your energy, and they're just these massive racks of panels. But you have much larger lots, and it's sort of easier to fit them on the site. Anyway, and I just added solar to my home, and we added 50 panels. It's a lot of coverage.
where'd you put it?
On the roof. Yeah. That's why I can't imagine people would be putting these in the yard. You would just lose yard space, but maybe they do. Maybe they want to.
Anyone else have anything?
I would move it with a favorable recommendation.
With the carve
With that caveat that, that if we could continue, the existing, how should we word it? I guess if there's mechanical equipment within a non-conforming setback, we would allow that to be added onto.
That this new equipment identified in this ordinance could follow the non-conforming encroachment.
Nick, can I say something? So if you have a legal non-conforming area, right, and you get a different system, you have to fall within exactly that area, or you can actually add on, like, alongside the house?
Like if you had AC equipment within a required yard, could you? I think, Rogelio, you could replace. I don't know that it has to be. Does it have to be exactly the same footprint if you were replacing, say, an AC unit that was?
The reason I'm asking, I'm sorry to interrupt. The reason I'm asking is that, what he said about, you don't want also someone to say, I'm now going to put my house is 40 feet deep, right? Mm-hmm. And now I'm going to have 40 feet of solar on the side of my house that's sticking out into an area that's not supposed to have it. You know what I'm saying? Because that could possibly happen in a situation, and I don't think that's what we really want. I don't think what we want is that if.
Well, it still needs to. These are things that can't be visible from the right of way. So you're not. If they do, let's say you have. The house goes back 20 feet, and you want to line that whole side yard with a 20-foot solar panel, encroaching 5 feet. You're not going to see it from the front. It has to be covered with a fence or something to prevent you from seeing.
So I guess, are we okay with that as a board?
Question.
That's what we're going to allow here. So some.
I really don't think it will ever happen.
Person may, but some person doesn't. We never think it does, and it ends up happening. So, someone may end up having someone that a 40-foot long solar field that's going into.
The thing is, they really need good exposure. That shouldn't be blocked. So they really need to be on the roof. Mm-hmm. I just can't imagine anyone would have the side yard.
With the shade of the next door neighbors.
Exactly, it's not going to work.
Yeah. But I kind of agree. It should be something that should not be visible from the street.
Yeah.
That's a regulation. Like your air conditioner can't be visible from the street. So
right.
I'm willing to take the risk on it. By sending it favorably to the commission.
So. Or would thank you because I made the motion. But should we take out racks as one of the elements here? just provide for them on rooftops. I mean, again, I don't think anyone would ever do that. But I don't know. Do you want to consider that? Rogelio, do you think that makes sense? I mean, I don't want to undo anything you
I mean,
were-
I just think the technology is changing so much. I don't want to be so precise and then
All right.
And then we prohibit something that's.
Yeah, maybe there's a little tiny.
Yeah.
Little
they
micro
figure
solar
out
panel.
exactly.
The good thing about this is that we could always come back and
Exactly.
Yeah.
I mean, this was how long? How old is this legislation?
The
2 years?
Well, we added the carport about 2 years ago.
Yeah, but so I'm saying these are things that are living, breathing things.
We
You
haven't
know,
had-
if technology
I think
changes, we
maybe
should
one
be,
has come in.
bold enough to roll with the technology.
We can adapt it in the future.
Right.
As things of that.
Yeah, I mean, one of my notes when I was reviewing this was, the waiving of the public hearing fees for installation of roofing, sustainable roofing system, solar carport, porous pavement, or cool pavement. That's all great, but who in the city knows that that's a thing?
Yeah.
So, which I would encourage you to take back to your crew and say, guess what? You should tell people about this. But
Well, I imagine the architects and installers, people in that business, I bet really know that.
I hope
You're going to
so.
sell
I
that
mean-
stuff, you're going to tell people, you don't have to pay.
No,
these
but I
fees.
mean, for homeowners who are doing renovations who don't know that this is a thing, they wouldn't necessarily say, I'd like porous pavement options when I redo my driveway, right? So anyhow, that's neither here nor there.
Well,
but,
that we make them either do light colored or porous. That's part
okay,
of
so
our.
bad example.
They know that.
Okay.
Yeah, for driveways.
They hate me for that.
Yeah.
Okay, so
I think we need a second.
We need a second?
I think-
I'll second it.
Great. Thank you.
Okay, so a motion by Nick.
So
Shelby.
understand it's the legislation, but as modified to reflect for legal non-conforming situations.
Side setbacks. Yep.
Great.
Okay. Ms. Bott,
yes.
Ms. DiPietro,
Yes.
Mr. Fernandez,
Yes.
Mr. Jelpi,
Yes.
Mr. Milan.
Yes.
Motion passes.
Okay, now we're on to item number 14, PB 210462, Water Supply Plan and Property Rights Comprehensive Plan.
Okay, so this is a comp plan amendment with two components. Both are state mandated. One is the first one is the water supply plan. And we have our public works, our city engineer is with us, should there be any questions on this. And so the water supply plan is mandated by Florida statute to be updated. We currently have one adopted in the comprehensive plan, and now it's the time to do the update. Essentially mirrors a lot of what is in Miami-Dade County's water supply plan and what is mandated by the South Florida Water Management District. As Miami-Dade County is our water supplier, so we have to basically do what they say. And I don't know if you want to add anything to the.
I think that was perfect.
So basically, it shows the water supply plan that we do have enough water to serve our needs for the next, I think, 10 years. So we're okay in that regard. The process for this, once this is adopted, once this goes to first reading for City Commission, we would send it to several state review agencies, including the Water Management District in Miami-Dade County, and they would submit any comments. Though we have submitted it to them for a preliminary review, and they are comfortable with what's in the water supply plan and in the water supply plan facilities work plan. Just to clarify, this relates specifically to water supply, not our water distribution network, not the pipes. This is the actual physical water that the water exists to serve our needs.
Do we have to do this every 10 years?
Yes. Yeah.
So 10 years ago, this planning board, it came before this planning board, and they just passed the, whatever, the.
If you want, I can speak to that. What
Yeah.
it is?
Yeah, sorry.
Yeah, sure. So, for the record, Nelson Perez Jacome, city engineer. What it is that part of the consumptive use permit that Miami-Dade County has requires you to do a 10-year water supply plan to ensure that you have the water to serve your needs, as Rogelio pointed out. We have to do it as a flow-down provision because we're volume water customers of Miami-Dade County. We don't have any source water wells, and we don't have our own consumptive use permit. But
So what happens when you didn't do it?
we would be violating
So
state
we
statutes.
cut off?
Yeah, if you own a water distribution system, you have to do a water supply plan, and it's just simply a mirror of Miami-Dade County's, essentially because of the fact that we're the volume customer of Miami-Dade County.
So that's the water supply plan. Then the next component of this is the property rights element. This was approved by the state legislature this year, and then they mandated that local governments adopt a property rights element, and they gave a time frame that as of the time of your next comp plan amendment update, you have to adopt this. So as we're doing the water supply plan, we were obligated to incorporate the property rights element into this comp plan amendment as well. And simply says that the city will respect judicially acknowledged and constitutionally protected private property rights. And this language was extracted specifically from the statute and inserted here word for word. There's really not much creativity allowed in this. We had to basically copy exactly what they said. So it has 4 components: that the city will consider property rights in local decision making, and that includes the right of the property owner to physically possess and control his or her interests in the property, including easements, leases, or mineral rights. 2, the right of a property owner to use, maintain, develop, and improve his or her property for personal use or for the use of any other person, subject to state law and local ordinances. 3, the right of a property owner to privacy and to exclude others from the property to protect the owner's possessions and property. And 4, the right of a property owner to dispose of his or her property through the sale or gift. So really, that's something that's mandated by the state that we've incorporated. So with that, planning staff recommends that the planning board transmit this ordinance to the city commission with a favorable recommendation.
I mean, there's really nothing we can necessarily change here, right? Because this is mandated either by the state or by the county, right? So we're just doing what they're telling us to do in order to maintain our relationships, our water relationships.
Just a question.
Yes.
Okay.
Was that a question?
No, it's not. It's a statement. I mean, you know, it's like, what else are we going to do, right? I mean,
the plan is fairly innocuous. All municipalities that have their own water distribution system in Miami-Dade County does it, as well as the county itself has a water supply plan.
And is it all going to, like, if Coral Gables, if they had the same situation, maybe it's a bad, but let's say another town that has it.
Right.
Okay?
Coral Gables actually has its own sewage system.
Does theirs look exactly the same?
It'll look largely similar. It depends on the municipality. For example, Hialeah is a volume water customer of Miami-Dade County, but they also have a 50% share agreement with the new reverse osmosis plant that they built. So their water supply plan would be a little bit more complex than ours. Ours is probably the lightest version of one that you would find, just because our plan basically says, hey, we talk to the county, and the county agrees to keep giving us water.
Isn't Hialeah like water in from the city and water out, or out in
Hialeah
county?
is both a volume water and a volume sewer customer, but they're unique in the sense that they have their own water treatment plant as well. When they annexed the area, like in the northwestern corner of Hialeah, they had to build that reverse osmosis plant.
Yeah.
So, for example, Homestead is a similar scenario, and other cities like, trying to think of another city that has its own water system besides Miami Beach.
North Miami Beach. North Miami or North Miami Beach has
but
their
they
own
have
water
their own
system.
plants.
Yeah, they have their own plants.
So,
yeah.
Honestly, we might be the only city in Miami-Dade County that's just has is purely a volume water customer from Miami-Dade County. All these other cities are also volume water customers, but they also have their own plants, and they supplement their plants with Miami-Dade water.
Well, you don't
That's
have
why
a lot
my
of room
water
here.
bill is so high.
Huh?
That's why my water bill is so high.
Start digging some wells.
South Florida has one of the nation's cheapest water rates. So,
do we?
Yes, absolutely.
But rate increases are always interesting.
In Massachusetts, where I am, it's free because I have a well.
There you go. Just a question, Mr. Chairman. When I ask because I noticed that in the population projections, which obviously are very important when we're talking about water consumption, we're seeing the steady rise when you look at our resident population, but also our daytime population, which is ultimately what we have to look at when we're considering infrastructure. And we see that, 2020, the total population is 158,000. We take into consideration residents, employees, guests, etc. By 2045 is 211,000. My question is, what efforts are we doing for water conservation and reuse? What are we doing to advance in that so that we lessen the demand on the groundwater and the other infrastructure, because we know that the more water we consume, then the easier that it is for saltwater intrusion and other issues into our bedrock. So just wondering, what are we doing on that front of water conservation and reuse?
Well, there's a few parts to that question. I guess tackling the last part first. We don't have source water wells in Miami Beach. All of our water, since we purchased it from Miami-Dade County, the majority of it comes from the Preston Hialeah plant, and their wells are way out west. We probably get a little bit from Alexander Orr that's on 87th Avenue that's still fairly out west as well. So we're not pulling them out and creating saltwater intrusion.
They are on our behalf.
They are on our behalf, right? I would argue the saltwater intrusion is probably more an effect of rising tides and rising sea levels, putting an additional head on the thing. But in terms of water conservation, we do have a water conservation program. It's led by our Director of Environment and Sustainability, and we not only do we encourage water conservation through a progressive fee structure, right? So depending on how much water you use, it's how much you pay. But there are informational materials made available to the residents as well.
And for reuse, we do anything on the reuse front?
We do not have reuse right now in Miami Beach. There is an ocean outfall legislation program that's being put in place by the county that does have a reuse mandate for Miami-Dade County. But reuse in Miami Beach right now is it's not really the most cost-effective means of water conservation. We just don't have the big clients that would purchase the reuse water.
Thank you.
To that question, I would add that our land development regulations require that any building over 7,000 square feet be LEED Gold certified, or else they have to pay a very significant fee. And a big component of LEED is water conservation. And so they you get points if you include different sorts of things to reuse water if possible on site, to be able to use rainwater for irrigation, storage of rainwater and things like that. You get points for it, so it's not mandated. It's basically like a menu. You pick and choose what you want to do, but water conservation is a big part of that. So we are encouraging water conservation in that way.
Wonderful. Thank you.
To Alex's point, I think Miami Beach could have more communication with the county, not just on the water we consume, but our wastewater infrastructure does not keep up with population growth, not just in Miami Beach, but I think countywide. We are one of the only counties in the country that are still in violation of the Clean Water Act and have been since the 70s when the Clean Water Act was made. So I think these conversations are super important, and I wish we could incorporate them more here on the planning board. But
we are in a consent decree federal mandate for improvement on those.
We definitely, from Miami Beach and the county, need.
So if I may clarify, the county is in a consent decree. We have flow-down provisions, but we are not currently in a consent decree.
The county is.
Yeah.
But to your point, we did account for population growth in our latest water sewer master plans that go out to 2045. So we're making sure that the capital plan that falls out from those master plans over the course of the next 25 years properly accounts for capacity.
Hopefully.
I have a couple of questions, and I don't know nearly as much about all this as Asa does, so forgive me. But when I was going through this, it was a lot of knowledge to absorb. Can you just explain what the decrease in water consumption is attributable to? How much of it is people drinking every single sip of water out of plastic bottles, for instance? Sorry, Alex.
Well, really, the biggest factor that's created a decrease in water consumption over the past few decades has been more efficient appliances. It's not so much drinking out of plastic bottled waters, but it's really the more efficient appliances that are decreasing.
So it's not like, everyone decides they're going to go green and that trend will reverse itself.
I'm sorry?
There's no risk that everyone decides to go green and that trend will reverse itself and all of a sudden you'll be drinking more of the tap water that you use in your refillable glass.
I don't know that there's any way that the amount of, I wouldn't be predisposed to think that the amount of water we consume from a drinking perspective would be able to outweigh the amount of water that we use, for example, in our appliances, in our showers, and things of that nature.
Okay.
That's the big bulk.
Okay.
Miami Beach does have a fair amount of water that's used in irrigation, though. I would caveat it with that.
Right, I keep forgetting about that. And then in the charts where you have budget items, the fact that there's nothing budgeted for sewer line repairs, which is a recurring issue in Miami Beach, going forward is because the capital budget hasn't been approved yet? Is that?
No, so if you're referring to the water supply plan, that's the item being discussed, that's specifically for potable water. I'd be happy to share with the board our capital plan that includes water and wastewater.
Okay. So that's not a part of this conversation? Yeah,
it's just not applicable to that specific
yeah, because I just kept saying leak detection, repair of water lines, so I didn't know
right.
if that included sewer or not, because obviously we have some super highly publicized and ongoing issues with sewer leaks that have not yet been resolved, going on 2 years.
What we've done is we've prepared and had it adopted by Commission $122.3 million, what we call the 5-year critical needs capital plan for the water and sewer infrastructure. And that encompasses both the water and the sewer side.
So both drinking water and
sewage as well.
Okay.
The pump stations and the force mains.
Would you mind emailing me that at your convenience sometime in the next few days?
Absolutely. I don't know if I could pass it through.
Yeah, you can send it to me and I'll forward it to them.
Absolutely.
Thank you. I appreciate it.
I think we'd all like to see it. Because I think to date it really feels like an emergency. We blew a pipe, now we're going to get the funds instead of forward looking at.
No, exactly. I mean, I know this
the increased density. This pipe's probably going to blow. Let's just put funds there before we build a new tower.
That's exactly right. And I know it's not specific to this particular item in front of it, but it raised all these issues because we're talking about putting an Olympic-sized pool at Town Center in North Beach, which seems to be begging to cause issues. We've got unresolved water issues around Parkview Island. We've got the Venetian Causeway had a pipe burst last week, I think it was. Like, there's all this stuff going on, and it feels like we're playing whack-a-mole. And we, as a city, keep approving new development and micro units and adding to our density without addressing, no pun intended, the underlying issue of pipes that are, on their last legs. So maybe we could even add that as a discussion item for either October or November to talk about that plan and how it impacts a lot of what we do here.
Sure, absolutely.
I think one of the biggest challenges is you can't see the pipes, but if we could have someone from Public Works here who's most familiar with where the pipes are and what the diameters are and when the last time they've been upgraded is, I think that helps.
It's scary what they
I don't know if the city has a record of that, but that's essentially what we really need to be looking at.
Well, we have a
We'll see how the sausage is made, do we?
No, but I think it's critical. I mean, I lived in a 1924 house for 13 years, and one of the original pipes, they were mostly original pipes, and it corroded completely, which we didn't know until we found out the hard way. And so I know
it happened to me recently. My house is a 1939 house.
Yeah, and now I live in a 1956 house, and it's got the original iron pipes, and they're in decent shape. But I've had them snaked, or not snaked, but I've put a camera through them a few times because of issues. And so, if that's just one residence, not very densely populated residence, I can't even imagine how the rest of our pipes as a city are going to withstand what's coming next.
And one other point I just want to put on the record: a few months ago, Board Member DiPietro convinced me to vote on the ordinance for office on Alton Road, which disincentivized hotel uses. And when you look at the information that they give us, hotel uses use 75 gallons per day per room, and office uses use 0.084 gallons per day per square foot. And
you don't take showers at an office.
You don't take showers at an office, so there you go. Yeah. So just wanted to put that out there for the record. But with water consumption, one of the things that perhaps the city could do, and just as a final comment that I wanted to make, was encourage people who live in homes and in multifamily buildings to check their faucets, their toilets, their showers, their pipes for leaks. It's incredible the amount of times when they go in there and they do those tests for leaks, the amount of issues that they find, and then afterwards, these owners in these buildings realize the savings once they address that. So if there's a savings in your bill, it also means you're also conserving water. And it's something that perhaps the city could do a better job at, is encouraging people to look out for those leaks.
Yeah, Alex, the issue with that, Alex, also is that for one homeowner, it's not a material thing, but if, you own 700 units, yeah, it's a big deal.
If I may chime in here a second, the other initiative that the city is doing, we're implementing advanced metering infrastructure citywide. In fact, we're in the IDA, the pilot phase, just to make sure that everything goes smoothly, but the formal rollout would begin in December or January. It would be about a year-long project, but once that happens, it would be similar to your FPL bill, where you have a dashboard, you can go online. There would be smart meters in the ground, so we don't have to spend operational resources looking at the meter and the water usage by walking the city. But more than that, it would help with conservation efforts, because the smart meter would be able to detect a low flow that's consistent, and it would alert the owner saying, hey, you have a possible leak.
By the way, I bet it's worse with irrigation issues.
Oh, my goodness.
You think about
yeah.
when heads of sprinklers go out, you oftentimes don't see it.
But that system has been great in other municipalities. The smart water meters, the wireless smart water meters, they've been great in other municipalities. I'm glad that we're doing that here.
They have in others?
I think Miami Springs was a municipality that tested it, and there's others.
Yep, we use them.
Yeah,
it's great. It's a great idea. I can't imagine it's outrageously. Is it really expensive, or is it?
Well, Miami Springs was actually a pilot, because Miami Springs is a part of Miami-Dade Water and Sewer system. It was a pilot that Miami-Dade Water and Sewer did. I don't know what their opinion on the success of that pilot was. What I would say, if I'm not mistaken, it was a fixed network. It was either Itron or Census, and that's a fixed network system. Think of a tower with radio communications. What we're putting in the ground is cellular meters that we purchased at a contract rate, so we're guaranteed the same service rate for the lifespan of the meter for 20 years, and we're very happy with the results thus far in our test phase.
Is it part of it for you? It's easier to gather information, like you don't have to send people out to read and stuff.
That's correct.
Part of the process
yes. So
too?
Operationally, there's some major efficiencies that are realized depending on what infrastructure you put in, because you could even put in smart valves. You could put acoustic leak detection for the distribution system, not only for the customer side system, but the big deal with the meter is you don't have to have meter readers going out and lifting up a meter box and reading the meter. You just collect the data.
Right. And I imagine you can also spot leaks earlier too, as real time, as opposed to getting a water bill 40 days later.
Right, exactly. And that's exactly right. So one of the things that would happen here, we currently bill you in arrears. So this meter would bill you on time. So there's actually going to be a bill that would be doubled up, right? Because when you get the new meter, you have to pay the one that you never paid, and then now you're getting billed on time moving forward. But this is all going to be notified properly to the residents, of course.
It's such a no-brainer. And imagine systems like that end up paying for themselves ultimately.
Yeah, and it provides a tremendous benefit from a customer service perspective as well.
Right.
We forgot to open the public hearing. We do have one hand raised.
Oh, I'm sorry.
Yep. So Mitch Novick.
Good afternoon, Mr. Chair or interim chair and members of the planning board. Many think that my pet peeve is Ocean Drive, but it's actually the 13 utility billing rate increases we've had in the past 8 years. I appreciate this conversation. I'm not looking forward to the new meters and getting double billed. And just for reference sake, I've lived in this city for 33 years, and I've seen not quite a dozen presentations of a public works official come up showing us tuberculated pipes with crud and lime that may have a very little percentage rate of flow. By this time, our underground utilities should be gold-plated, and I would just urge everybody to keep their eyes on how this city manages its water rates. Thank you for this time.
Thank you, Mr. Novak. I think we could. Anyone want to move this thing along? Or
I think we have a water expert on the board.
Who won't swim in the bay right now because he's so worried about the pollution.
Who won't swim in the bay ever. Yeah,
Because of pollution. I mean, she's worried about she'll swim in the ocean, which is
I
not
tell
a great
everyone
thing.
I live on the open sewer line.
No.
My husband hates when I say that.
Live on Parkview Island, and I used to be able to jump in from my deck, and now I paddle it with great trepidation. And the second I get out of the paddleboard, off of the paddleboard or out of the kayak, you take a scalding hot shower because it's the open sewer line.
I have noticed you've
Lovely.
been glowing a little more green, Tanya, lately.
What's that? What'd you say?
You've been glowing a little more green lately.
Yes,
I've kinda noticed.
I find hence why I'm wearing
From the
hot pink,
paddleboarding.
because the lime green and the hot pink really work well together.
Fluorescent.
I will move it with one last statement that I'm even in my house, and I've said it a few times on this board, where the city water hooks up into my house during big rain events, blows right back into my garage too, which means I know that there's some, on Normandy we pump a lot of water to the golf course, and I'm sure somewhere there's a blockage, and when we're pumping that water in, it's like blowing into my garage, and I can get like 2-3 feet of water blowing in. So, I know there's a lot of issues underground that hopefully we can start to put
You're not practicing paddleboarding.
more eyes on.
Practicing your paddleboarding in your garage.
In the garage. I've got a wet vac, and I know how to use it. So I'll move this.
I'll second.
Okay, motion by Ms. DiPietro, second by Ms. Bott. Roll call, Ms. Bott?
Yep.
Ms. DiPietro?
Yes.
Mr. Fernandez?
Yes.
Mr. Jalpi?
Yes.
Mr. Milan?
Yes.
Motion passes.
Thanks so much. This is educational. Appreciate it. Yeah, thank you. Okay, we're done with everything except we have some discussion items here. And I guess I have some time right now if you guys want to go forward with these. If anyone has one that specifically want to go out of order on this, or we just go down the line on this. Anyone have something they want to discuss? Sorry?
Do we want to do the fulfillment centers first, since that's a super hot topic?
I'm fine with that, because if this goes on too long, I'm going to have to leave at some point. So I'd prefer doing what the group would prefer to discuss first. And I'm okay with, so right now we're going to go discussion item regarding retail fulfillment centers.
So, so, Mr. Chairman, I placed this item on the agenda because a number of months ago, we had before us legislation having to do with retail fulfillment centers, and we discussed it. There were concerns that were expressed by the board. I think we passed an unfavorable recommendation to the City Commission. Then the item was withdrawn. At the time, I said it would be adventurous for us to have a follow-up discussion on this because policy should be discussed on do we want them? Do we not want them? If we do want them, where should they be? Should it be for limited products, or should it not be at all existing in Miami Beach? And so at that time, I had requested that discussion, but in the meantime, one of the establishments that was looking to use this category of retail fulfillment center has since been working on opening locations throughout our city, and it raised some concerns. And so I thought it would be good just to reopen that discussion to see kind of what direction or how we feel about this. I would be remiss not to mention also that Commissioner Minor also does have legislation on the agenda of the City Commission, or is working on legislation that I guess and attorney and staff guide me appropriately with that legislation eventually find its way to us before this body?
It will. I'm sorry. It will. The commission actually just referred an item that was sponsored by Commissioner Minor to the planning board. We're working on that draft with the sponsor, and that is scheduled to come before you at your meeting in October.
So I don't know, and I'll pass it along to you guys if we want to, have this discussion now, or if we want to wait for Commissioner Minor's pieces of legislation to make their way over to us. But that's the reason why I put this discussion on the agenda.
Is this still for GoPuff, even Minor's legislation?
It's based on that business model, yes.
Yeah. So do we want to not discuss it, just want to sort of react to what is conjured up there, and then we can banter about, at a later date when we have something more tangible in front of us?
That would be my recommendation. You're going to have a draft definition before you and draft regulations. So that would be my recommendation.
At the time when I put this on I requested this discussion, there was no such legislation drafted at the time, and so that's why I think at this point, out of respect and deference to the City Commission, I'd wait for them to send it over to us.
Okay.
I would just add that I think there's an unintended consequence when something comes before the planning board and we have a conversation about it and get as much information as we can about it as a body and recommend it to, pass along a recommendation not supporting it to the commission and fully expecting the commission to have a full open public discourse about it so that the community can learn about it and people can proceed accordingly, and then it magically gets withdrawn, never to see the light of day again until they're, painting the walls, a few weeks before opening. I don't know what the solution is. I understand that it is technically correct the way it happened. Nothing untoward happened. But it's something I think that, and I don't know how this gets done, but that needs to be addressed, because that sort of, the process is correct, where it goes to the planning board, then it gets discussed at commission, and then, people weigh in on it, and then it gets voted on, and that process was preempted. And I don't want that preemption, that process preemption, which airs it out as a community discussion, to happen again about anything. I mean, in this case, it's just retail. It's not a make or break. But what if it were something much more significant or much more impactful to more people? And so I don't know what that answer is.
I don't think that we could say, you're forced to discuss issues. I mean, understand, we're just making recommendations, favorable, up or down, right?
No, I understand that, but then for the commissioner sponsoring it to just withdraw it, and it then just goes through as an as of right item without any further notice to the public or conversation about it or impact discussion or anything.
So I don't know the specifics we were talking about, but that, if they had as is rights, I guess, why'd they come to us, why'd the legislation come to us in the first place?
That's a good question. I don't have an answer for it, but it did. And it was, a commission discussion item or a commission item to be voted on, and that got pulled. So I just think that process needs to be not something that can be got around.
Although we're a board, we're not commissioners, right? So I guess, the commissioners make the ultimate decisions.
Of course, but they didn't, because they never had the chance to discuss this item. That's my point, is that it was withdrawn before there was any discussion. But that's my point.
Right, but I imagine there's some sort of legalities that happen there. I don't, it doesn't. I would hope someone analyzed it, reviewed it, decided that it was appropriate or not appropriate, despite or with or without legislation.
I think
because we were in that situation. Was it legislation in there? It was legislation we were dealing with. Yeah, it wasn't like an application. It was legislation. So maybe it's shoehorned into some other existing legislation.
Why it came to the planning board if it was.
Remember, the City Commission is the legislative body of the city. So this board, you sit in a quasi-judicial capacity on individual applications, but on legislation you are advisory. And with the Retail Fulfillment Center ordinance, following the planning board's discussion, the sponsor withdrew the item, which is his prerogative.
But then, so why did it come here in the first place?
Because the City Commission referred the ordinance to the planning board.
But Tanya, you're saying that the place happened, or the retail store happened already, that it was approved and somehow it exists?
It's opening on Alton Road.
But maybe the business model they're deploying here just fits our current ordinances. I think the way we were discussing it wasn't going to be a good PR for that company. So I think we also put them we backed them into a corner a little bit. Because they just got a big investment. They're a huge startup. So, and when I think about the conversations we were having, if I were that company, I would be backing away pretty quickly too.
But they ended up opening.
They have not yet opened, but they're going to.
They will end up opening. So,
but I don't know if their full business model will be.
Tanya, you're
will be
research how the hell
here.
that happened, right?
So that's where I think that we're probably better positioned to.
I'm sorry?
No, that we're probably better positioned to have a better conversation about this.
Yeah, I think we should.
Legislation
should
before us.
I agree.
Yeah.
So then, anyone, 3 or 5? Let's go first. I'll let. Should we spin the wheel? 3 or 5?
Let's do Ocean Drive.
Okay, that's number 3. So it's discussion regarding Ocean Drive pedestrianization, and expansion areas.
I'll just say that the city currently has a consultant working on a master plan for the whole MXC area, and Ocean Drive is part of that consideration. So if you have any ideas, any thoughts, any recommendations, we can certainly provide them to the consultant.
Through the rumor mill, I heard that they're reopening Ocean Drive to traffic. Has that been decided on?
I don't think a decision has been made on that.
Okay.
And the consultant, what is the consultant working on?
The consultant is Siskovich, and their purview is looking at regulations for Ocean Drive, business regulations, business incentives, the actual infrastructure of the roadway, the layout of the roadway, everything and anything regarding the functioning of Ocean Drive, and Collins Avenue.
And what?
Collins Avenue, the whole mixed-use entertainment area.
Right. All right. I mean, I've had a number of conversations. I was on a conference call with Miami Beach Chamber of Commerce to kind of brainstorm ideas about Ocean Drive, and one of the ideas I had, I do think it would be great if we could incentivize an arts institution on Ocean Drive. The city has a very transient relationship with the art fairs. They happen in December, and then they all fly out of town. But, galleries, small museums have cafes. I feel they could be like a great kind of anchor tenant on Ocean Drive to help transform it from what it is. Also to bring people there for reasons other than partying, So I don't know, to what degree that's possible, but it seems like it could make sense.
Well, I think that's part of the proposed vision for the ADC, or for the proposed ADCD districts. And so the question is, how do we start? When do we start? What are you looking for from the community? Let's go. I think a lot of people are interested in seeing that.
Well, and I think you have the Betsy Hotel that's already there that has an art gallery in it.
Yeah.
And looking at, even if it stays within tourism and hotel uses, how even the branding of these hotels can be elevated and maybe fit a new Ocean Drive that's, has these things.
Ocean Drive reimagined?
Reimagined with art fairs.
I think one of the ideas of when we requested this discussion item was that if in this visioning process and in the process of this group that's been convened by the mayor and the work that Bernard Siskovich is doing, if any of that end work eventually has to come through the planning board and be approved by the planning board, for them to, along the way, give us some updates, because we don't want them to do, or at least I personally wouldn't want them to do all of this work, and then we end up with something that we have concerns about. And maybe if we, along the way, can share some of our thoughts and some of our feedback with them, so that way it's time well invested, and we don't surprise them at the very end with concerns or something we may have. And I think that was part of the idea when we presented the request for this discussion item.
I mean, can we ask for a presentation of where it stands now, what the thinking is now?
I can reach out to them. I don't know, they have a contract that has specific things that they have to do, but I'll reach out and see if that's possible for them to make a presentation to the planning board.
I mean, very low end things that come to mind right now with the street is on either ends, and even as the streets come down, like if they were roundabouts, it would keep the traffic flowing. Right now, you get the cars coming in and blocking, and then people can't get out, and the traffic doesn't flow well. Everyone kind of buckles everywhere instead of having roundabouts. And then also, I think it's a great moment to have that street obviously be more permeable surfaces and a little bit more natural landscaping instead of just asphalt the whole way down. Almost kind of an extension of, not totally the boardwalk, but the new boardwalk we have. So it really turns into a restoration and recreation space.
Your mouth to God's ears, right?
Yeah, absolutely. I wonder, this might be a separate discussion item for a future planning board meeting, but I wonder if we have two MXEs in the city. We've got the Ocean Drive MXE going west a few blocks, and we have one up in North Beach at Ocean Terrace. And, my understanding is that the MXE was put in place to encourage rehabilitation, adaptive reuse, encourage investment, opening restaurants and hotels and boutiques and things like that. And it has done that, but it, I think, has also provided a license to spiral out of control. And I think the only reason we don't have those issues in North Beach is because there's nothing there yet. But I think it's coming because there's new development coming. And so I wonder if the MXC land use permissions, for lack of a better way of putting it, have outlived their purpose, and maybe they need to be rescinded and reimagined as something that is more appropriate to get us to where we want. I mean, if we already have the facilities built and we just want them to be used differently, then maybe the MXC language isn't the right language. And I'm not an expert, so I could be really wrong on this, but I think I would love to hear from you guys.
Funny, there's no conversation about expanding it, is it?
No, it's about rescinding it.
Shrinking it, right.
No, like getting rid of it completely, and then saying, okay, so that worked to a certain point, and now it's no longer serving us well. And so what could be put in its place that would serve us well, that would encourage and incentivize the galleries and the art spaces and the porous pavements and the open spaces and whatever else that we want to encourage, rather than have it be a free-for-all, which it is in South Beach and will likely become in North Beach if it's not, looked at more carefully. So can we add that?
Sure. Yeah, I mean, that's something that we've been doing. I think it was earlier this year, the board transmitted with a favorable recommendation several amendments to the MXC district. It's MXC just means it's a zoning district. It has its own regulations, setbacks, heights, and uses. So we amended some of the uses and some of the requirements for the uses, and we prohibited standalone bars as part of that. We prohibited commercial use of rooftops with the exception of restaurants and things like that. So we've made changes to the MXC district, perhaps more are warranted. I know the consultant is looking at that issue as well to see what else can be done to modify what uses are allowed in the MXC district.
But the question remains, and this is maybe we can have sort of what it was intended for, what it accomplished, where it's gone off the rails, and what we're doing to bring it back onto the rails. And then, with all that information in front of us, and I would welcome public participation for people who are affected by it, business operators and hoteliers and all that sort of thing, and then say, okay, so is this the right tool to get us to what we want next? Because it got us to what was good, and then it got us to what was not so good.
Control. Right.
And so maybe it's not, tinkering with MXC. Maybe it's getting rid of the MXC and putting in something, completely different.
Yeah, it's easy to be Monday morning quarterback, right?
Oh, so easy.
So I sat on boards of schools, right? And I look back at decisions that were made 40 years before I was on the board, and I thought they were, not really smart decisions, but I wasn't sitting in that seat at that moment, and someone made a decision. It was a hard decision, probably, and really considered it, and so, it to a certain extent it worked, right?
No,
and I think I think to what you're saying is like perhaps we've outgrown it. We succeeded, mission accomplished, and now it's time to reimagine, what we're planners, right? What's going to happen forward.
Exactly, and it's not at all casting aspersions on what it has been and what it set out to create. I mean, I think it was visionary. So, but things changed a lot in 40 years, especially these 40 years, for heaven's sake. So, let's get rid of things that are well-intended but no longer serve us for the world we live in now, and put in place something that serves us now and will serve us well for the next 40 years.
Yeah.
And then the next set of planning board people in 4 decades can say, what were they thinking? Time to reimagine and rethink how we're doing business here.
Yeah.
One of the things that Tanya, you brought up, and Rogelio, that you brought up, were those MXC regulations that we approved earlier this year, and it included the CUP review of all indoor entertainment for the MXC, and as you mentioned, the commercial use of rooftops and standalone bars, and it would indeed be good to see what impact has that had. Has it had a positive impact? Because I think a lot of times we spend time discussing legislation and regulation, and it's oftentimes important, but equally important is to know, well, is it yielding the results that we hope it would have yielded? So somehow there's a way to get that information.
I mean, unfortunately, things like that take time to work through. It's, the businesses that are there are grandfathered in, so it's going to apply.
Yeah, you got people with rights too. It's just a little difficult and a lot of money invested.
Yeah,
people are not going to say it's okay,
work.
For us to change rules when they dealt with, made their investments under set
No,
rules.
and we want to be mindful of that.
Yeah.
No, we're not trying to put people out of business if they're good operators.
It's a difficult situation right now.
It is. It's very tricky. Yeah.
As planners, we work on
need good
regulations, and we
investments
want
in
to
our
see
city.
things change immediately.
Good investments in our
We
city.
adopt these rules, but it has to work its way through.
Through the system, yeah.
Yeah.
Absolutely.
Okay, maybe we'll just. So we're going to move on to the last discussion
Do we
item.
want to
Sorry.
keep this up? Well, so I'll reach out and I'll reschedule it, but I'll reach out to the consultant.
I
and see
think,
if we
listen, we're always going to be talking about this because also, the reality is there's going to be someone appearing in front of this, either a CUP or something, and it's going to be a recurring nightmare for this board for a long time still.
But I mean, you can't expect change if you're setting yourself up for a repeat of the same thing, if you're allowing the same thing to continue to happen. So if you want change, you have to put that plan into place. And so I think it's part
Chip
of
away.
Yeah, exactly. I think it's part of the discussion that needs to happen.
So and just for clarity, so Rogelio, you're going to reach out to them to see if maybe they could give us some sort of, very superficial, briefing on it.
I'd probably try to do things, any discussions that we want to have in November is a very light agenda. We have one private application, and right now no ordinance is scheduled for November, so that might be a good opportunity if you want to have any discussions to schedule them for the November meeting.
Yeah.
Well, I think the fulfillment center should travel with Commissioner Miners.
Oh, yeah, yes, I'm not referring to that one.
I agree with that, Tanya. Okay, then the last discussion item here is regarding hotel occupancy limits, cap on hotel rooms, and prohibiting hotels in certain neighborhoods. Continued
For this one, I know you had requested that we provide information. I've looked up a lot of it. I'm trying to get it open before me. I'm not able to do that right now. You had asked me the number of hotel rooms.
I have that actually.
Which is 21,172. I was trying to look up the number of short-term rentals, and I'm not able to get it open right now. So I don't have a lot of information to update you right now.
So my question is this. The City Commission is looking at legislation. After we've had this discussion, I know that the City Commission worked on some legislation, I think at their last meeting, having to do with occupancy limits.
Mm-hmm.
It's occupancy limits on short-term rentals. Was that what the City Commission was looking at?
I think that was the intent, to be able to limit that in short-term.
Okay. So my question is this. With this policy that the City Commission is looking at on short-term rentals and their occupancy limits, what enforcement mechanisms can the city consider for it? I know that certain jurisdictions have interlocal agreements or memorandums of understanding with the different platforms for short-term rentals. And so my question is, can the city, on a daily basis, audit these platforms, because it's all online, we can see it on our phones, on our computer, and see the listings, and see whether these listings are meeting our requirements, that they're advertising at the occupancy limit that is legislated by the city, or that if a BTR is required, that they're indeed providing that BTR, and that they're not putting a fake BTR, so that if they're not meeting these requirements of the city and the thresholds we've set in place, that perhaps the city could reach out to the platform and work on removing those listings that are complying with our regulations. So, I guess it's more of a legal question. To what extent do we have the ability to do that?
It's very difficult to enforce occupancy, because at the end of the day, the only way to know for sure is to see who's coming in and out, or to get inside the unit. And it's obviously it's just, as an operational matter, it's very challenging to enforce. Do you have anything to add, Rogelio, as far as code compliance? I don't really work with code compliance on this issue, but I know that enforcement of our short-term rental restrictions is a challenge.
And how about through the advertisements, when they're advertising more? Like, for example, someone had complained on social media about a location that was having a dozen people in a unit. In a fourplex building, in one of the units, they had about a dozen people. Lo and behold, I go into the platform, and absolutely, they were advertising that the occupancy for the unit was a dozen people, because they have that amount of beds. And what I discovered is that it's not completely uncommon to come across these listings. And so I'm wondering, when we are then legislating these occupancy limits, can we better enforce this through? Is there a way that we could better enforce it through the advertisements of what's being put on the platform?
You may want to ask if you want to continue this, if the board wants to continue this discussion once you're done, obviously. But sure, you may want to ask Code Compliance to appear at the next meeting, because they can really speak to their actual challenges doing these investigations. But I would say that if anyone, if any member of the public sees that a unit is being advertised in excess of any permitted occupancy, that all of that information should be provided, of course, to Code, so that Code can follow up on it.
But Alex, don't you think people are a little more sophisticated? Like, they'll say 4, but we'll look the other way. When you have 14, this is an enforcement problem. I can see how it's I'm here just to visit. I'm not with. I'm not staying here. I'm just visiting my buds.
Right. One of the things that has come up is that they actually are advertising it because they get more money, especially when they're on the platforms.
Well, so you're saying that they'll say up to 8 people that could stay at this place?
Or more. We've seen even more.
If that's a situation, we should slam them.
Well, I know somebody who...
Maybe Code, we need to have this conversation with Code, I'm sorry.
No, we totally do, because I know somebody who did a screenshot of the unit, the building next door to her, that consistently has, rowdy STR people showing up, and showed it to Code Compliance, and the response was, well, unless we see that many people in the building or in the unit, we can't do anything, which seems not very productive. But I just wanted to say, for the record, I had reached out to GMCVB about issues related to this, and what they said was, currently we have 20,450 hotel rooms in the city of Miami Beach, which is 33% of the Miami-Dade total. And within that number, that includes hostels, STRs, micro-units, it's all the same pot. So I don't know how many sort of uncounted STRs there might be, but I think anything that's on one of the platforms would be captured in that number of 20,450, and rising, I might add. There are tens of thousands being added in the next couple of years, which is problematic.
I just want to say that, like all of us as a board, we've all worked on this. I think collectively we've helped push forward legislation that we've supported that comes from the City Commission on this issue.
But if code could come so that maybe we can have a better idea on the enforcement and how maybe it could be improved. Maybe it's a matter of resources. Who knows? You know, just might be a good continuation.
This is such a difficult issue to enforce.
Yeah.
You know.
Well, you know the legal aspects of it.
Yeah.
But you know, the way that the water management system is evolving into these sort of smart water meters and will give us more information. There are geo-tracking software platforms that can cross-reference using people's phones, not the person itself, him or herself, but you know who's coming from where, what's going on, what are they doing here. I mean, you probably heard about it during the beginning of COVID outbreaks across the country because it was on the news a lot, but police departments around the country are using this, and we can cross-reference who's coming in, how many
next thing
people.
they're going to be tracking me, right? I mean, I don't know. It's a slippery slope.
No, but I mean, it's
Big Brother.
It's not tracking a particular person. It's just the flow of movement, and so I think once again we do things the way we're used to doing them because that's how we're used to doing them. But as the situation in which we find ourselves, the world evolves, and so we need to start rethinking how we do things because there might be better resources, better tools available to us.
It's thinking outside the box.
To get stuff
agree,
done.
but I'm not sure I'm willing to give up civil liberties to make
No,
sure
of
that 8 dudes aren't staying in a hotel room. You know?
This isn't giving up civil liberties. It's not tracking individual anything. It's just little points on a map. I mean, we all carry our cell phones, so we're all being tracked as it is, right? Like that's not changing.
But I think Nick's suggestion of having code come and it could be very productive to have their.
I'll reach
So
out to them.
can I ask you guys something? So like Found Blue, right? Found Blue says they have 4 people could stay in this room, right? Who monitors that? Does anybody monitor that, or are they in danger of losing a license if somehow someone says that many more people are staying there? Because is it possible doing it through licensing and that way as opposed to? I mean, I guess it's always enforcement, but there's got to be some self-enforcement, perhaps. And I don't know what you do to encourage self-enforcement.
It's mostly self-enforcement. I think 4 to 5 years ago, the City Commission amended the LDRs to create occupancy restrictions on new hotel development. We're preempted by the state from adopting business regulations on public lodging establishments, which includes hotels. So the approach we took, I think it was 4 years ago when we adopted that ordinance, was that we could impose occupancy limits as a condition of development. So we do it prospectively in the LDRs, and any hotel that's been permitted since 2017 has those occupancy limits. Anyone before then does not. So typically, a property will limit or police occupancy on its own based on whatever their internal policies are. And usually it's when and I worked front desk in college, disclaimer, for two summers here on the beach actually, and usually it was when you saw too many people coming in and out.
Yeah, and that's where also making sure that when we continue this discussion, talking about what are the regulations on having a front desk and staff on site or not, and the other aspect of it is how do we promote the adaptive reuse of the older collection of hotel buildings that just can't compete anymore with the market of newer, beautiful, modern hotel buildings. How do we, promote that adaptive reuse of those buildings?
That's why I thought the Bancroft was such an amazing project. There it is. That's, to me, God willing, that place kills it, succeeds, because when something does well, people copy,
And as a point of personal privilege, there were you guys may recall that the conditional use permit for the Bancroft, we added language that Rory Greenberg and his team agreed to, having to do with the autocycles, with the what are they called? Slingshots. With the slingshots.
Yeah.
They were having slingshots in the garage.
Having
and
what?
Those slingshots in the garage, and now they're gone. And I think it's something that you all may want to know, because we all were part of that decision-making process of adding that to the conditional use permit.
Oh, you mean those are the vehicles?
The vehicles,
Yeah,
yeah.
not like.
Not the other.
I know. Yeah, I thought you were like
Those require parking spots in your back pocket.
I thought I got hit
not
by
in
a
the
rock
garage.
walking by in Ocean Drive.
I just wanted to share that with all of you because I was very excited when I heard that the slingshots were out of there.
Yeah.
Yeah, that's awesome.
Yeah.
It's a little tangential, but as Wynwood has gone from truly being a bunch of galleries to kind of looking like a mall and being bars, we might want to look into tax incentives that allow some of these galleries to come to the beach, to the older Art Deco hotels for adaptive reuse, because I think that artist market has been pushed out and they're getting pushed into Little River, but maybe we want to welcome to the beach.
That's a great idea.
Absolutely.
I love it. But I guess the question is it too expensive? It's going to come down to economics, right?
Yeah.
I mean, we could provide enough, tax incentives, all that, but someone's got to pay rent.
That's true.
But it's an idea worth exploring. I mean, who knows what's possible?
Yeah, the market's cruel. We could
Market
be nice,
is-
but the market is cruel.
Yeah, but the market is also cyclical. I mean, so who knows what's possible?
True.
I think it's also how we position ourselves. I think a lot of people just think, oh, Ocean Drive, locals don't go there, it's a party, whatever. So it's also how we kind of manipulate and wrap
But
up
locals used to go
our
there.
real estate.
Right, but locals used to go there.
At one,
Yeah.
I mean,
at one point,
I remember when it started happening, I'm probably one of the older people here, but I was, when it was really starting to
accumulated
happen.
youth, Mark.
It was exciting. It was
Yeah,
really, really exciting,
And locals want to be able to go
Right.
there and want to have a reason to go there and not be,
Exactly.
kept out of,
But I
one
can't
of the
remember
best
the last
parts
time
of
I
the
was
city.
there. I can't remember.
I think you have a lot of New Yorkers who I always hear, now that New Yorkers are coming here, they used to always say, oh, Miami doesn't have the culture, it doesn't have the shows, it doesn't have the art. So we can start bringing that to them. It even kind of serves that population that for COVID and or tax reasons has decided that they do want to move here.
Yeah.
At one point in the 80s, it was giving the incentive of having the restaurant on the ground floor to help incentivize, the fixing up of the hotels upstairs. Today it's time to have that new conversation to see what it is. What is the next, cafe use that will help and, fix up the rest of the building. Today's probably not cafe use, probably is something else. What is it? And so I think that that's a very good point that you all had. That is a discussion of economics that we need to probably be having at this table. Mr. Chairman, great meeting.
Yeah, I think we've beaten that dog. And I just want to say something, though. I'm Kareem. I hope that your family's doing well. His mother's having a heart surgery today, this morning. That's why he's not here. We miss you, and I am praying that it all works out really well for you.
Yes.
With that,
Agreed.
is there someone move to adjourn the meeting? And I note that 3:30, not bad.
Good
10
job.
to 3:30. I'm
Good
gonna have
job.
to talk to Kareem about this.
You got us out of here on time.
Yeah.
Motion to adjourn.
All right.
Second? Anyone second?
Second.
Am I allowed second as a chair now? I'm not allowed seconding.
I think
You
the
are.
chairperson can second. You can't
Okay,
make
I'm
the
gonna
motion,
second,
but I think
darn
you
it.
can second. Motion approved by acclamation.
Yes, by acclamation.